Not two matters, 230 Lord. Election matter, 230. 230.
Kodi.
One submission. Article of charges issued after retirement. Madam.
After retirement, pending matter. We'll see. ಮೂರು ದಿನ ಸ್ವಾಮಿ ಒಂದ್ ನಿಮಿಷ. ಎಲೆಕ್ಷನ್ ಮತ್ತೆ MPMLA ಕೊಡಿ
ಒಂದ್ ಸಬ್
ಸಸ್ಪೆನ್ಷನ್ ನಾಳೆ ಬರ್ಲಿ ಬಿಡಿ. 2:30 ಏನು ಆಗೋಗಿದ್ಯಾ ಆರ್ಡರ್? ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಎನ್ಕ್ವೈರಿನೇ, ಸುಮ್ನೆ ಮಾಡಲ್ಲ. ಏನ್ ಪೆಂಡಿಂಗ್ ಎನ್ಕ್ವೈರಿ? ಎಸ್ ಕೊಡಿ, ನಾಳೆ ಬರುತ್ತೆ ಕೊಡಿ.
Let's one matter at 2:30.
ನಾಳೆದೆಲ್ಲ ಕೊಡಿ.
ಒಂದ್ ಸಬ್ಮಿಷನ್ ರಾಶಿ. ಇದು ಬೆಂಗಳೂರು ಬೆಂಚ್ ಇದು ಬೇಲೂರು ಕೇಸ್ ನಲ್ಲಿ 5 ಕೇಸ್ ಕನ್ನಡ ಕೇಸ್. ಒಂದು ಕೇಸಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಾರೆ, ಇನ್ನು ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಗ್ತಿಲ್ಲ. ನಾಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ಬೆಂಗಳೂರು ಕೇಸ್ ಇಲ್ಲ ಯಾಕೆ ಬಂತು?
ಇದು ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ಲಿ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ ಟು ಡಿಸ್ಪೋಸ್ ದ ಕೇಸ್ ಇಮಿಡಿಯೇಟ್ಲಿ.
ಅದಕ್ಕೆ
ಫೈಲ್ ಎಲ್ಲ ಇಲ್ಲೇ ಬಂದಿದೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಕಮ್ ಬಿಫೋರ್ ಮೀ?
ಅಲ್ಲ, ಇದು
GMCPC ನ
ಅಲ್ಲ, ಇದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್
ಇದು
2:30 ಹೆಂಗಾಗುತ್ತೆ? ಪೆಂಡಿಂಗ್ ಮಾಡಿ 2:30 ಹೆಂಗಾಗುತ್ತೆ?
ಫೈಲ್ ಬಂದಿದೆ, ಇಲ್ಲ ಅಲ್ಲಿ ಬಂದಿದೆ. ನಾಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಅದರಲ್ಲಿ ಒಂದ್ ಕೇಸಲ್ಲಿ
2:30.
Let's one matter at 2:30. Surface matter mulats. It's a school.
Lordship, this is a pending election matters which was posted yesterday. Your Lordship is pleased to post it on coming Thursday, that is tomorrow. Elections are on 19, but the order sheet shows that the matter is posted on 27th. May I request it on tomorrow, Your Lordship?
My Lord, this is surface matter, Your Honor. The auction purchaser has paid 100% of the auction amount.
Your auction purchaser?
That pressure is that. Pardon me?
Are you the auction purchaser?
No, I am for the bank, Your Honor. He is putting huge pressure on the advocate and bank, everything, Your Honor. Otherwise, give me back with interest like that.
ಈಗ ಏನಾಗಿದೆ?
Kindly final order ಮಾಡಿ dispose ಮಾಡಬಹುದು ಸ್ವಾಮಿ. ಅವರು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಕಟ್ಟಿಲ್ಲ, ಸ್ಟೇನು ಇಲ್ಲ ಅಲ್ಲಿ.
ನಾಳೆ ಕೊಡಿ.
Please, Your Honor.
So, Lordship, petitioner working as a guest lecturers, the urgency to it.
ನಾಳೆ ಆಗ್ಬೋದಲ್ಲ?
2:30 urgency.
ನಾಳೆ ಮಾಡಿ, ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ನಾಳೆ ಹಾಕಿ.
Lordships, one criminal petition pertaining to Bangalore bench, Lordships. Previous Friday is fine. Grateful, my lords.
I'm a bona fide purchaser. Sorry, my lords. I'm a bona fide purchaser of a property, and without giving me an opportunity of being heard, the commissioner has passed the seizure order on my property.
Which commissioner?
Deputy commissioner, sir.
Why?
For the debts committed by the seller, I'm a bona fide purchaser. The previous.
ಯಾಕೆ ಹೇಳಿ? ಆಯ್ತು, ನಾಳೆ
The acts are being
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
fresh matters.
ನಾಳೆ.
Yes.
My lords, one matter at 2:30, my lords.
ಯಾಕೆ?
My lords, petitioner is a successful bidder in a tender notification, my lord. He has deposited entire amount, but in respect of those properties, there is encumbrance at column number 11. NOC has not been issued.
ನಾಳೆ ಆಗ್ಬೋದಲ್ಲ?
No, it's urgent, my lords.
ಯಾಕೆ ಹೋಗಿ urgent?
Because tender authority is releasing the deposited amount. 2:30.
Two matters tomorrow, the police act.
ನಾಳೆ.
Land acquisition matter, B group.
Two service matter.
Lordship, one part of matter at Bangalore. Tomorrow. Kindly take this matter on. Part of matter at Bangalore. Kindly take this matter on 23rd, my lord.
Why?
Venkatesh Dalwai moved this matter. He's on VC.
23rd ಇಲ್ಲಿ ಇರಲ್ಲ. I doubt. ಕೊಡೋದು ಕೊಡಿ.
Please, much up.
ಎಸ್ ಸ್ವಾಮಿ ಹೇಳಿ.
May I make one submission, please, my lord? There are two petitions, please, my lord, regarding the Pontiff's case, please, my lord. There was an interim order passed by this honorable court. Matter is part heard. Now that is pending for consideration before this honorable court. Kindly have it on 17th, please, my lord. 17th.
ಅದು ಫೈಲ್ ಬಂದಿದೆ.
Now my colleague Baswaraj Patil is there. He is submitting the memo, please, my lord.
Already submitted. Don't worry. Yes.
Obliged. Grateful, my lord. Grateful.
My lords, one matter for tomorrow, my lords. The BTDA.
Give it, sir.
Please, sir.
ನಾಳೆಗಾದ್ರೆ 2:30 ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ.
Your Lordship,
One matter for vacating stay, your lordship. Contempt has been initiated, your lordship.
Correct. ಯಾವಾಗ
ನೆನ್ನೆ
move ಮಾಡಿದ್ರಲ್ಲ, ಬಂದಿಲ್ಲ ಇವತ್ತು?
This is another matter, your lordship.
ಎಲ್ಲದರಲ್ಲೂ contempt ಆ?
ಅಲ್ಲ, yesterday's matter is
ಅಂದ್ರೆ
also not been
no
posted.
habit of complying with the order.
ಎರಡಿದೆ, so please.
ಆಯ್ತು, ಕೊಡಿ. ನಾಳೆ.
Yesterday I moved one matter ಮಾಡಿ education institution ಬಂದಿಲ್ಲ ಅದು ಇವತ್ತು.
ನಾಳೆ ಆಗ್ಬೋದಾ?
End of the list.
ಆಯ್ತು.
ಅಲ್ಲ ನಾಳೆ ಬಂದ್ರು ನಡೀತದೆ ಅಂತ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಬಟ್ ನೋಡಿ ಅದು ಯಾಕೆ?
Lord, serial number 157. My lord, it's the fresh matter, my lord, because one impleading application is filed even before the matter is posted. It is posted in hearing on I, my lord. I may be permitted to mention after a fresh matter.
Before raising, I will take it and don't worry.
But I'm seeking for contesting, my lord.
ಆಯ್ತು, 2:30 ಗೆ ಹೇಳಿ.
2:30 ಗೆ
2:30.
Serial number 156 was same.
ಆಯ್ತು, ನೆನ್ನೆ 2:30 ಗೆ ಯಾವ್ಯಾವ್ದು ಹೇಳ್ಬೇಕು? All these election matters which are urgent and have been pushed down either interlocutory or B group. You mention at 2:30, I'll take that.
Two matters for 2:30 minutes.
Okay.
One is election matters. Election is on 19th. The person who is disqualified.
19th ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಅದು.
Please. And one more, challenging compromise decree before the Lok Adalat.
ಅದು ಏನು urgency?
Tomorrow Revenue Authority is going to prepare Lavani sketch.
11
My scoot is
ಆಗೋಗುತ್ತಾ ಇಲ್ಲ?
ಅಂದ್ರೆ ಮಾಡ್ರೆ position disturb ಮಾಡ್ತಾರೆ.
ನಾಳೆ ಕೊಡಿ ಅದು.
Please.
2:30, all right.
Please.
That may be posted, my lord.
ಒಂದು election ಮಾತ್ರ 2:30 ಗೆ, ಇನ್ನೊಂದು ನಾಳೆಗೆ.
Please.
My lord, permit me to seek an adjournment in serial number 135.
Well, we'll grant, don't worry, madam. Yes.
It's
ಈಗ ಒಂದು ತಗೊಂಡ್ರ ಮೇಲೆ ಎಲ್ಲ adjournment ಕೇಳು. Yes. Call the case.
Serial number 1 fresh matters. AD Ramanand.
Both 1 and 2 same.
Please, my lords, by virtue of interim order granted by Supreme Court, my lords, they are rendering the services.
Correct. ಅದಕ್ಕೆ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಅಲೋ ಮಾಡೋಣ.
Since 9 months, they have not.
ಹೌದು ಸರ್.
Not getting salary ಅನ್ನೋದು ಒಂದೇ.
ಅಲ್ಲ, interim order main prayer ಒಂದೇ ತಾನೆ? ಹೌದು. ಸೊ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು ತಾನೆ?
Please.
ನೀವು ಗ್ರೀವೆನ್ಸ್ ಹೇಳಲೇಬೇಕಾಗಿಲ್ಲ. ವಿಲ್ ಫಿಕ್ಸ್ ಅ ಡೇಟ್. ಯಾರು ಸ್ಟೇಟ್ ಕೊಡ್ಬೇಕಾ ಯಾರು?
Please, my lords.
Learned HCGP 1, 2.
1 and 2, your lordship.
1 and 2.
Please.
3 and 4 hand summons. 5 and 6 MB Kanvi. Petitioner to serve set of papers upon the aforesaid council forthwith. List the matter on 28th. Salary ಅಷ್ಟಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಓಕೆ ಮೇಡಮ್, ಇಲ್ಲ ಅಂದ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ಆನ್ ಸ್ಯಾಲ್ರಿ. ಸ್ಯಾಲ್ರಿ ಕೊಡದೆ ಕೆಲಸ ಮಾಡಿಸ್ತಿರಲ್ಲ. ಎಸ್
My lords, in the connected matters, my lords, where I got interim order to
number
serve, ಅದೇ ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತೇನೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್.
ಆಯ್ತು, ಅವ್ರಿಗೆ ಮಾಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ನಂಬರ್ಸ್ ಕೊಡಿ, ಅದ್ರ ಟ್ಯಾಗ್ ಮಾಡಿಸ್ತೇನೆ.
Please, my lords.
ಕೊಡಿ, ಎಲ್ಲಿದೆ
I'll give.
ನಂಬರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ, ಎಲ್ಲ ಟ್ಯಾಗ್ ಮಾಡಿ 28th ಹಾಕಿ. 28th in preliminary hearing.
Please, my lords.
Yes.
Bill number 2 is same.
2 same.
Please.
1 and 2 same.
GI Rachinmat.
Recreation. Page number.
Your lordship, the petitioner is an.
Page number ಏನು?
Similar order.
Page 24. AC ತಾನೆ? Page 24 covered. Prayer quote ಮಾಡಿ. Yes, ಗೊತ್ತಿಲ್ಲ.
For all respondents accept. For all respondents I accept.
All respondents for separate order sheet ಅಲ್ಲಿ ಕಲ್ಸೂರ್ ಮಠ ಅಂತ ಹಾಕ್ಬಿಟ್ಟ ಆಮೇಲೆ.
Serial number 4 KL Patil.
Lords, this is a tender matter, my lords. Quoting for A schedule and B.
Emergent notice to the respondent, petitioner to serve set of papers upon, notice the respondent, petitioner is also at liberty to serve on the panel counsel representing the respondent. List the matter on 28th in preliminary hearing. Status quo quae, the tender maintained till the next date of hearing.
Obliged.
Yes, next.
Serial number 5 Arunachal P. Hegde.
Please, a short one, madam. We could not get the file, madam. During the course of the day, we will comply the office objections, madam.
That's okay, matter really.
Lord, this petitioner was given with the delegation by respond number 6 society to contest the election for respond number 5 bank.
Again, quorum irliಲ್ಲ ಅಂತನಾ?
Allah, chairperson has not signed the resolution because he also contested for delegation. He did not get the delegation.
The learned AGA is directed to accept notice for the respondent. But office objection ಏನು ಹೆಗ್ಡೆ ಅವರೇ?
File ಸಿಕ್ಕಿಲ್ಲ ನಿಂದೆ, ನಾವು during the compliance of the
43 1 to 15 ತುಂಬಾ ಜಾಸ್ತಿ
ಅಲ್ಲ ಮಾಡ್ತೇವೆ during the course of the day ಮಾಡ್ತೇವೆ.
ಸುಮ್ಮನೆ ಹಿಂಗ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರೆ ಏನು ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
Covered similar matter.
ಆಯ್ತು, ಕವರ್ಡ್ ಸರಿ. So and so learned AG is directed to accept notice for the respondents. The learned counsel for the petitioner submits the issue in the list and answered by judgment rendered to the coordinate bench in WP 107. Berkeley AC. So and so. Interim order.
Please.
There shall be an interim order as prayed for. The same shall be released only after compliance with the office objection.
Please. Please.
6 Srikanti Patil.
Regularization of service, my lord.
Correct.
And, my lord, he joined the service, my lord.
Notice
on-
ಮಾಡಿ interim order ಕೊಡಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, please.
Yes. Learned age HCGP is directed to accept notice for response 1, 2 and 3. 4 ಯಾರು?
Lord, Rabkavi Banati Town Planning Authority.
ಆಯ್ತು, ಯಾರು ಕೌನ್ಸಿಲ್ ಇದಾರಾ?
Standing council, I'm not sure.
Emergent notice returnable by, list the matter on 11th November, 11th ಅಲ್ಲ, 13th November.
Please.
Number 7, Pranav.
This case, my lord, I undertake to appear for respond number 6 society.
ಏನು ಆಮೇಲೆ?
I would file my detailed, this one. The
Detailed objections.
Election is on 26th, my lord.
ಹಾ.
So I need tomorrow or day
Lord,
after
sir.
at least, because it's.
Kindly see the page number 128, your lordships. They have removed the petitioners, your lordships, on the sole ground that the plots which they have purchased are from the earlier office bearers of the year 2007, your lordships.
No, the earlier office bearers were the father and husband of these very petitioners.
File your objections. Elections ಯಾವತ್ತು?
26th, your lordships. And
Interesting, ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಈಗ?
19th is the, your lordships, the nomination, last day of nomination, your lordships.
Day after
To
tomorrow.
contest and to vote.
Yes,
your
day
lordships.
after tomorrow.
Yes.
In preliminary hearing.
Yes.
Yes.
Copy
In
me.
fresh matters.
Yes.
Copy ಇಲ್ವಾ?
Copy, sir.
ಅವನ್ ಕೆಲಸ ಮಾಡಿ. Learned counsel,
Prashant.
learned counsel Prashant Gowder accepts notice for
Respond number 6, madam.
respond number 6, 1 AG ಯಾವ್ದಕ್ಕೆ?
Your lordships, 1 to 4.
1, 2, 4 and 5.
1, 2, 4
4
and
and 5. ಆಮೇಲೆ ಇನ್ಯಾರು?
I issued notice to the returning officer, respond number 5.
Returning officer.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಗವರ್ಮೆಂಟ್ ತಗೊಂತಾರೆ.
Please.
5 also, 1, 2, 4 and 5 ಆಯ್ತಲ್ಲ ಮೇಡಮ್. List on Friday in preliminary hearing.
9th is also same.
9 is same, yes.
Yes.
7 and 9 both.
Please.
Your lordships, on 18th there is a last date, your lordships, for nomination.
I think 17th is before 18th.
Yes, your lordships. No.
Number 8, Indiaji.
But for petition in the matter. But as per annexure E, page number 20.
Police protection. Yes, sir. If there is threat in real time, you grant. The petitioner is before this court seeking the following prayer. We'll dispose it off, please. The petitioner is said to have submitted an application before the competent authority seeking regularization of unauthorized cultivation to an extent of 15 acres in survey number 60 of Kodalgiri village, Alnavar Taluk. The Tahsildar order yavadu? The petitioner had approached this court in writ petition 105797 of 2025, which comes to be disposed directing the third respondent to consider the case of the petitioner and pass necessary orders in accordance with law. In the interregnum, it transpires that there was some untoward incidents happened in the subject land, and the petitioner had registered a complaint before the superintendent of police, Dharwad, and also submits a requisition for grant of police protection to protect the property and its usage from the hands of certain persons. An endorsement comes to be issued by the respondent police declining to grant such police protection. It is therefore the petitioner is before this court in the subject petition. The learned counsel for the petitioner submits that the endorsement dated 7/10/2025, which rejects the grant of police protection, is contrary to law, as the life and limb of the petitioners and the property is in jeopardy. The learned AGA would, however, contend that if the threat perception of the petitioner to his life or limb is in real time, the jurisdictional police would undoubtedly grant such police protection to protect either the property or the life of the petitioners. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the respondent respondent number 4 to accord such police protection on the analysis of threat in real time and not imaginary if projected by the petitioner, ordered accordingly.
Please, but I accept notice for all.
ಅವ್ರಿಗೆ separate order sheet ಕಳ್ಸೋದು ಮಟ್ಟಿಲ್ಲ.
Number 10, Prashant Matpati.
ಆಯ್ತಲ್ಲ ಅದು? Oh, 9, sorry.
Right to my lord.
My lords, I appear for respondent number 6. I'm the standing counsel, my lords. Election is on 26th, my lords. May I request that this be had on Monday, my lords?
Lord, I am seeking for a contest, my lords. 18th is the last date for last nomination, my lord.
Friday,
Please,
just on Friday.
Please.
I mean, direct take notice 1, 2, 4 and 5.
1, 2, 4 and 5 AGA.
Sanjana Mudhol for respondent number 6.
Sanjana Mudhol for respondent number
6.
Respondent number
3 is
6.
Baramgad room.
See, ಇನ್ಯಾವುದು?
Baramgad 3, election of
3 or ಬರ್ಕೊಳ್ಳಿ ಯಾರಂತ. Registry to print the name of so and so is appearing for the respondents. List on Friday in preliminary, in fresh matters.
Okay.
Yes.
Please.
Nitin Ramesh.
Same order. ಮೊನ್ನೆ ಸ್ಟೇ ಮಾಡಿದೆಯಲ್ಲ. ನಂಬರ್ ಕೊಡಿ.
ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗುತ್ತೆ ಸರ್.
ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗ್ಬೇಕಾ? ಏನಾಗ್ಬೇಕು?
ಇದರಲ್ಲಿ ಅನಾಲಿಸಿಸ್ ಫಸ್ಟ್ ಅಂಡ್ ಸೆಕೆಂಡ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಒಂದೇ ಅನಾಲಿಸಿಸ್ ಮಾಡಿ
ಮೈಕ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
ಒಂದೇ ಅನಾಲಿಸಿಸ್ ಮಾಡಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ, ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದೆ.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಮೇಲೆ ಅಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕಾಯ್ತು ಸರ್.
ಬೇಡವಾ?
ಬೇಕು ಸರ್.
ಅದನ್ನೇ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಬಟ್ ಇಂಟರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಇಲ್ಲ, ಇದು ಇಲ್ಲ ಸರ್.
ಮೊನ್ನೆ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. ಅದ್ಯಾವ ನಂಬರ್ ಕೊಡಿ, ಅದು
ಕಾಪಿ ಕೊಡಿ.
ಆ ಕಾಪಿನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಟ್ಯಾಗ್ ಸೇಮ್ ಆರ್ಡರ್
Please, for all respondents.
ಇಲ್ಲ ಇದೆ, ಅದನ್ನ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. ಎಸಿ
On behalf of AV Patel, may I seek time, my lord, on 29.
I appear for respondent, my lords. Earlier.
Some inconvenience for AV Patel. He's.
ಅದಲ್ಲಪ್ಪ, ಇವರು ಫಾರ್ಮರ್ ಜಡ್ಜ್. ನ್ಯೂ ಆರ್ಬಿಟ್ರೇಟರ್ should be appointed now.
No, my instruction is that matter is settled, my lords.
Settled.
How settled?
Learned counsel appearing for the respondent Vinay Kaujalgi on instructions would submit that the matter has been settled between the parties. In that light,
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀನಿ 29th.
ಅಲ್ಲ 29. ಇಲ್ಲ ಅಂದ್ರೆ list the matter on 29th. Please. Yes.
Number 13.
13 minutes subject to appear for the petition. Connected back minutes 5 and 6 are formal parties and filing in a memo.
Learned counsel for the petitioner files a memo seeking dispensation of issuance of notice to respondents 5 and 6 on the score that they are formal parties, and the memo is taken on record. Notice issuance of notice dispensed with at the risk of the petitioner. Kumar sir, ಇನ್ನೇನಿದೆ?
In the last occasion, the sum court has directed the government to secure the records so that the matter can be disposed of.
Your lordship, the matter pertains to your lordship, the striking down of condition, your lordship, 3A of job oriented courses, your lordship, that has been upheld by this honorable court, your lordship, and
ಅದನ್ನ dismiss ಮಾಡಿದ್ದೀನಿ.
please, your lordship, that is.
Next week ಅಲ್ಲಿ ಒಂದು date fix ಮಾಡಿ.
ಆಯ್ತು, ಫಿಕ್ಸ್ ಮಾಡಿ.
We can.
Next on 28th.
Please.
Number 14, Sanjana Kulkarni.
I appear for respond 5. Let's in this.
Yes, Sangram.
It is not here. Lords, I have challenged.
No, number 5.
No, my lords. The government appears, my lords. Notice has not yet been ordered, my lords.
Next matter.
Lords, it is a college, my lords, which has requested the regularization of subject in the year 1987, my lords.
Objection at serial number 20. Office objections overruled. Yes, next. ಏನ್ ಹೇಳಿ?
Lords, considering.
Regularization.
Please, my lords, we have.
Learned AGA is there, HCGP is directed to accept notice for respondent 1 and 2. Given 3, all the respondents.
Please.
List the matter on.
Petitioners may be directed to serve the copy.
Petitioner to serve a complete set of two sets of papers upon the count on the HCGP forthwith. List on 12th November.
Please.
Number 15, Mahanteshwar Patil, Dinesh Kulkarni.
ಇದರಲ್ಲಿ.
Respond number 5. Tender matter. Lord, even the deputy commissioner has filed affidavit.
Vacating interim order.
Their main ground is with regarding to non-completion of the tender process within 91 days.
ಅದೇ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಬರದ್ನಲ್ಲ, ಅದು ಇಟ್ಸ್ ನಾಟ್ ನೀವೇ ಅಪೇರ್.
By virtue of interim order, Lord, he has continued. Petitioner has.
ಯಾವತ್ತು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿರೋದು?
Interim order is granted.
ನಂದೇನಾ?
ಹೌದು. 15/1/2025.
ಫುಡ್ ಗ್ರೈನ್ಸ್ ಇವ್ರು ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲೇ ಮುಗಿಸಿರೋದೆಲ್ಲ. ಇರ್ಷಾದ್ ವಜಾ ಮಾಡ್ತೀನಿ ಈಗ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಫಸ್ಟ್. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್.
But to that effect, an affidavit is filed by the deputy commissioner stating that it is completed within 88th day. It was final, bid was already over. So it is within the time.
Pass over. Irshad, pass over.
Number 16, Sridhar K.
I appear for the petitioner. Matter relates to the selection to Vice Chancellor of Karnataka University. My lord, he is the person fourth respondent selected is not eligible.
Why?
Because he was not a professor for 10 years as per UGC regulation. He was a registrar for some time, for about 4 years. That period has to be excluded. If that period excluded, then he is not eligible to be even to make application. Apart from that, ಅದು ಒಂದು ground. Plus, considering the merit, I am stands more meritorious than the fourth respondent.
ಮೆರಿಟ್ ಯಾರು ಅಸೆಸ್ ಮಾಡಿದ್ರು?
No, my case has not been considered. That your Lordship has to look into the records and then whether my case has been considered.
He was not even part of the shortlisted. 3 persons were shortlisted. Petitioners was not even within the 3 persons who were shortlisted.
Whether my application is considered or not.
One minute.
I appear for the person who has been now appointed.
You are for the appointee.
Yes.
They have been directed to
Karnataka University.
Karnataka University.
ನೀವು ಯಾರಿಗೆ?
University. Respondent number 3.
Where is search committee? The constitution and
that is that
they will have to government and the governor.
Government and
I appear for Chancellor Milords. Milords, they have not challenged the process. They only challenged on 2 grounds, Milords. One, Milords, the petitioner is having more merits. The second point, Milords, one of the persons of the search committee, Milords, is belong to the same community. These are the only 2 grounds what they have urged.
Same community.
One of the person in the committee belong to the community of the.
There is no other ground which is being made out.
ಆ ಗ್ರೌಂಡ್ ಎಲ್ಲ ನಡೆಯಲ್ಲ.
ಆ ಗ್ರೌಂಡ್ ತಗೊಂಡಿಲ್ಲ. ನಾ ಮೆರಿಟ್ ನಲ್ಲಿ ನನ್ನ ಕೇಸ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ತಾವು ಅದಕ್ಕೆ ಒರಿಜಿನಲ್ ರಿಕಾರ್ಡ್ಸ್ ತಾವು ನೋಡ್ಬೇಕಾಗತ್ತೆ.
No grounds is made out to bring any records, Milords, because they have not challenged any process. They are only on 2 grounds, Milords, only on more merits.
Shortlisted candidates ಎಲ್ಲಿದ್ದಾರೆ?
They have mentioned it in the petition itself. If they have pleaded it in para number 4. The government constituted a search committee consisting of 5 members, and it appears that the committee has looked into the credentials of each of the candidates, and appears that the committee recommended 3 names, namely 4th respondent at seal number 1, and 1 Samantha Deshmani at seal number 2, and a Vedmurthy AB at seal number 3.
How can we go into the?
My lord, they have been directed to file objection. They have not filed the objection. That is one aspect.
I don't have any records. I can only stand on the strength of.
objection.
University is not considered.
University we have filed the objection.
University formally placed the facts only.
No. You want objections?
Objection from the first and second respondent.
First and second respondent yaru?
Chancellor.
They are the authorities.
They will make their submissions. Why are you worried? Objection ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕ್ಲಿಲ್ಲ ಅಷ್ಟೇ.
There is no grounds made out, Milords, for me to make a.
I will place my matter. One day.
28.
I am leaving for US on that day. Earlier to that or.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
1 month.
Earlier to that ಆಗಲ್ಲ.
1 month ಹೋಗ್ತಾ ಇದ್ದೇನೆ.
ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ತಗೊಳ್ಳ?
ಆಗ್ಬೋದು. Date admit.
Stay ಏನಿಲ್ಲ ತಾನೆ?
Stay it was, that is modified. After I took charge, stay was granted and I brought it to your lordship.
Granted.
24th your lordship can have.
So madhyana move ಮಾಡಿದ್ರು. On the same day I had taken charge. They had moved it at 2:30 minutes and stay was. That is modified.
My lord.
By the other bench.
Not my lord.
No.
My lord, 24th your lordship. I will come here. For
24th.
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 Please.
List on 24th at the 24th.
Please.
17.
Obliged.
Lords, in this filing of amendment application would not be necessary, my lords, so since we have already sought for a relief of certiorari in the prayer, my lords.
ಏನ್ madam? Non-filing amended application.
Yes, ma'am.
ಏನ್ amended application?
On the last occasion, my lords, it was called for the first time, and honorable court perceived that there was no relief of a certiorari sought in the prayer, my lords.
ಎಲ್ಲಿದೆ ಆ ತರ ಏನಿಲ್ವಲ್ಲ?
Prayer ಅಲ್ಲಿ
ಅಲ್ಲ ಆ ತರ ಆರ್ಡರ್ ಏನಿದೆಯಾ ಇಲ್ಲಿ?
the previous order.
ಏನಿಲ್ಲ, ಆಫೀಸ್ objections. Office objection stands overruled. What's the matter?
It's a tender matter, my lords.
My lord,
Petitioner had participated.
Kindly pass over, my lord. He's held up in, he's on his legs.
Usmania.
He's on his
Usmani.
legs. No, Lingaraj Maradi, Lingaraj Maradi.
What's the matter?
Kindly pass.
It's a tender matter, my lords. Petitioner had participated in the e-procurement tender called for running of Kalyan Mandap, my lords. However, after the tender was called and it was allotted to him, it was found that it was in an unfit condition to use, my lords. We have given several representations seeking for repairs and also changes or taking back of the tender, my lords. And we have paid 20,40,000, my lords.
ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
Bare 14,71,000 is returned, my lords. Our grievance is another 5,71,000 has to be returned.
Why is it withheld?
Without any.
Why is it withheld?
Without any reasons, they have withheld, my lords. They have not given any reasons.
ಯಾವಾಗ ಕೊಡ್ತಾರೆ ಅಂತ ಕೇಳ್ಬಿಡಿ. Why do you put a building that is impossible to use for tender?
I'm not.
They have accepted that by returning the
When they
amount.
themselves have appointed an inquiry committee, my lords, they have also given a report saying that it is not in a condition to use, my lords, and to return the security deposit.
I'll post it on 28th.
Please, ma'am.
ನೀವೇ ಕೊಟ್ರೆ ಪರವಾಗಿಲ್ಲ ವಾಪಸ್. ಇಲ್ಲ ಅಂದ್ರೆ
There is a direction.
ಕಾಸ್ಟ್
Much police.
Yes, much obliged.
28th.
Please.
18 and
28th in preliminary hearing. Yes.
Please.
Therefore, respond number 1.
Respond number 3 needs to be served, my lords. Anil Kalisar is on his legs.
Post immediately after
My lords,
service.
one submission. One submission.
ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ?
ಇಲ್ಲ, he is, my lords, guarantor. He is borrower. I am Sauharda Bank.
ಸರ್ಫೇಸಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಇಲ್ಲ, Sauharda Act ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ತಗೊಂಡಿದೀವಿ, EP ಹಾಕಿದೀವಿ. Now EP has been stayed.
ವೈ?
My lords, they
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇದೆ ಅಂತ ಮಾಡೋದು ಅಷ್ಟೇ.
they appear, they don't file objections, they don't participate in the inquiry, and now they have come up with some slips and say that they have.
Will arrest warrant na we will arrest and permit further proceedings to go on.
Mr. Anil Kalisar is on his legs, my lords. Can you pass?
Pass.
Please.
Number 19.
Your Lordship, a week's time to issue process to R6, Your Lord.
Post immediately after service of notice upon the fifth respondent. A week's time is granted to do the needful.
There is an interim order, Your Lordship.
2 weeks time is granted to do needful. Interim order subsisting will continue with the
Obliged.
next.
Number 20. Bihar Dundappa.
My lord, in respect of respond number 2, correct address will be punished.
2 weeks time to do the needful.
And office objection.
2 weeks time, yes.
Please.
Sankesh Shankarappa.
Please, my lords. Lords, the office objections are clerical in nature. I undertake to comply them. My
En
lords.
Perola.
This is a case of heinous police brutality, my lords.
Police brutality?
Please see page 12, my lords. My petition, the photographs, the injuries, they speak for themselves, my lords. I lost one ear tympanium. My lords, there is one deep vein thrombosis in my left lower limb. My lords, there are so grave injuries.
Why were you
to
taken
other-
into custody?
My lords,
Why were you taken into custody?
me, I am not taken to custody. I am under treatment.
Police brutality ಯಾಕೆ ಆಗಿದ್ದು ಸರ್?
My lords, let me put few facts. On the intervening night of 28 and 29, I'm a law student. I'm an ex-serviceman. I run a mess in Dharwad. My lords, on that day, there was a match of some India-Pakistan match was there, cricket match was there. 2 police officers in drunk condition, they come to my mess and say that, shut down your mess. They use some vulgar language. I demand that I'm an ex-serviceman. Please speak respectfully. There are 2 customers waiting for dinner. Let them have, I will close it. They get into altercation with me. Thereafter, those 2 policemen, they get into altercation with me. Thereafter, they call their station. The entire station drops down to my premises. They lock me and my family within the mess. They lock it. And for an hour, I and my 2 young minor nephews were brutally assaulted within my premises. And thereafter, they remove my jacket, clean the blood stains, take out the CCTV footage, they destroy DVR and run away from the location. I was detained in my premises, bleeding condition. For an hour, I was stopped from being taken to hospital. This is the brutality. Never witnessed in this city, my lords. Never. And the high-handedness of investigation. Please see.
Crime register madidra?
There is an FIR. At the time of filing this petition, no FIR was registered. Immediately we come to this honorable court. They register an FIR after lapse of 15 hours. I go and file a complaint. My wife goes and file a complaint in the middle of the night, 3:30 a.m. The police officer, same officer, waits for 15 hours. Once I am in this honorable court, they register an FIR. In between, they register false FIR against me.
Challenge madidira?
Not challenged. Their bail has been rejected. 2 officers are already in custody, and the
Officers are in custody?
2 officers. The first 2 officers. The illegality now is, my lords, the accused police officer, he himself is investigating. The inspector is also involved in the assault. He in fact assaulted the minor.
The investigating officer?
Inspector, head of the station. He also assaulted.
What is the prayer sought now?
My lords, I sought for change of agency and investigation under some judicial supervision.
That has been already done on 10/10/2025.
Yen madidira?
Changing the investigation officer since the
Did
incident.
you appoint that investigating officer?
Lord, since he was the head of the station, at the time of the incident, he was
Not involved in the assault?
no.
Who is under arrest?
ಹೆಸರು ಗೊತ್ತಿಲ್ಲ
One
ನನಗೆ, but
assistant sub-inspector
two
and one
police
constable.
police have been arrested and they have been detained.
How is that police enter into and end up in such brutality against citizens?
But taking note of the complaint averments, my lord, there are no such, as they contend before the lordship, there are no such specific allegations against the particular persons. A general complaint is filed.
Why did the police enter into and do such things?
To that, my lord.
Now, you have not claimed compensation for what is done?
My lords, it's only on 20th we are all seeking appropriate remedies. My lords, may please see this document. Their high-handedness, my lords, these never imagined that they will step down to this level. He was forced out of KIMS. My lords, may please see on 6/10, this doctor issues a certificate. This was produced in their bail application, my lords. This doctor says patient is fit for discharge. Immediately after 3 days, I am operated at KLE Belgaum. I was forced out of KIMS. I was thrown away. I was not able to stand up under the influence of these accused police persons. I was thrown away of the hospital. The wife of the victim is here in the court hall, my lord.
Correct prayer kelbeku. If I have to pass some drastic order, there should be some prayer appropriately sought.
My prayer
In
would
there,
be,
they will take it to the division bench and create problems.
my lords,
You should seek appropriate prayer, will teach them.
please.
Yes.
My prayer is limited only to the change of agency and under the supervision of judiciary. That can
ಮಾಡಿದ್ದಾರೆ ಕೊಡಿ.
CCRB ಉಪವಿಭಾಗ ಹುಬ್ಬಳ್ಳಿ ಧಾರವಾಡ has been appointed as a
ಯಾರನ್ನ?
ಕೆಳಗಡೆ
ಯಾರನ್ನ ಮಾಡಿದ್ದೀರಾ?
ಸಹಾಯಕ ಪೊಲೀಸ್ ಆಯುಕ್ತರು CCRB ಉಪವಿಭಾಗ ಹುಬ್ಬಳ್ಳಿ ಧಾರವಾಡ. This is on 10/10/2020.
Who is the superintendent of police?
Lord, I have to. Yes, sir.
Get the name of the superintendent of police.
Please.
We will direct the superintendent of police to inquire into this.
That is done.
Bonjan Arya is the Bonjan Arya is the superintendent of police.
Whatever, pass over.
And my lords, one more concern. On the 30th, there was an interim order to preserve the CCTV footage
That will always continue.
of the premises. That may kindly be safely handed over by these accused police persons to
Where is
the
the
concerned IPO.
DVR ಎಲ್ಲಿದೆ?
It is served.
It
my
is
lord.
preserved?
Yes, yes.
The coordinate bench of this court on 39/20/25 had passed an order directing preservation of the CCTV footage / the DVR that would drive home as evidence, that would be the evidence of the incident. The issue in the list pertains to gross police brutality, alleged gross police brutality upon citizens. A citizen, the petitioner who runs a mess. The 2 police officers who were allegedly involved in such brutality have been taken into custody is the submission of the learned counsel with the petitioner, and the bail sought by them is rejected. What further shocks the conscience of the court is the station house officer under whom the 2 police officers had behaved in the manner, or even the station house officer had behaved, was appointed as the investigating officer to investigate into the crime registered by the petitioner on the said incident. After the filing of the present petition, it transpires that the investigating officer is changed and who is now appointed?
My lord, CCR, Sayaka Police Ayuktharu,
Assistant
Police Commissioner,
ACP.
CCRB.
The assistant Sahayak Police
Sayaka Police Ayuktharu.
of the CCRB is appointed as the investigating officer in change to what the petitioner has sought. Therefore, the learned AGA submits that the grievance of the petitioner is redressed. I decline to accept the same. The grievance of the petitioner is far from being redressed. The learned counsel for the petitioner has also, the memo,
Please.
also seeks to place on record certain documents with regard to the Kim's Hospital yielding to influence and driving away the petitioners on the date of assault, and for which the petitioner had to be operated 2 days later in a different hospital. All these would clearly go to show that prima facie go to show that there is something more than what meets the eye. Therefore, the superintendent of police of the Dharwad district,
Yes, please.
Dharwad district, rural urban idea,
Illa suburban barutte. City.
Dharwad district shall now supervise the investigation or appoint an appropriate investigating officer to investigate into the offence. The copy of this order be served upon, the carbon copy of this order be served upon the learned AGA for appropriate action, and compliance be reported by the next date list on 28th in preliminary hearing.
Very great.
Yes.
Assistant Matter number 22, Abhishek Tripathi. Number 20. 22.
Non-compliance. Agil Vayatanu.
22. Yes. 22 correct.
My lord, serial number 22, my lords.
I'm going to dismiss this.
My lords, this petition all along was listed in B group. Certain new office objections have been raised now, my lords, after 4 years. I will, within 2 days, I'll comply with the same, my lords.
ಎಲ್ಲದಕ್ಕೂ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ up to 63. Finally, 10 days time is granted to comply with the office objections, showing indulgence as it was a common order that is passed. In the event objections are not complied with in all these cases as directed by the coordinate bench earlier, the petitions would be dismissed without showing any indulgence to the submissions made by the counsel for the petitioners, as this would be the last straw of opportunity to comply. Withdrawal idre kodi madhyadalli yadaru. Yes.
My lord,
List all these matters on 29th.
My lord, one submission. My lord, serial number 22 is the reservation policy matter, my lords, where your lordships had granted interim order.
Office submission comply ಮಾಡಬಾರದು ಅಂತಿದ್ಯಾ?
Please, please.
Next. Withdrawal ಯಾವುದಿದೆ ಅದು ಕೊಡಿ. Up to n ಎಲ್ಲಿವರೆಗೆ ಮೇಡಮ್ ಇದು? ಇದರಲ್ಲಿ interim orders ಎಲ್ಲೆಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಬೇಕು.
Number 64, preliminary matter, MCO query.
Notice. Learned HCGP is directed to accept notice for the respondent. AGA na? Learned AGA is directed to accept notice for the respondent. ಎಲ್ಲರಿಗೂ
Please.
To all the respondents. Yes. Next.
1, 3, 4 and 5.
ಎಲ್ಲರಿಗೂ ಅಂದ್ರೆ 1, 3, 4 and 2 ಯಾರು?
2 BTD engineers, chief executive.
They are appear.
Sanjay Channal.
Second R2 ಗವರು ಮಿಕ್ಕವರಿಲ್ಲ. Next.
Number 65, PG Chignatu.
Notification by
Survive ಆಗತ್ತೆ ಈಗ. Anything survives today?
Please, your lordships. Yeah, other corrected matters are not pending, your lordships. Similar matters are pending, your lordships.
ಕೊಡಿ. Numbers ಕೊಡಿ.
Furnish it to lordships. From 1 to 3 government, your lordships.
1 to 3 government.
4 and 5. 4 and 5. Sunil Desai is appearing for the
1 to 3 government, 4 and 5 Sunil Desai. Next.
Respondent number 6 is not the KL Patil appearing, Your Lordship.
6 KL Patil.
KL Patil, please.
Bill number 66. Dharwad Pramod.
I seek time, my lords, kindly next week. A senior
time.
is,
Yes. Objections, if any, by the respondent by the next date. List the matter on 30th.
obliged.
Bill number 67. Prasanna Kumar P.
Yesterday, day before yesterday, the Lordship has directed me to ascertain and has ascertained that a communication was sent to the applicant as well as to the authority who have been appointed, stating that non-furnishing of the necessary documents with regarding to the treatment having been taken and compliance of the government order.
Medical reimbursement ತಾನೆ?
ಹೌದು.
ಯಾಕೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅವು ಕೊಟ್ಟಿಲ್ಲ ಅವರು. He has to submit to the TMC.
ಇಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಅವ್ರ main grievance is that was intimated in the year 2022 itself.
ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರಲಿಲ್ಲ.
ಅಲ್ಲ ಅವರು ಮೊನ್ನೆ ಬಂದಿದ್ದಿಲ್ಲ. ಇಲ್ಲ.
ಅಲ್ಲ ಬಂದಿರಲಿಲ್ಲ ಮೊನ್ನೆ.
ಇಲ್ಲ ಮೊನ್ನೆ
ಯಾರು ಇರಲಿಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ.
There was no representation behalf of the petitioner on 13/10/2025. This court had directed the petition, this court had passed the following order. The learned AGA on instructions would submit that the application of the petitioner seeking reimbursement of medical expenses did not append to it necessary documents. It is therefore the communication between the two departments happens in to direct the petitioner to produce all the documents. It is therefore liberty is reserved to the petitioner to produce all the documents before the competent authority in furtherance of the claim that he has made seeking medical reimbursement. In the event such application along with all documents are submitted as is needed, the respondent shall process the application of the petitioner in accordance with law and grant such medical reimbursement that he is entitled to, ordered accordingly.
But appointing authority is also not made as a party.
Well,
Number 68.
yeah, ಅದಕ್ಕೆ ಟೈಮ್ ಲಿಮಿಟ್ ಏನು ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ, ಸೊ ಕಂಟೆಂಪ್ಟ್ ಏನಾಗಲ್ಲ. 60 compassionate appointment.
May my lord's request for, I just I've not gone through the file, I have misplaced my file.
Objection ಹಾಕೊಂಡಿದೆ ಅದು when coordinate bench rights were bound by it.
Please.
Yes. ಇದೇನಾ ಅದೇನಾ?
I have, my lords, I have to go through the.
Learned counsel Prashant Hosmani seeks 2 weeks time to go through the papers and make submissions or file statement of objections as the case would be. 12th November. Yes, next.
69. SM Kalwad.
Damage our.
ಅದೇ ಬಲವಂತ್ ಸಿಂಗ್. Balwant Singh.
But as per RL, decision of RL Jain judgment, my lord. At the time of passing damage award, the only SLO gets a power.
Damage award ಅಂತ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು ಅಷ್ಟೇ.
There is no provision. And also, my lord, as per award also, as per the SLO original award.
One moment, sir. Who is the beneficiary of the award?
Respondent number 3, my lord.
Serve ಆಗಿದೆಯಾ?
ಇಲ್ಲ, first time it is.
First time. Emergent notice to the third respondent. Returnable by the 12th of November. 1 and 2 AGA. Yes.
May seek for interim order.
ಏನ್ interim order?
ಅಲ್ಲ, some of the landowners they are filing a writ petition to execute this order award.
ಬೇರೆದ್ರಲ್ಲಿ interim order ಇದೆಯಾ?
ಅಲ್ಲ, this is the only first time matter.
First time ಅಲ್ಲಿ ಇದಲ್ಲ, ಬೇರೆದ್ರಲ್ಲಿ ಈ ತರ
ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೇ first time ಬಂದಿದ್ದು.
ಇಲ್ಲೊಂದೇನೆ ಇರೋದು.
ಇದೇ first time.
There shall be an interim order of stay of award stay ಮಾಡೋದು ಕಷ್ಟ.
ಅಲ್ಲಲ್ಲ,
Based on 12th.
some of the landowners they have filed
Petitioner is at liberty to move the matter in the event any action is taken prejudicial to the interest of the petitioner in the interregnum. List on 12th November. Yes, next.
Please.
Number 70. Ganesh Raibagi.
60.
70.
Lord, petitioner is exclusive
Exclusive?
owner of the mother's property, that property.
Senior citizen.
Senior citizen ಮೇಲೆ.
Lord, Assistant Commissioner has allowed this. He would have not filed the Deputy Commissioner. Deputy Commissioner has rejected his and stated that it is civil in nature. Go and approach the court.
It says exclusive.
So the deputy commissioner order has to be set aside.
Now, my lord,
ಅಲ್ಲ ಈಗ ಸದ್ಯಕ್ಕೆ ಸ್ಟೇ ಮಾಡೋಣ.
ಅಲ್ಲ ಸರ್ಡ್ ಅನ್ರಿಪ್ರೆಸೆಂಟೆಡ್ ಇದ್ದಾರೆ ಅವ್ರು ಎಲ್ಲರೂ.
ಆಲ್ ಸರ್ವ್ಡ್?
ಹೌದೌದು.
so my lord, I have an interaction with them, some of my lord respondent 4 and 5. They are present before the court and they are supporting the case of the petitioners also. Only one respondent.
ಸದ್ಯಕ್ಕೆ ಸ್ಟೇ ಮಾಡೋಣ. The respondents are, the coordinate bench had issued notice on 28/20/25. Though the respondents are served, have remained underrepresented. As a last chance to give an opportunity for getting themselves represented, list the matter on 28th.
Yes.
The order of the deputy commissioner shall remain state till the next date.
Much.
Yes.
71, the case.
But in the same stage.
Single subject.
In the same step.
Same stage. ಅಲ್ಲ ಇದು same stage on 28th. Covered ಎಲ್ಲಿ? Single subject.
Single subject, your lordship, ಮಾಡಿದ್ದಾರೆ.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the prayer of the petitioner is identical to what was sought by several identically placed teachers, in the writ petition, page 41. ಆಮೇಲೆ ಇನ್ನ ಇದೆ writ appeal is order. And page 66. The learned HCGP though would vehemently refute the submission of the petitioner, counsel for the petitioner to buttress her submission that the issue does not stand covered. The perusal at the orders would clearly indicate that the issue in the list is identical to what is decided by the aforequoted orders, and the petitioner also becoming entitled to the same relief that is granted to those assistant teachers in the cases quoted herein above. In that light, the petition deserves to succeed, with the prayers being answered in its favor. So, approval of appointment alva?
Please, your lordship.
So, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸೇಮ್ ಆರ್ಡರ್. ಇದರಲ್ಲಿ BS ಪಾಟೀಲ್ ಆರ್ಡರ್ ಇದೆ ಅಂತ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅದೇ ಆರ್ಡರ್, ಸೇಮ್ ಆರ್ಡರ್. ಪೇಜ್ ಹೇಳ. For the aforesaid reasons, the following order. Page 66. Yes. Next.
72, Muhammad Ali.
With objection ಬೇಕಾಗುತ್ತೆ.
My lords, this is an issue with respect to a legal body and an illegal body formed by the respondents.
What?
In respect of a wakaf.
ಆಯ್ತು.
I am being a wakaf legally formed committee, president of a legally formed committee, as page 24. My tenure is subsisting till 23 November 2025. And pendency of this tenure, the other respondents who are at objections raised being, those are the respondents who have illegally formed in a committee, and without there being any legal formation of that authority, they have passed a resolution and secured all the documents which were a part of the administration of the body. Subsequently, the Waqf officer issues a public notice with respect to forming of a new committee of those respondents who are party to this list. Now, I being a president, I have a tenure till November 2025, which is ending next month. Subsequently, elections are near. My humble submission is,
What is under challenge?
The public notice which is so issued at Annexure J.
What public notice is that?
Annexure J at page 42 may can be perused.
What is that notice?
Annexure J says, notice is hereby given for the information of the residents of, so having interest in the affairs of the management of the institution to prefer objections and suggestions. It is for calling upon objections, suggestions, and to form a committee.
So what? ನಿಮ್ ಟರ್ಮ್ ಆದ್ಮೇಲೆ ಆಗ್ಲೇಬೇಕಲ್ಲ ಅದು.
ಆದ್ರೆ ನಮ್ ಟರ್ಮ್ ಇನ್ನೂ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಸರ್.
ಅದು ನೋಡ ತೊಂದ್ರೆ ಇಲ್ಲ.
Subject to that, my lords may dispose of the petition.
Petition may not survive for consideration. After this approval, a new committee is formed.
Already formed.
Yes, in the March 2025.
Challenge ಮಾಡಿ.
Pendency of the this list, my lords.
You don't challenge that.
Lordship, regarding the formation of this new committee,
it is not informed to the present committee.
That's all right. You want liberty to challenge that or not?
My term is ending by 25/11.
ಹೊಸ ಕಮಿಟಿ ಬಂದ್ಮೇಲೆ ನಿಮ್ ಟರ್ಮ್ ಮೇಲೆ ಎಂಡ್ ಆಗೋಗಿದೆ ಆಗ್ಲೇ. If you want to challenge that, you challenge that.
That is not intimated also, and
I
that
can't
is.
give you advice, sir.
My lords,
List
my
after
humble
4
submission
weeks.
is, my lords, even if the committee is formed, it is not in pursuance of section 67 of the Work of Act, my
That I
lords.
can answer only under a challenge, not in your oral submissions.
I seek a liberty.
That's
my
why I
lord.
told you, I
seek
can't
a
give you
liberty.
advice.
I seek a liberty, my lords.
Yes. The learned counsel, the petitioners are before this court in the, seeking the following prayer. The learned counsel Sadiq Godwala, representing the respondent, submits that during the subsistence of the subject petition, a new committee is already constituted. The learned counsel of the petitioner seeks liberty to challenge the said constitution of the new committee on the score that his tenure would end only in November 2025. Therefore, reserving liberty to the petitioner to call in question the formation of the new committee in terms of the order dated 12/3/2025.
13/3.
You know?
13/3/2025.
13/3/2025, the petition stands disposed.
Yes.
Yes, grateful, sir.
Bill number 73, MB Hiramand.
Petitioner, land of the petition,
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
ಅಂದ್ರೆ excess was taken, millards. A representation was directed to be considered. Millards, they themselves got a survey conducted, millards, through the office of ADLR. ADLR has reported that there is a excess. Yes, ma'am.
Yes, sir.
Your
I get it.
CV Angadi appears, millards, for our 2 to
Counsel CV Angadi is directed to accept notice for respondents.
number 2 to 4, millards.
2 to 4.
Yes.
One state,
State, millards.
one AGA.
Please.
List on petitioner to serve set of papers upon SV Angadi forthwith.
Please,
List on 12th November.
please. Grateful.
Yes.
Number 74, K. Anand Kumar. Vijay Kumar.
For the petitioner, my lord, the petitioner is working as a daily wages basis.
Correct. Select list of Paura Karmika.
Yes,
74 alva.
oh, please.
Select Paura Karmika select list is challenged.
Your provisional list and the final list, my lord, the present petitioner is selected. Revised the list, my lord, the name of the petitioner deleted, my lord.
Correct. Let them answer.
And the, my lord, kindly, as per the notification.
9/2/2024 is the list.
Please.
ಇವಾಗ 1.5 ವರ್ಷ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ ಸ್ಟೇ ಇಲ್ಲ.
ಬೇಡ ಅಷ್ಟ ತಾನೆ, ನಾನು ನೋಟಿಸೇ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, my lord, kindly see, I produced the notification,
Notice
my
has been
lord.
ordered, Your Lordship.
I produced the, there is a 23 vacancy post, my lord. 17 application has been filed.
ಕರೆಕ್ಟ್ ಹೇಳಿದ್ರಿ, ಇಂಟ್ರಿ ಮಾಡಲ್ ಕೊಡ್ಬೋದ ಅದನ್ನ? ಒಂದೇ ನಿಮಿಷ. ಎಸ್, ಹೂ ಹ್ಯಾಸ್ ಟು ಆನ್ಸರ್?
Your Lordship, the senior, Your Lordship, to the petitioner is been selected in the final list. Your
ಈಗ
Lordship.
23 ವೇಕೆನ್ಸಿ ಇದೆಯಂತೆ.
Please, Your Lordship, the Lordship has directed, Your Lordship, the respondent number 3 to find out if any vacancies are available, Your Lordship.
Who is respondent number 3? There is no representation.
ಸರ್ಡ್ ಆಗಿದೆ 4.
Even
ಯಾರು appear ಆಗಲ್ಲ? ಯಾರು appear ಆಗಲ್ಲ?
ವಿಜಯ್ ಕುಮಾರ್.
ಇದಾರಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್ ಯಾರು?
Vijay Kumar.
ಬಡವಡಿಗಿನ ಅಲ್ಲ.
Even
As per the government notification ಮೇಲೆ seniority ಇಲ್ಲ, 2 ವರ್ಷ ಆದ್ರೆ ಸಾಕು.
ಆಯ್ತು, ಅವ್ರು ಬಂದ್ರೆ ಹೇಳ್ಬೋದಲ್ಲ.
even I have also sought for the information, Your Lordship, but not yet received.
That's the matter. There is no representation on behalf of the third respondent. Awaiting his appearance as a last chance, lists the matter on 28th. In the event the third respondent would not be represented, appropriate orders would be passed. This court would be constrained to grant an interim order directing appointment of the petitioner. Yes.
Please.
Bill number 75, Sunil Desai. MB Hiramand.
Did not
Post of
serve the
principal.
copy.
ನೆನ್ನೆಯಿಂದ ಪಾಸ್ ಓವರ್ ಆಗ್ತಾ ಇದೆ.
ಅಲ್ಲ, ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು.
ಯಾವ ಕಾಪಿ?
Writ petition copy is not yet served on. We were directed to take notice.
I'll give minutes.
Principal tenure ಮುಗ್ದೋಗ್ಬಿಡುತ್ತೆ. Learned counsel of the petitioner to serve set of papers upon Mallikarjun Swami Remat. ಅವರಿದ್ದಾರೆ, ಗಾಯತ್ರಿ ನೀವು ಇದ್ದೀರಾ, ಎಲ್ಲರೂ ಇದ್ದೀರಾ, ಎಲ್ಲರಿಗೂ. Yes.
Let's in connected matter, there is an interim order.
Interim order subsisting in any of these cases shall continue to the next date of hearing, 30th.
Great.
Yes.
That's 27th.
Why? Good day. 27th, all right.
76, CR Hiramand.
Order, this is with regarding to collection of sample, and the lordships had directed me to ascertain with regarding to whether the procedure within 14 days that it has been completed or not. Lord, may I have-
ಯಾವ್ದ್ರಲ್ಲಿದೆ ಅಂತ
That's
ಕೇಳ್ದೆ ನಾನು.
40,
14 days.
46,
4
3 millets. 46, 3 ದಲ್ಲಿ.
ಆಗಿಲ್ವಾ?
ಆಗಿದೆ. ಅದಕ್ಕೆ ಡೇಟ್
ಅದೇ ಒಂದ್ ನಿಮಿಷ ಹೇಳಿ.
please. Lord, the samples were collected on 5/11/2024 at the time of drawing Maja.
Furious ghee.
And it was
2024.
Yes, my lord. And it was sent to the district lab Mysore on 5/11 same day. It was reached on 8/11/2024. So, my lord, from 8/11/2024, analysis report is submitted on, it has been received on 27/11/2024.
14 days ಎಲ್ಲ ಆಯ್ತು.
In that, my lord, November 9 is the second Saturday, 10th is the Sunday, all 5 days exclude ಆಗುತ್ತೆ.
ಆಯ್ತು.
It exactly comes 15th day ante ಆಗುತ್ತೆ. It was as on the date when we received the email, it was 15th day. So, my lord, though the process
ಸಂಡೇ ಸಾಟರ್ಡೆ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೇಕು ಅಂತ ಯಾರು ಹೇಳಿದ್ರು ನಿಮ್ಗೆ?
ಅಲ್ಲ, but since it is a government lab, my lord, department which has been conducted the samples on that particular day, my lord, it will not be functioning. 4 Saturday, Sunday ಅವು exclude ಮಾಡಿದ್ರು.
ಫೋರ್ತ್ ಸ್ಯಾಟರ್ಡೆ ಈಗಲೂ ರಜಾ ಇದೆ.
ಹೌದು. ಒನ್ ಡೇ ಅಷ್ಟೇ ಬಂದಿದೆ.
ಬೇರೆ ಗ್ರೌಂಡ್ ಇಲ್ವಾ?
ಬೇರೆದಿದೆ, ಬೇರೆದಲ್ಲಿ ಬನ್ನಿ. That's section 38. That's wherein
ಫುಡ್ ಸೇಫ್ಟಿ.
Food and safety.
Sorry, 47.
ಅದೇ ಮತ್ತೆ
Sampling and analysis. It is very clearly stated that, my lords, when a food safety officer takes a sample for analysis, he shall give a notice in writing of his inspection. That is not been, he shall give his inspection in writing to the, my lords, food businessman operator. That has not been complied. They have not given any written notice to the petitioner. That is also, my lords, one of the. Let's again, my lords, section 47(2).
Immediately on the next working day.
ಅವಾಗ ಕೊಡ್ಲಿಲ್ಲ.
ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ಲ.
ಅಲ್ಲ, immediately they have to, my lords, send for the analysis.
ಮಾಡಿಲ್ಲ.
Now, my lords, their contention is, now, my lords, they are saying that analysis have been received the that sample and sent the report. That report, my lords, appears to be some rectification. Thereafter, my lords, he came to know that there is some rectification. He intimated through phone call and get the rectified report. That is also one of the, my lords, illegality. There is no amendment as such. Amendment ಆಗಲಿಲ್ಲ. ಅವರು ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. That is by way of memo, amendment ಆಗಿದೆ. That is also not in the rules, and rules are, my lords, regulations. There is no provision as such to get the amended copy. There is no
amended what copies?
Amendment of, my lords, that report, Annexure B. I have produced the, my lords, Annexure B, wherein, my lords, I have received a copy which is, my lords, original copy.
ಅದರಲ್ಲಿ ಏನಿದೆ?
ಅದರಲ್ಲಿ, that is what, my lords, Annexure B, my lords.
ಅದರಲ್ಲಿ ಏನಿದೆ?
ಅದರಲ್ಲಿ, my lords, the very sample is received after the, my lords, analysis. My lords, may kindly appreciate.
Page.
Annexure B, page 22. In first para itself, my lords, last line, so and so area on 28/11/2024 for analysis. The code number of the that sample ghee and the product.
ಆಯ್ತು, sample description 500 gram ghee in plastic bottle ಅದ?
ಅದು 200 grams.
ಅದು 200 grams. That is also one of the, my lords, illegality.
ಆಯ್ತು, ಆಮೇಲೆ
sample was received on 28/11/2024 ಅಂತ ಇದೆಯಲ್ಲ, my lords, their examination, my lords, second paraದಲ್ಲಿ
28/11/2024.
Examination is prior to sample receiving. Next paraದಲ್ಲಿ ಇದೆ 27/11 to 21/11 to 27/11 ಅಂತ ಹೇಳಿ. Sample receive ಆಗಿಲ್ಲ, examination has conducted. And for this, my lords, they have taken a contention saying that, my lords, there is a mistake in the report. There is a date which has been received, that is 8/11 and there. That is totally, my lords, illegality. I may be, my lords, submit That's at the last bottom, that is report, last bottom ಅಲ್ಲಿ date of inward 6 ಅಂತಿದೆ, 6/12 ಅಂತಿದೆ, 6/12 ಅಂತಿದೆ, inward date.
ಎಲ್ಲಿದೆ?
Annexure B ದಲ್ಲಿ last inward dated 6/12/2020.
Inward date
ಹೌದು.
6/12.
This is the report, Millers, wherein received by the Millers, the designated officer or the Miller food analyst, by the Millers analysis. To overcome Millers their mistake, now they have produced by way of memo, Millers, they have produced some documents saying that Millers, this is the report wherein corrected, and after that correction they have sent.
ಏನ್ ಕರೆಕ್ಷನ್ ಮಾಡಿದೀರಾ?
ಬರೀ ಅದು instead of 28th it has been 8th. We have received the samples on 8/11. ಅದು 28th and typical error ಆಗಿದೆ. That is the date, and 500 grams ಇದ್ದದನ್ನ 200 grams ml rectification ಮಾಡಿದೀವಿ. But the analysis report was received on 27th itself. But physically it was received by the office on 6/12. But through mail it was received on 27th November itself.
How did you say 28/11 first ಅಲ್ಲಿ?
Typical error, since my lord, the concerned officer who sent the sample itself on 5/11/2024, and it was received by the lab on 8/11. It cannot be beyond 28th.
5/11 ಕಳಿಸಿರೋದಕ್ಕೆ
ಹೌದು 5/11 sent to the district.
ಸರಿಯಾಗಿ ಕೆಲಸ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲ, we have that has been
What has been?
Lord, this is the rectified copy. May I pass?
What is this way of working? Cyclostyle orders ಮಾಡೋದು ಸಿಕ್ಕಿದ್ದೆಲ್ಲ ಮಾಡೋದಿಲ್ಲ.
Lord,
when it is pointed out, you
no,
correction.
No.
ಯಾವತ್ತು ಮಾಡಿದ್ದೀರಿ correction?
ಅದನ್ನ 27 before analysis report before ಮಾಡಿದ್ದೇವೆ.
Correction 27.
ಹೌದು, correction ಮಾಡಿದ್ದು.
Signed 27th November.
ಹೌದು, ಎರಡು 27th November. But original copy has been received by the inward on 6/12. They are not founding that the inward it is received on 6/12.
What is communicated to the petitioner?
But through mail only.
What which one?
This annexure B itself.
Which one is communicated to the petitioner, sir?
ಅಲ್ಲ, the annexure B, the which
Annexure
is B.
Annexure B.
ಅದರಲ್ಲಿ 28th ಅಂತ ಇದೆ date.
ಏನಿದೆ?
28th ಇದೆ.
How can that be?
ಅಲ್ಲ, ಅದನ್ನೇ rectification ಮಾಡಿದ್ದು ಇದು through mail ಅಂತ.
So ಇದು antedate ಮಾಡಿ rectification ಮಾಡಿ.
No, that is not.
ನಿಮಗೆ ಬಂದಿದ್ದು ಯಾವತ್ತಿದು?
Millers, I have not received on the date of Millers, received on the date of adjudication at annexure A. Adjudication date ಅಲ್ಲಿ ನನಗೆ ಅವರು ತೋರಿಸಿರೋದು, and I received it adjudication annexure A. Annexure A itself is
ರಿಪೋರ್ಟ್ ಆಫ್ ದ ಫುಡ್ ಅನಲಿಸ್ಟ್ ಬಂದಿದ್ಯಾ ನಿಮ್ಗೆ?
ಬಂದಿದೆ. ಅಡ್ಜುಡಿಕೇಶನ್ ಡೇಟ್ ಯಾವಾಗಿದೆ ಅಲ್ಲ ಅವತ್ತೇ ಅಡ್ಜುಡಿಕೇಶನ್ annexure A.
ಡೇಟ್ ಯಾವತ್ತು?
annexure A Millers.
ಪೇಜ್
That is on 4/1/2025 ಅಂತ ಹೇಳ್ತಾರೆ. That is the order passed by the authority.
16, page 16. Page 16.
Where a fine was imposed.
ಅಲ್ಲ, if that is so.
4/1/2025 ಗೆ the adjudication takes place.
Yes.
Order is passed. ಇನ್ನು 50,000 ದಂಡ ವಿಧಿಸಿದಾರಾ?
ಹೌದು,
ಕಟ್ಟಿದಾರ ಅದನ್ನ.
paid.
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
ವಾಪಸ್ ಕಟ್ಟಿಸ್ತಾರೆ.
ಆಯ್ತು.
Yes.
My Millers submission is, if that is so, for the sake of Millers their argument, admit what is the Millers base on the proceedings were conducted, on which report as the adjudication was conducted. Adjudication was conducted on the basis of annexure B. I have submitted that even on the day of adjudication, morning 8:30, TV9 ಅಲ್ಲಿ there is a bites by the Millers food analyst designated officer. By showing this report only, I have produced Millers the copy of the screenshot.
ಇದು ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದ ಈಗ 8/11 ಕರೆಕ್ಷನ್ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ, it is produced along with the.
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದೆ ಕೋರ್ಟಿಗೆ. At the time of filing of the statement of objection, it was not placed.
Statement of objections
ಹಾಕಿದ್ದೇವೆ.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇವೆ.
ಅದರಲ್ಲಿ statement of objection ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಅಲ್ಲ,
ಅದರಲ್ಲಿ
ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ
sir. At para 14 page 16.
ಈಗ statement of objection ಅಲ್ಲಿ have you taken a contention that it was a typographical error?
Yes.
Where is it?
Page 6 para 14. It starts from para 12.
One moment,
please. Further, respondent submits that the sample received by him as report dated 27/11 both.
Para 7
12 my lord. Page number 6. Further, the respondent number 4 submits that the sample received by him and his report dated 27/11 both were having been weighed mentioned on 200 grams, but while sending email it was wrongly mentioned at 500 grams. Was rectified immediately before sending hard copy of the final report dated so and so. It is also categorically denied by the lab was manipulated and is not contrary to the sample received for example. It is false to state that on perusal of form 5A, the sample lifted from the petitioner is 200 grams as per form 5, and contrary to this report it is mentioned as 500 grams. It is baseless to say that then it is false to say that sample of ghee was received on 28/11/24 and report was dated 27/11/24. In fact, the sample sent by the respondent number 3 and the same was delivered to the respondent number 4 on 8/11/2024 has been analysis from 21/11/24 to 27/11/24, and the result report of the analysis was prepared and sent to respondent number 3 on 27/11/21, and the same was delivered on 30/11/2024.
ಬಟ್ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದು ಯಾಕೆ?
ಮಲೋಡ
ಆಯ್ತು, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಜೊತೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಅದನ್ನ ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
ಅದ್ರ ಜೋಡಿ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. Entire another forms, those documents are produced, but that document was not placed.
And this
proceedings which were been
ಅಲ್ಲಿ what report is taken note of?
Annexure B, that
27/11/2014 24 the annexure B report ine date is same, my lord, only in so far
ಸೇಮ್ ಗೊತ್ತು, ಅದರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಫಸ್ಟ್ page 16 ಕೆಳಗಡೆ ಕಾಲಮ್ ಟ್ಯಾಬ್ಯುಲರ್ ಕಾಲಮ್ ದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ 27/11 ಆಫೀಸ್ ಚೀಫ್ ಆಫ್ ಮೈಸೂರು ಇವರು ನೀಡಿದ ವರದಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಅಂಡ್ ಬಿಫೋರ್ ದಟ್ ಮೇಲೆ ಪ್ರಸ್ತಾವನೆ ಪ್ರಿಯಂಬಲ್ ದಲ್ಲಿ
ಅದರಲ್ಲಿ 200 ಗ್ರಾಮ್ಸ್ ಅಂತ ಇದೆಯಾ?
ಹೌದೌದು.
ಆಮೇಲೆ ಸ್ಯಾಂಪಲ್ ರಿಸೀಟ್ ಡೇಟ್ 28/11 ಅಂತ ಇದೆಯಾ, ಏನಿದೆ?
27/11
ಅಲ್ಲ, ಇದ್ರದ್ದು 8/11 27 ಇಲ್ಲಿ ಸ್ಯಾಂಪಲ್ ಇಸ್ ರಿಸೀವ್ಡ್ ಆನ್ 28/11 ಅಂತ ಇದೆಯಲ್ಲ, ಅನೆಕ್ಷರ್ ಬಿ.
ಅನೆಕ್ಷರ್ ಡಿ ಮೇಲೆ ಪ್ಲೀಸ್
ನಿಮಿಷ, ಪೆಟಿಷನರ್ ಅನೆಕ್ಷರ್ ಬಿ ಅಲ್ಲಿ 28/11 ಅಂತ ಇದೆಯಲ್ಲ, ಪ್ಲೀಸ್ ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಏನಿದೆ ಅದ್ರ ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಇದೆ ಏನಾದ್ರು?
ಇಲ್ಲ, 27/11 ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
27/11 ಅಂತಾನೆ ಇದೆ.
ರಿಸೀವ್ ಡೇಟ್ ಎಲ್ಲ ಸೇಮ್ ಇದೆ, ಬಟ್ ಕರೆಕ್ಷನ್ ಆಗಿರೋದು
28/11 ಫಾರ್ ಅನಾಲಿಸಿಸ್ ಬಂದಿದೆ ಅಂತ ಇಲ್ಲಿ ಅನೆಕ್ಷರ್ ಬಿ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಅದೇ ರಿಪೋರ್ಟ್ ವಾಸ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಜುಡಿಕೇಶನ್.
ಹೌದು ಹೌದು ಸರ್.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
ಅಲ್ಲ, ಎಕ್ಸೆಪ್ಟ್ ದಟ್ my lord, this
the petitioner is before this court calling in question an order dated 4/1/2025 passed by the first respondent imposing penalty of 50,000 rupees and declaring that the sample collected, i.e. ghee, was substandard. Heard so and so. Facts in brief germane are as follows. On 5/11/2024, the food officer, the designated food officer under the Food and Safety Standards Act 2006, in hereinafter referred to as the Act for short, conducts an inspection of the business premises of the petitioner on certain allegations. During the conduct of inspection, sample of ghee of 500 grams was seized and sent for examination. It is the examination. The examination yielded a report declaring that the ghee sample selected, the sample selected was of substandard quality, and therefore penalty of 50,000 rupees comes to be imposed apart from the aforesaid declaration. It is this that has driven the petitioner Milk Dairy before this court in the subject petition. The learned counsel appearing for the petitioner submits that the procedural lacunae galore in the case at hand, inasmuch as the procedure adopted by the respondent in determination or drawing up proceedings runs completely counter to section 47 of the Act. It is a submission that section 47 mandates that when the food safety officer takes a sample of food for analysis, he should give a notice in writing with his intention to have it so analyzed to the person from whom he has taken the sample. This is one of the illegality. The learned counsel submits that this has not been done by the food safety officer, and therefore it is in violation of law. The learned counsel would submit that this is only an illustration of violation, but violations are many in the case at hand. He would further contend that in Annexure B, another report.
Yes, Annexure B, ma'am.
He would further contend that the report of the food analyst appended to the petition would depict that the sample for analysis was received on 28/11/24, but the analysis is done on 27/11/24, which is long before the receipt of the sample. He would contend that an antedated report is placed contrary to law, and the penalty is imposed without application of mind. Per contra, the learned AGA, the consurement, would place on record a would place on record two documents which depict correction of the date of receipt of the sample. It depicts 8/11/2024. This 8/11/2024, and would submit that all other procedures are clearly followed while drawing up the report of the analyst. He would seek dismissal of the petition. I've given my anxious considerations. Therefore, narrated facts are not in dispute. They are a matter of record. The link in the chain of events are a jugglery of dates. The inspection of the premises of the petitioner was conducted on 5/11/2024. After the inspection, the sample of ghee, which was allegedly substandard, was drawn from the premises of the petitioner and sent for examination. There is a dispute with regard to what is the amount of sample that was drawn, whether it is 200 grams or 500 grams. The report appended to the petition depicts that it is 500 grams. The learned AGA has placed on record that it is 200 grams and not 500 grams.
The same document was appealed.
Correct. 200 grams and 500 grams. The 500 grams. The other submission, sorry, one nimisha. With regard to the sample, receipt of sample, the document, the report of the food analyst indicates that the report of the sample, the sample was received for its analysis on 28/11/2024 and the 28/11/2024, but the analysis of the sample has already taken place on between 21/11/24 and 27/11/2024. Therefore, it is a case where even before the sample is received before the analyst, the analysis takes place ostensibly in thin air. The learned AGA has again placed on learned AGA taking this court through a document that is now sought to be placed before the court would contend that the sample was received on 8/11/2024 and it was analyzed between 21/11/24 and 27/11/24. Therefore, there can be no illegality as is alleged. The submission is noted only to be rejected, though it may be in justification of what the document may be in justification of what the learned AGA submits, but there is complete lackadaisical attitude on the part of the food analyst, on the part of the analyst in recklessly drawing up dates in the report of in his report. The illegality projected with regard to dates are noted herein above. If the sample is received on 28/11/2024, it could not have been analyzed a day before, i.e. on 27/11/2024. Even if the justification is taken note of, what shocks is adjudication proceedings has taken place not on the document that the petitioner, that the learned AGA has now placed, but on the document appended to the petition as Annexure B.
It is the entire appeal copy. That the same document is produced.
Right. Annexure B. The learned AGA, though seeks to justify by production of the entire records, contending that it is not on Annexure B, but on the corrected version. The corrected version nowhere found its place Even while filing statement of objections, it is only now that the learned AGA is wanting to produce. Therefore, there is wanting to produce. This is the aforesaid is the first leg of illegality in the proceedings. Section 47 of the Act, which becomes germane to be noticed, reads as follows. Section 47 mandates certain functions at the hands of the sampling, the hands of the food safety officer. A food safety officer who takes the sample of food for analysis shall give a notice in writing with his intention to have the sample analyzed to the person from whom he has taken the sample. Sample of the ghee, whether it is 200 mg or 500 mg, is drawn from the petitioner. There is no notice given or communication to the petitioner. There is admittedly no notice or communication given to the petitioner that the food analyst, that the food safety officer is wanting to get the sample analyzed. This is the second leg of illegality. ಇದು 5 days ಅಲ್ಲಿ ಕಳಿಸಿದಾರಲ್ಲ, ಇದು ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಸರ್, ಆಗಿಲ್ಲ.
ಸಬ್ ಕ್ಲಾಸ್ 4 ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
The third illegality is subsection 4 of section 47. Subsection 4 mandates that the article of food, unless destroyed, shall be produced before the designated officer as soon as possible, and in any case within 7 days from the date of receipt of the report of the food analyst. This also has not been done in the case at hand. With these admitted facts and the illegalities, the impugned order, which imposes penalty of 50,000 rupees and declares that the ghee of the petitioner was substandard, would tumble down, and as a result, the petition deserves to succeed. Allowed, quashed.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೆಕ್ಷನ್ 68 ಕೆಳಗಡೆ ದೇರ್ ಇಸ್ ನೋ ಮಿಲೆಟ್ ಜುರಿಸ್ಡಿಕ್ಷನ್. ಅಲ್ಲಿ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಅಡ್ಜುಡಿಕೇಶನ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ.
ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಹೇಳಲಿಲ್ವಲ್ಲ.
ಅಲ್ಲ, ಅದು ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ ಅವ್ರದಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ.
ತೊಂದರೆ ಇಷ್ಟು ಸಾಕು. ಅಲೋ ಆಗೋದು ಒಂದು ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಆದ್ರೆ ಸಾಕು. Yes.
77, Suraj Balloli.
Allowed, the aforesaid reasons, the following order allowed, impugned so and so quashed. The amount of penalty that is collected by the petition, by the respondent from the hands of the petitioner shall be refunded within 4 weeks from the date of receipt of the copy of the order, failing which it shall carry a cost of rupees 50,000 apart from the refund of 50,000 that is to be made. Next.
77.
Please, Lords. Lords, the petitioner is seeking for compassionate
Relation
appointment.
disputed.
Disputed. I have received instructions. As on that day, he was working in the office with the engineers and going for line inspection. So there was no marriage at all. And there is no even marriage certificate.
Nomination in ಮಾಡಿಲ್ವಾ?
Nomination sister ಮಗಳನ್ನ ಅಂತ ಹೇಳಿ ಮಾಡ್ತಾರೆ. ಇವ್ರನ್ನ ಆಮೇಲೆ ಮದುವೆ ಆಗಿದ್ದಾರೆ ಅಂತಾರೆ. When the officers found out from the registry that he was not at all there in the marriage, he was working in the office.
ಆಯ್ತು, ಇದು ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ?
We have got instructions. A week accommodation will file.
Counsel for the respondent seeks 3 weeks time to file statement of objections. List the matter on 13th November. Objections, if any, by then. Yes, next.
Highly obliged.
78, Rajshekar Burji. Arvind Kulkarni.
Your Lordship.
But petitioner, my lord, who is working
Your
as
Lordship,
assistant.
I'm awaiting for instructions to file statement of objections, Your Lordship.
And what's the matter?
But a petitioner, my lord, who is working as an assistant professor, my lord, in the third respondent, my lord, cardiothoracic vascular surgery department. Now, my lord, the fifth respondent, my lord, who was working at the Gadag Institute of Medical Science, my lord, is transferred to the third respondent, KIMS, my lord, contrary to the transfer guidelines, my lord. And the transfer of the fifth respondent, my lord, is by virtue of a abolition of a post, my lord, in which the petitioner is working as a professor, my lord. Now, my lord, may I request, my lord, kindly see, my lord, annexure. ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಟ್ಟಿಲ್ಲ, ಅವರ objection ಆಗ್ತೀವಿ ಅಂತ ಹೇಳಿ ಟೈಮ್ ಕೇಳಿದ್ರು.
The order which is under challenge is dated 5/3/2024.
So
there is delay in approaching the court also. The interim order was not granted.
You are the beneficiary of the order.
No, I am for the institute.
Now, my lord, virtually, my lord, the abolition.
Respondent is not represented?
He has been served.
No.
Saruda? Yes, learned HCGP seeks 10 days time to file statement of objections. List the matter on 28th. In the event objections would not be filed by then, 28th October. In the event the objections would not be filed by the state by then, it shall be construed that there are no objections to be filed in the case at hand. The MLA recommendation alva
yes, madam, definitely.
objection ಸ್ವಲ್ಪ ಬರುತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಹಿಂಗ್ ಬರೀದೇ ಹೋದ್ರೆ objection ಬರಲ್ಲ.
Yes, Lord, may I request in the preliminary hearing?
Preliminary hearing, in preliminary hearing, yes.
79, Sanjana Smudho, Srinand Pachapura.
May it please, my lords, appearing on behalf of.
Regularization.
Regular.
Yes, madam.
Please, your lordship. As per the endorsement, your lordship, they have not completed the 10 years, your lordship, as on the date of cutoff date, your lordship, is 2006, your lordship. That is the endorsement is been given, your lordship.
ಇಲ್ಲಿ ಚಾರ್ಟ್ ಹಾಕಿದ್ರಲ್ಲ, where is that, Sanjana?
At page 5, my lords.
1797, 91. Is the dates of appointment correct?
Yes, my lords.
The petitioners, comma, 4 in number, are at the doors of this court seeking a direction, calling in question an endorsement dated 4/8/2022 by which the claim of these petitioners seeking regularization of their services has been turned down. The consequential direction to regularize the service of the petitioners after completion of the 10 years from the date of their initial appointment is sought. Heard the learned counsel Sanjana Mudhol appearing for the petitioner and the counsel Srinath Pachapare for the respondent and the learned HCGP for the state. Facts in brief germane are as follows. The petitioners were appointed as watermen on daily wage basis in the Gokak city, in the Gokak city municipal council against sanctioned vacant posts. This is an admitted fact. The particulars of appointment of the petitioners is as follows. The chart on the extract matter. The first petitioner is appointed on 1/7/1997, semicolon. The second on 1/11/91, semicolon. Third on 1/10/2004, and fourth on 1/10/2004. The petitioners have, as on today, completed 28 years of service. The first petitioner has completed 28 years. The second retire ಆಗಿದಾರಲ್ಲ? Second petitioner is retired?
No, my lords, they stay.
The second petitioner 34 years and petitioners 3 and 4 21 years respectively. The petitioner, you had approached this court earlier?
Yes, my lords. Annexure E is the.
Petitioners, a few of the petitioners were at the doors of this court seeking consideration of their cases for regularization in writ petition 100-103 of 2021, which comes to be disposed by an order dated 27th January 2021, directing consideration of the representation submitted by these petitioners for regularization of their services within 2 months from the date of receipt of the copy of the said order. The result of the direction is the impugned endorsement dated 12/9/2022, which declines to accept the claim of these petitioners for regularization of their services on the score that the claim runs counter to the judgment of the apex court in the case of State of Karnataka versus Umadevi, 2006 4 SCC, page 1. The learned counsel, it is this endorsement that has driven these petitioners to this court in the subject petition. The learned counsel.
One clarification, my lords. After the writ petition order, my lords, we have given a representation pursuant to which Annexure J is passed. Annexure J I have again challenged in writ petition number. Yes, my lords, page number 51. 51, my lords.
1 minute, madam.
In that we had not challenged Annexure K, my lords.
1 ನಿಮಿಷ. Endorsement 12/9/22 ಯಾವುದು madam?
That is Annexure K, my lords. 12/9 is, we had challenged Annexure J.
Which is this Ravi Hosmani order?
My lords, in that, there is a liberty given to challenge annexure K, my lords. That is at page 49. We had not challenged annexure K, we had challenged communication
Yes,
letter.
ಬರ್ಕೊಳ್ಳಿ. Last ಏನ್ ಹೇಳ್ದೆ? ಇಲ್ಲ, the said endorsement was not challenged while the petitioners again had approached this court and writ petition 100174 of 2023, in which the endorsement dated 12/9/2022 was not challenged. The coordinate bench of this court disposed the writ petition, reserving liberty to the petitioners to raise a challenge to the said endorsement.
I have also challenged annexure M in this matter, my lords, 59.
Said endorsement. The result of ಇನ್ನೊಂದು ಯಾವ್ದು madam?
Annexure M, my lords, page
ಈಗ
59.
latest endorsement.
Please, my lords.
Annexure M is the latest endorsement.
Yes, my lords.
That is 22.
The result of the, as an offshoot of the order passed by the coordinate bench in writ petition 100174 of 2023, comes the impugned endorsement dated 23/7/2024, rejecting the claim of the petitioners on the very same ground that the petitioners have not completed 10 years of service as on the date of the, as on the cutoff date as obtaining in the judgment of the apex
One
court.
more objection has been taken, your lordship. There, your lordship, in the year 2017, your lordship, the list of eligible candidates was issued, your lordship. For
Submission ಬಂದಾಗ ಬರ್ತೀನಿ madam. Don't so. Now don't disturb. Yes.
Sorry.
Judgment in the case of Uma Devi. It is the aforesaid endorsement that has driven these petitioners to this court in the subject petition. The learned counsel Sanjana Mudol, representing the petitioners, would vehemently contend that the petitioners have been in continuous employment as watermen in the fourth respondent municipal council without any break. It is more than 20 years each of these petitioners have been working. The two directions of consideration of their cases for regularization at the hands of this court have become no avail, for the reason that the state is now wanting to rely on the judgment of the apex court in the case of Uma Devi to deny the claim of the petitioners. The learned counsel submits that judgment in the judgment of the apex court in the case of Uma Devi is distinguished in subsequent judgments, which all bear consideration. Subsequent judgments. The learned HCGP would vehemently refute the submission to contend that as on the date of the rendering of the judgment of the apex court in the case of Uma Devi, the petitioners had not completed 10 years of service, and none of the petitioners had completed 10 years of service. Therefore, ಒಂದೇನಾಗಿತ್ತಲ್ಲ?
Please, my lord.
None of the petitioners had completed 10 years of service, and therefore the claim of these petitioners cannot be considered. The other submission is, in the year 2017, the list of eligible candidates for the purpose of regularization was already notified by the municipal council, in which the names of the petitioners were not found. No objections were filed by these petitioners, or their claim was never registered that they are entitled for regularization at the relevant point in time. And therefore, the learned counsel submits that this court should not entertain the plea of these petitioners seeking regularization at this juncture. The learned counsel Srinath Pachapure, appearing for the fourth respondent, submits that they have recommended the cases of these petitioners for regularization and communicated to the state on 12/1/2025. Correct, Adu?
No,
15/1/2025.
On 15/1/2025, and therefore submits that he has no further say in the matter, as it is the state which has to pass an order. I have given my anxious considerations on. Therefore, narrated facts are not in dispute. The dates on which the petitioners entered employment is charted here and above. The dates are again not in dispute. The issue is whether these petitioners would become entitled to consideration of their cases for regularization or otherwise. The petitioners were twice over before this court seeking consideration of their cases for regularization, which all come to be rejected. Which all come to be rejected by the impugned endorsements. The endorsement is that the petitioners had not completed 10 years of service as on the date of the rendering of the judgment of the apex court in the case of Uma Devi, which is on 10/4/2006, which is on 10/4/2006. The service of the petitioners 10/4/2006. It is germane to notice that in identical circumstances, this court, ಇದು municipality jana?
Yes, my lords, that is.
This court in writ petition 107774 of 2023 concerning a different municipal council had directed regularization of those petitioners by the following order. Para 12 in the end of haki. Notwithstanding the aforesaid direction, ಆಮೇಲೆ ಮಾಡಿರೋದ ಇದು ಇಲ್ಲ directed so and so. The endorsement of the impugned endorsement hinges upon the judgment of the apex court in the case of Uma Devi, which has stood distinguished by subsequent judgments of the apex court. The apex court in the case of ಇಲ್ಲಿಂದ ಬನ್ನಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಬೇಕು. ಪೇಜ್ ಏನು ಸಂಜನಾಥ್?
75 endorsement annexure J, K and M is what I'm questioning, my lords.
All three?
All three.
One moment. The endorsements which have from time to time been issued by the state, which are all challenged in the subject petition, read as follows. Pages?
Page 46 is annexure J, my lords.
Annexures
is
every
14.
matter. Which are the annexures?
J, K and M.
J, K and
M.
N. ಇದು ಮೂರು
M
extract ಮಾಡಿ.
for monkey, my lords. M.
Monkey,
M.
ಬೇರೆ ಏನು examples ಇರಲಿ. Yes. So and so. All these endorsements would run foul of what the apex court has held from time to time. The apex court in the aftermath of the judgment of in the case of Uma Devi has held as follows. ಇಲ್ಲಿಂದ para 14 ಇಂದ come to the end. ಇದು ಬೇಡ ಇಲ್ಲಿವರೆಗೆ.
Lords, yesterday I passed on another judgment of your lordships. I was also relying on that.
Yes. So and so. 49 up to ಇಲ್ಲಿಂದ para 12 ಇರಬೇಕು. ಅಲ್ಲಿಂದ page 40 para 19, 12 to 19. In the light of the judgments the apex court quoted supra, the petition deserves to succeed with a direction to the respondent to consider the case of these petitioners for regularization of the services from the date on which they completed 10 years from the date completed 10 years from the date of their initial appointment. It is further germane to notice the subsequent judgment of the apex. Where is it?
Please, my lords.
Where is the new judgment?
The one that your lordship was referring to.
After that? No homework. It is germane to notice the subsequent judgment of the apex court in the case of Dharam Singh versus so and so, reported in 2025 SSC Online SC page 1735, wherein the apex court has held as follows, para 18 to 20. The apex court holds that making the keeping the persons in continuous ad hoc employment would itself become arbitrary and violative of Article 14 of the Constitution of India. In that light, a direction would ensue to the respondents to consider the case of these petitioners to regularize their services. They regularize the service. For the aforesaid reasons, the following order allowed the endorsements, all three endorsements quashed. The state shall now consider the case of these petitioners for regularization of the services, bearing in mind the observations made in the course of the order with an outer limit of 12 weeks from the date of receipt of the copy of this order, if not earlier.
Yes.
Yes.
Grateful.
Connected ಏನಿದೆ?
Same, my lords. The petitioner in that matter, there's only one petitioner. He's the driver and the fourth respondent.
ಅದು same. Annexures, endorsement annexures.
My lords, I'll furnish, my lords. Very
ಎಲ್ಲ
good.
ಬರ್ಕೊಡಿ.
Please.
Endorsements ಬರ್ಕೊಡ್ತಾರೆ. Correct. Yes, next.
Number 80, Girish V. Bhatt, Sridhar Srinivasa.
My lord, we received the objection today. Kindly have it on tomorrow, my lord.
In charge allowance.
In charge.
7.5 or 15. ಎಷ್ಟು?
They are not entitled in terms of Rule 32 because for the post of director, my lord, 10 years of service is required.
ಏನ್ post sir?
Lord, post of director in Karnataka.
In charge of Kannada Regional KRI, Kannada Research Institute of the part of the university. I have filed the statement of objection. I am representing the university. I filed the statement of objection.
They are appointed, they are placed on independent charge or in charge?
In charge.
Under Rule 66 or 32?
32.
32 ಅಲ್ಲಿ in charge ಬರಲ್ಲ, only independent charge.
32 ಅಲ್ಲ.
If you are placed in the under 32, you have to give everything.
It is not been 32 ಅಂತ ಹೇಳಿ we have been clarified ಮಾಡಿದ್ದಾರೆ.
Order should speak, not your objections. Order ಏನಿದೆ?
Order ದಲ್ಲಿ the order which is
Order
been challenged
32 ಅಂತಿದ್ಯಾ 66 ಇದೆಯಾ?
66 ಇದೆ, 32 ಇಲ್ಲ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಯಾವುದು? Impugned order.
ಅವರು what is been challenged in writ petition 107412 sorry 105535 ದಲ್ಲಿ the order of impinge order what have challenged.
You have not seen?
No, my lord. Objection noted.
25 writ petition.
ಕೊಡಿಲ್ಲ. ಇವ್ರನ್ನ ಪ್ಲೇಸ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಇನ್ ಚಾರ್ಜ್ ಪ್ಲೇಸ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಇನ್ನೊಂದು writ petition, ನಿಮ್ಮ writ petition ಇದೆ. ನಿಮ್ಮ writ petition ಇದೆ. Order impinged order. Impinged order ತೆಗೆರಿ.
Okay.
ಇದೆ. Page number 26, my lords. In writ petition 105535.
105535.
105535.
ಯಾರು 66 ಅಂತ ಹೇಳಿದ್ದು? Page 27. ಚಾರ್ಜ್ ಅಲವೆನ್ಸ್ ಅಲ್ಲ, ಸ್ಯಾಲರಿ ಕೊಡ್ಬೇಕೀಗ. Not 15%. Whole salary applicable to the post. You have not placed them on in charge, it is independent charge. 32 ಗೂ 66 ಗೂ ವ್ಯತ್ಯಾಸ ಗೊತ್ತಿಲ್ವಾ? ಗೊತ್ತಿಲ್ವಾ?
My lords.
Open case here, sir. 66 is in charge, they will get charge allowance. 32 also they will get charge allowance, but it is independent charge.
Independent charge.
Independent charge is done only when they are fully entitled to hold the post. In charge ಯಾರು ಬೇಕಾರ್ ಮಾಡ್ಬೋದು. That's why they'll get more benefits than your charge allowance and other things. ನೀವು ಓದಿಲ್ಲ.
Objection noted.
Where is Girish?
Held up in another court, my lord.
40 ಕೋರ್ಟ್ ಇದೆ ಅಲ್ಲಿ.
ಪಾಸ್ ಔಟ್ ಮಾಡೋರು ಬರ್ತಾರೆ.
Yes. List the matter on 28th. Just look into it and come. Sridhar ಯಾರಿಗೆ?
For
ಯಾರಿಗೆ?
Karnataka University.
Who has placed them on independent charge? University?
Yes.
Rule 32 ಅಂತಿದೆ.
ಅಲ್ಲ 32 ಅಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ he was not eligible ಅಂತ ಬರೆದಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
32 ಪ್ಲೇಸ್ ಮಾಡಿಲ್ವಾ ಅವರು?
ಇಲ್ಲ, ಆದ್ರೆ in that order what I have referred in page number 27 they have mentioned that in order to place him on 32 he was not eligible on that date, that to hold that post the eligibility criteria was that he should hold 10 years in the teaching post ಅಂತ ಇದೆ.
ಅದಕ್ಕೆ ಇನ್ ಚಾರ್ಜ್ ಮಾಡಿದಾರ?
ಹಾ, ಇನ್ ಚಾರ್ಜ್. that is what 32 reference ಕೊಟ್ಟಿದ್ದಾರೆ, he is not eligible as per 32 ಅಂತ ಬರೆದಿದ್ದಾರೆ.
Then you are right. I am wrong. We will take it on 28th.
Much obvious.
Please ma'am.
By 81, my lords, one clarification with regard to the connected matter, my lords. This is the first time the petitioner has approached the court. There are no, yes, ma'am.
For the same reasons.
Yes.
ಅಲ್ಲೇನು separate order ಮಾಡಲ್ಲ. 80?
81.
Burial
my lords.
ground.
Please, it's a burial ground. The government has granted, but surveyor has to demarcate it because it is for a different
ಯಾವಾಗ
community.
ಮಾಡ್ತೀರಾ ಸರ್?
The reason is, in spite of the concerned officer went to the survey, since from the date of grant, the entire village using that land for agriculture purpose. And a separate
Burial
order
ground, how did you then grant it for burial ground?
that is granted, but it is not used by the village.
When
And
was the
but
grant?
the villagers are used for the.
2012, my lords, it is annexure B,
In the
page 12.
meanwhile,
Sorry,
Deputy Commissioner has passed an order granting another 2 acres of land wherein they are utilizing, the villagers are utilizing that land.
ಮಾಡ್ಲಿ ಬಿಡಿ, ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ದು?
ಈಗ one more submission. In the meanwhile, unauthorized cultivators are cultivating their land and they have filed Form 57 and seeking regularization. We have been obstructed by them. And now the present petitioners have approached the loci seeking that they are not demarking in spite of a grant order is passed against the authority. And notices have been issued to the Tahsildar and they have given explanation to the locaयुಕ್ತ.
Yes.
These
No,
are the
my lord.
subsequent development that has been taken place.
ಆಯ್ತು, ಅದೆಲ್ಲ ತೋಡಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಎಲ್ಲ ಇಲ್ಲೇ ಇದಾವೆ.
ಹಾಕ್ಲಿ.
Please.
Leonard, AGA on instruction should submit that there are plethora of subsequent developments that have taken place with regard to the claim of the petitioners, and all of which would be placed by way of objections or document or memo along with documents as the case would be.
Please.
29th.
Grateful.
Yes, next.
Seal number 82, MR Reimbursement.
My lord, I am for respondent, my lord.
My lord, yesterday I filed the wakalat in respect of respondent number 145, my lord. I placed short accommodation to file objection to the
Pending ಇದೆಯಾ?
petition.
My lord, 5 I am representing, my lord.
ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇಲ್ಲ sir, stay order ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲಲ್ಲ ಸರ್.
Yes.
Appeal is filed before the revenue authority.
Yes, sir. 2 objections are pending from there.
Revenue authority appeal pending ಇದೆ sir. That is different matter sir. ಇದೇನಂತ humble submission my lord. Compromise petition file ಮಾಡಿದಾರ. Compromise petition ದೊಳಗ petitioners ಅನ್ನ implement ಮಾಡಿಲ್ಲ.
ನೀವು ಯಾರು?
Sir,
Respondents.
Sir, third party, sir. They are not at all a part of compromise decree, sir. But they have taken the stay order.
No, what we have filed the writ petition to quash the
Compromise decree ನಿಮ್ಮನ್ನ compromise award ಏನಿದೆ?
compromise award sir.
ಅದ್ರಲ್ಲಿ ನೀವ್ ಇರ್ಬೇಕು ಅಂತ ಯಾಕಿದೆ?
Sir, humble submission sir. ನಮ್ party
ನೀವು humble submission ಬೇಡ. who are you ಹೇಳಿ first?
ನಮ್ ಪ್ರಾಪರ್ಟಿ ಅದ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಕೊಂಡ both are the brothers and brothers. ನಮ್ ಪ್ರಾಪರ್ಟಿ adjacent lands.
ಇದು yesterday's matter?
13th.
Day before yesterday.
Sunday.
adjacent lands sir. ಅದನ್ನ ನಮ್ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಕೊಂಡ
ಏನ್ ಬೇಕು ಹೇಳಿ?
ಸರ್ ನಂದ ಸರ್ ಅದ್ರೊಳಗೆ ನೆಕ್ಸ್ಟ್ ADLR ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಾರ. ಕಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನಮ್ಮನ್ನ. ADLR ದಾಗೂ ನಮ್ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡು ADLR ದಾಗ ಪಾರ್ಟಿ ಮಾಡಿದಾರೆ DDLR ಮುಂದೆ ಸರ್.
Sir, because they are their property is adjacent to them, sir. They have been given notice and they have made a party in the DDLR, sir. They are mentioning there is a boundary issue, my lord. But it has been resolved in the DDLR order, that is in a page number 61, my lord.
All right.
It is already solved, my lord. And presently they are in violation of the order of the High Court, my lord. That they are clearly in a previous writ petition, my lord. High Court has clearly mentioned that this boundary issue, if you want to challenge the Deputy Director of Land Record Order, my lord, you have to approach Karnataka Appellate Tribunal for second appeal.
ಮಾಡಿದಾರಾ ಅಂತ ಕೇಳಿದ್ ನಾನು.
Yes, my lord. It is already
pending ಇದೆಯಾ ಅಲ್ಲಿ?
No, sir. They have filed second appeal, my lord.
Yes, appeal pending is there in.
Unnecessarily they are taken
that appeal
stay
is
order.
Wait, sir.
Yeah, sorry.
My lord.
Appeal pending ಇದೆಯಾ?
Appeal pending ಇದೆ. That appeal is pertain to challenging the DDLR order, not the compromise petition. Compromise petition is before the Lok Adalat. Lok Adalat. So
List the matter
this
on 30th. Yes. Next.
My lord,
Recreation.
my lord, kindly extend the interim order.
Interim order. Recreation.
Recreation, no, but there is a small fact which has to be brought into notice, my lord. I have the benefit of the order, but still, my lord, they are not allowing me to open the premises. That's the reason, my lord, this honorable court last time had directed them to file an inspection report. Now, what they do is, my lord, they come, these photos were seen by the court, my lord. They come to the premises, then DVR ಏನಿದೆ ಅದನ್ನ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ, and they are not allowing me to open. By great difficulty, my lord, I have taken these photographs.
Yes, sir. ಏನ್ lawlessness ತುಂಬಾ ಇದೆ.
Entire Uttar Kannada, my lord, facing this problem. All petitions are queued up before my lord.
Yes.
Lord, insofar as the allegation.
Police Raj.
Insofar as the
Kindly
contention.
look at my prayer, my lord. I have asked for the direction not to remove the CCTV DVRs, my lord.
Why do you take away the DVRs? Any evidence irbardu anta?
For obvious reasons.
Insofar as the inspection report is concerned, my lord, I will be.
Henceforth, I will pass an order
Yes.
that whenever you touch the CCTV of a place that you inspect, you have to drop why you are taking the CCTV and everything. Otherwise, ನಿಮ್ಗೆ ಏನ್ ಇಲ್ವೇ ಇಲ್ಲ. ಏನ್ ಬೇಕಾದ್ ಮಾಡ್ತಾ ಇದೀರಾ ಪೊಲೀಸ್ನವರಲ್ಲಿ.
The direction, my lord, it may be disposed, my lord.
Well, that can be done. Well, I will instruct the concerned.
The first covered ಅಂತ ಮಾಡ್ಬೇಡ.
Covered, but
Additional that condition shall be imposed.
Page, ಯಾವ page ಅದು?
My lord, it is at
The petitioner is before this court ಅಂತೆಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು.
page 7.
Page 7 annexure.
Page 7 ನಲ್ಲಿ judgment covered ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. The learned counsel appearing for the petitioner submits that the police, whenever they conduct inspection of any premises, recreation club or otherwise, would at the outset disconnect the CCTV and take away the DVR. And then
close the premises like this.
and close the premises. The learned counsel would submit that this is the problem that every recreation club is facing from the hands of the police in the area.
Uttar Kannada.
In that light, it becomes necessary to direct the, it becomes necessary to observe that whenever the police would want to disconnect the CCTV or take away the DVR from any place of inspection, they shall drop an inventory of such inspection and as to record the reasons as to why the CCTV or the DVR would become necessary for their investigation, if any. Failing which, the petitions before this court are mushrooming on the allegation that the police inspect and take away everything and seal the premises.
Please.
And my lord, I may be permitted to open, my lord. They are not, by this force, my lord, they are closing it down.
For the other lane ಇದೆ, operative portion of those orders same ಮಾಡಿ. Open ಮಾಡ್ತಾರೆ.
Open ಮಾಡ್ಲಿಕ್ಕೆ they are closing it
ಏನ್
like
ಕಾರ್ಡ್ಸ್ ಆಡ್ತೀರಾ ಅಲ್ಲಿ?
ಎಲ್ಲದೂ ಇದೆ, ಕೇರಂ ಇದೆ.
ಮತ್ತೆ ಇರಿ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ಅದನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಆಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ.
ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಬಂದೇ ಬರುತ್ತೆ, ಆ ಆರ್ಡರ್ ಎಲ್ಲ ಹಂಗೆ ಇದೆ. ಎಸ್
ಪ್ಲೀಸ್.
ನೆಕ್ಸ್ಟ್ both petitions.
The matter is arising out of GST, my lord. This petition annexure challenge is annexure C, my lord. Page number 18.
What's the challenge?
This assessment order, my lord, relevant is page number 20, my lord. It's squarely covered by the High Court judgment, my lord. From the top, second paragraph, first tab. Issue is
ITC,
excess claim of ITC. No,
Interest
under
on
the
delayed
wrong head, my lord. This is squarely covered by the annexure E, my lord.
ಗೊತ್ತಾಯ್ತು.
Instead of IGST, ಇದು CGST, KGST ತಗೋಬೇಕಾಗಿತ್ತು. IGST ಅಲ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡಿದ್ದಕ್ಕೆ ಇದು ಡಿಮಾಂಡ್ ಬಂತು.
Close this.
Your lordship, the interest has been demanded on the delayed payment, your lordship. And there is no provision to waive the interest, your lordship.
ಪೆಟಿಷನ್ ಕಾಪಿ ನಿಮಗೆ ಕೊಟ್ಟಿವಿ. ನೀವು ಬೇರೆ ಪೆಟಿಷನ್ ದಾಗ 128A ಅಲ್ಲ.
ಎಲ್ಲೋದ್ರಿ?
It's not been, ನನಗೆ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ನ ಅದನ್ನ ಮಾಡಾತೇನ್ರಿ.
ಇದಲ್ಲ.
List on that. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಪೆಟಿಷನರ್?
ನಾ ಪೆಟಿಷನರ್ ಮಲ್ಲ.
ಬನ್ನಿ.
ಅಲ್ಲ.
Whatever the copy has been given, your lordship, I am arguing ಇಲ್ಲ.
ಅಲ್ಲ ಅದು ಇಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ
ಗೊತ್ತದ್ರೊಳಗೆ ಇಲ್ವೇ ಇಲ್ಲ.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಅಕೇಜನ್ ಹಂಗಾಗಿತ್ತು, ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಮತ್ತೆ ಇಲ್ಲ.
List on 31st October.
Please, my lord.
ಕೊಟ್ಟಿಲ್ಲ.
85, Gayatri sir. Niyaz denied.
Appear for the petition alerts.
85.
Day before yesterday's matter alerts, sir.
Go back to Andhra. ಅದೇ ತರ. Yes. You will go back?
We are the.
ಅಲ್ಲ, you are the beneficiary. Yes. Srinivas Nayak, correct.
I'm the respondent number 1.
Yes, sir.
Lord, in connected matter, I have challenged the impugned order dated 70, passed by the assistant.
ಈಗ first one by one we'll finish it. First Gayatri madam ಹೇಳಿ.
Yes, madam. The petitioners herein have challenged the.
You are
We are the in-laws, my lords. Respondent number 1, he is the daughter-in-law of the
One minute,
petitioners
one
here. Yes.
The petitioners are before this court calling in question the proceedings in criminal miscellaneous 227 of 2025 registered invoking the provisions of the Domestic Violence Act 2005. Heard so and so. The petitioners in allot madida mane.
Yes, it was allotted in the year 1972. One more property was purchased in the year
The
2006.
petitioners are the absolute owners of the subject properties. They are alleging certain harassment ಅಂತ ಹೋಗಿದ್ದ ಹೆಂಗ್ ಏನಂತ ಹೋಗಿದ್ದೆ?
ಅಲ್ಲ ಅವರು ಏನಂತಾರೆ 20, she was there till 2024 in the Andhra Pradesh. She
ಅದು
alleges
ಗೊತ್ತು
that.
ಮೇಡಮ್. ಈಗ ನೀವು
ಅಲ್ಲ,
ಬಿಫೋರ್
she
ದಿ
alleges that
ಅಸಿಸ್ಟೆಂಟ್
we were
ಕಮಿಷನರ್ ಹೋಗಿದ್ದು ಯಾಕೆ?
Please, minutes.
ಬಿಫೋರ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹೋಗಿದ್ದೆ.
Let's, because she acquired our property thrown out of the petitioners. That is why we approached the commissioner seeking the possession of the property, minutes. And the eviction order is passed in the connected.
We'll dispose it. Take it as disposed.
Let's one more submission. Yes, let's one more submission. The suit is also pending. Your lordship may.
ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಎಲ್ಲ ಇದರಲ್ಲೇ ತಗೊಂಡ್ಬಿಟ್ರೆ.
Yes. Eviction order, that whatever I challenge, my lord, that has to be eviction.
First petition is allowed. ಯಾವುದು? Domestic violence proceedings against these two petitioners goes. ಆಮೇಲೆ
Second petition pertains to Senior Citizen Act.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು? ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡೋದು?
The daughter-in-law has challenged
Challenge.
The Assistant Commissioner.
eviction order.
Because I have been ordered to vacate the premises, my lord.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
My lord,
You are
but-
the daughter-in-law ಅಲ್ವಾ?
Yes, minutes.
You are residing in Andhra Pradesh.
Till 2024, she was residing.
Yes. That also goes.
That
Petition dismissed.
because there is a judgment, my lord.
What is it?
In which the eviction order passed by the Assistant Commissioner has been set aside by the High Court, set aside by the Supreme Court, my lord.
I will see, we'll consider this. ಇದನ್ನ ಡಿಲಿಂಕ್ ಮಾಡಿ ಅದನ್ನ ನಾಳೆಗೆ ಹಾಕಿ.
Let's, there is one more judgment by the apex court wherein it has held that Mulot's assistant commissioner is authorized to pass an eviction order. And also Mulot's, this honorable court has also held that Mulot's, that similar order can be passed.
ಕೊಡಿ.
Yes.
ಎಲ್ಲ ಕೊಡಿ ನಾಳೆಗೆ ಹಾಕಿ. ಒಂದು ಮಾತ್ರ ಡಿಸ್ಪೋಸ್. ಯಾವುದು? 107073 allowed.
In fact, Mulot's, in the judgment I have submitted, it was not a residential
ಕೊಡಿ.
property, it was
ಈಗ
a.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದ judgment.
What Supreme Court holds is that, Mulot's,
We'll see.
yes. Let's, instead of tomorrow, may I request a day after tomorrow?
Friday.
Great.
List on Friday.
Great.
Cell number 86, Kushal MK.
My lords, may I request this matter on Friday, my lords? I'm receiving the documents today. I was directed to produce the notification and the award of the land acquisition proceedings. I'm receiving the documents today, my lords.
Friday?
Friday, my lords.
List on Friday at the request of the council appearing for the petition. Next.
Much obliged.
87, AB Patil,
Appearing for petition.
MD Kandi.
I have filed an application for vacating stay also, which was.
Correct. MSME 25% 100%?
25%.
ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ.
Please.
There's no 100%, minimum 25%.
ಮ್ಯಾಕ್ಸಿಮಮ್ ಏನಿಲ್ವಾ?
ಏನಿಲ್ಲ.
ಮತ್ತೆ ಯು ವಿಲ್ ಕಿಲ್ ಕಾಂಪಿಟೇಷನ್ ಎಲ್ಲ MSME ಗೆ ಕೊಟ್ಬಿಟ್ರೆ.
That is
Then that is
government decision.
Where is the government sitting silent?
Section 11 ಪ್ರಕಾರ.
Yes, sir. State is not a party.
My central government is a party, first
ಅದೇನು?
respond. My lord, objection for vacating.
Government is a party. ASG ಅವ್ರ ಪಾರ್ಟಿ
ASG ಬರ್ಬೇಕಾ?
ಅಲ್ಲ, ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡಿದಾರ, ಸ್ಟೇಟಿನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಸ್ಟೇಟ್ ಅಲ್ವಾ ಇದು? Union of India.
Please, there's the annexure C as per the regulation issued by the central
ನೀವ್
government.
ಯಾರಿಗೆ?
I am for the bank. Respondent 3. More than 51 banks, branches, they are no
suffering.
security, they are suffering because
What to do? If the Union of India has done something like that, you are the
As per
one
annexure
person
C.
now security is the biggest problem because they are
to-
security.
Correct, right? I'm not saying I will adjourn it. Who appears ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ. MB Kanviya, where is he? Pass over, let Kanvi come.
Next week.
Yes.
ಯಾಕೆ sir?
My lord,
No, next week, ಕೊಡಿ.
object, permitted to file.
Give it. Learned counsel for the petitioner files objections to the application seeking vacation of the interim order. His name is taken on record. Pass over.
Please.
Kanvi ಅವರು ಬರಕ್ ಹೇಳಿ. Ask Kanvi to come.
Please.
So I pay for the petition. Studies, madam, that delegation form, suppression in the delegation form.
Yes, yes.
But the learned friend himself is filing statement. I have the copy of the disqualification of order your lordship wanted me to produce. The learned friend himself has produced it along with the statement of objection.
Respond number 6 on
All
behalf
right,
of statement of objection.
Page 5, minutes, the order of disqualification, page 5, operative position is at the bottom.
3 ವರ್ಷ ಸದರಿ ಸಂಘದಲ್ಲಿ ಆಡಳಿತ ಸದಸ್ಯರಾಗಿ ಮುಂದುವರೆ ಅದ್ಯಾವ ಜಡ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ, ಒನ್ಸ್ ಟರ್ಮ್ ಇಸ್ ಓವರ್ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಗೋಸ್ ಅಂತ.
Page number 11, my lord, annexure R5.
Even if the order says you will not be able to contest in future elections also. ಹಂಗಿದ್ರು ಹೋಗ್ಬಿಡುತ್ತಾ?
Alarm. That proceeding itself goes, my lord. That proceeding because of the conclusion of the term, and moreover there is an interim order of stay operating, and after
Stay
that.
ಬಿಟ್ಬಿಡಿ. Stay I will said I will interpret, not a problem. You are saying that this judgment holds that when the period is over it goes.
Yes.
But what about the order that is passed now?
My lord, as far as
Disqualification order ಇಲ್ಲೇ ಇದೆಯಲ್ಲ? Yes, ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಅದು ಲಾಸ್ಟ್ ಓದಿ ಅದು.
Yes.
ಮುಂದಿನ 3 ವರ್ಷಗಳಿಗೆ ಸದರಿ ಸಂಘದಲ್ಲಿ ಮತ್ತು
ಸಂಘದಲ್ಲಿ
ಇತರೆ
ಮತ್ತು
ಯಾವುದೇ
ಇತರೆ ಯಾವುದೇ
ಸಹಕಾರ ಸಂಘಗಳ ಆಡಳಿತ ಮಂಡಳಿ
ಸದಸ್ಯರಾಗಿ ಮುಂದುವರಿಯಲು
ಮುಂದುವರಿಸಲು.
ಹಾಗೂ ಆಡಳಿತ ಮಂಡಳಿಯ ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಲು ಆರಿಸಿ ಬರಲು ಅನರ್ಹರನ್ನಾಗಿ ಘೋಷಿಸಲಾಗಿದೆ.
the operation of that order is stayed. my lord.
ಅಷ್ಟೇ ತಾನೆ ನಿಮ್ ಗ್ರೌಂಡ್
That is-
ಆಪರೇಷನ್ ಆಫ್ ದಿ ಆರ್ಡರ್. ಡೋಂಟ್ ಟೆಲ್ ದಟ್ ಇಟ್ ಗೋಸ್ ಆಫ್.
ಅಲ್ಲ ಅಂದ್ರೆ in view of this judgment, that disqualification proceeding will only be operative for that term only. When the term expires, that disqualification proceeding cannot be continued with.
Not this kind of an order which says you will be debarred from contesting for the next 3 years in any society.
My lord, his contention, my lord, is that I should have disclosed it in column number 3. In column number
You have
3.
not disclosed it.
We have not disclosed it for the reason that term has expired.
ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ತೀರಾ?
On December 2024, a fresh term has come.
ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ? ಬಿಡಿ. ಚಾಲೆಂಜ್ ಯಾಕೆ ಮಾಡ್ತೀರಾ? Why have you challenged it?
ಅಲ್ಲ ಅವನ ಮೊದಲೇ
Challenge it.
ಅಲ್ಲ ಮೊದಲೇ ಮಾಡಿದ್ರು.
If that is ಆಯ್ತು ಮೊದಲೇ ಮಾಡಿದ್ರೆ ಅದು ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆ ಅಂತ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಮತ್ತೆ
Withdraw ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Oh, you can't have both, sir.
My lord, after that, my lord, I have contested the election. I am re-elected, my lord, because of the stay order, my lord.
Because of the stay order. Because that is subject to the result. Yes, sir.
Lord, sir, it is thereafter no delegation form which is issued. This is prescribed by the State Cooperative Election Commission, which mandates disclosure.
ಅಲ್ಲ mandates disclosure ಆಯ್ತು ಈಗ ಸ್ಟೇ ಇದೆ ಅನ್ಬಿಟ್ಟು ಮಾಡಿಲ್ಲ ಅವರು.
ಮಾಡಿಲ್ಲ, but if you lordship see the impugnant,
ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಾರಂತಲ್ಲ ಆಮೇಲೆ.
contesting is for the primary society. The issue is with regard to now the contest to the millets, the federal society, that is KDCC bank.
Is anything else?
Lord, my only submission, my lord, is it is his allegation that I should have disclosed the disqualification order and stay order in column number 3 of the delegation form. My humble submission is neither the Karnataka Cooperative Societies Act nor rules mandate that such a disclosure is to be made in the delegation form, my lord.
Disclosure, you'll be disqualified even to contest if you have suffered disqualification.
If that is the case, my lord, then what is the meaning of interim stay, my lord, in appeal?
That meaning I will give you now. No problem. Don't worry about that. That is the court's job, the court will give. What is the meaning of interim stay?
Lord, but his allegation, his writ petition is structured on the ground that I should have disclosed it in column number 3.
Correct. That is,
And the reason given
that
is,
is appropriately structured.
Lord, in annexure R4,
ಯಾವ್ದು ನೀವು ಇದು ಹೇಳಿದಲ್ಲ? Which rule is that? He cannot contest. He can, if he is disqualified.
28C will suffers will, yes.
ಅಷ್ಟೇನಾ?
yes, annexure R4, we have given explanation wherein we have stated that the reason why it is not disclosed is because for this term, no, there is no disqualification as far as delegate is concerned. That was for the previous term. That is why it is not disclosed.
Yes, what do you say with that?
That takes care, if your also sees 18A, if it is section 20 and 18A are read, if he has already suffered a disqualification, he ceases to have a right to vote. 28C has to be read while considering section 20. His manner of voting.
The petitioner is before this court. Objection ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, ಅದು objections ಅವ್ರು ಕೊಟ್ಟಿರೋದು.
ಈಗ ಕೊಟ್ರಲ್ಲ?
ಹೌದು.
Statement of objection filed today.
The separate ಬರ್ಕೊಳ್ಳಿ. Learned counsel appearing for the, which respondent is this? Respondent
number
number 6 files a statement of objections. The same is taken on record. The petitioner is before this court calling in question an endorsement dated 4/10/2025 by which the order endorsement by which the objection of the petitioner to hold that the sixth respondent is ineligible to contest
Contest and vote in the election.
to contest and vote in the ensuing elections. Heard so and so. Facts in brief germane are as follows. On notices being, hello, one ನಿಮಿಷ. The elections in the case at hand is to the KDCC Bank. The KDCC Bank publishes a provisional voters list relating to Siddhapur Taluk in terms of section 13D within bracket 3 of the Karnataka Cooperative Rules 1960. In the said list, it was notified that there are 23 eligible voters. In terms of it is the averment of the petitioner that in terms of Rule 13D3B of the Karnataka Cooperative Rules, the objection so filed. It is the averment in the petition that the objections were filed by these petitioners before the election officer, raising the objection with regard to the suppression of the sixth respondent of suffering disqualification and mentioning in the column that he has not suffered any disqualification. This itself would debar the sixth respondent from either contesting or voting in the ensuing elections. On this, the petition is structured on the said premise. The petitioner on the said premise submits the said representation, which comes to be rejected by the impugned endorsement at 4/10/2025. It is this that has driven the petitioner to this court in the subject petition. The learned counsel Mallikarjun Swamy Hirimat submits that in terms of section 28C,
Yes.
28C of the section rule. Section 28C of the Act, a person who suffered disqualification would not be entitled to vote or contest in the ensuing elections. In terms of the order of disqualification, and the learned counsel submits that while submitting an application for what is it?
To cast vote and contest in the election.
While submitting an application to cast his vote or contest in the election, the column which depicts that whether the sixth respondent has suffered any disqualification, it is indicated that he has not. It is learned counsel submits that this is the suppression by the sixth respondent. The learned counsel appearing for the sixth respondent would vehemently refute the submission, contending that the disqualification suffered was for an earlier term. Once the term is over, the disqualification also gets over, and would seek to place reliance upon the judgment rendered by the coordinate bench. The learned counsel would further contend, that the disqualification that the petitioner, that the sixth respondent has suffered, has been challenged before
DRCS.
Deputy Registrar.
has been challenged before the district registrar of cooperative societies, and there is an interim, deputy registrar of cooperative societies, and there is an interim order of stay operating of the said disqualification. Therefore, on the strength of the stay, the petitioner has submitted, the sixth respondent has submitted the application seeking to contest, seeking to vote and contest. He would submit that the petition be dismissed as the action of the sixth respondent is in tune with law. The learned AGA also would toe the lines of the learned counsel appearing for the sixth respondent. I have given my anxious consideration to submissions made by the respective learned counsel. The issue in the list revolves around certain statutory provisions, the Act and the rules. Section 28C of the Act reads as follows. In terms of Section 28C.
29C.
29C.
I'm sorry, 29. My apology.
In terms of Section 29C, a person who suffers disqualification, Section 29C reads as follows. The Section 29C mandates that no person would be eligible for being elected or appointed or continue as a member of the board if he is 29C alla?
CH will.
29CH. ಎಲ್ಲಿದೆ ಸ್ವಾಮಿ ಅದು? He is no person who has suffered, no person shall be eligible to be elected or appointed or continued as a member of the board if he is disqualified to be a member of the society or to vote as such member. In the teeth of the said, it is an admitted fact that the sixth respondent has suffered disqualification. The order of disqualification reads as follows. Page 5 here. The order which disqualifies the sixth respondent disqualifies him for a period of 3 years for contesting, voting.
Yes, contest. Disqualification is for
contesting, only contesting.
Contest means
voting also.
Voting.
The disqualification, the petitioner suffers disqualification for a period of 3 years. The said order of disqualification is challenged before the Deputy Registrar of Cooperative Societies in appeal.
Page 8,
in which the DRCS has granted an interim order which reads as follows. Page 7. ಎರಡಿದೆಯಾ?
ಅಂದ್ರೆ ಮುಂಚೆ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತು because it was passed by an in-charge officer.
Page 9 ಹಾಕಿ ಸಾಕು, 7 ಬೇಡ. Therefore, the order of disqualification has stayed as on date. The said proceeding is said to be pending before the DRCS. The learned counsel for the respondent would submit that in the teeth of the interim order of stay that is granted, the disqualification would not become an impediment even to contest. The issue now is whether there is disclosure of disqualification or otherwise. The application of the sixth respondent is as follows. Annexure A.
No, Miller, it is my application. They are not producing their application because there is a
application ಏನಕ್ಕೆ ಹಾಕಿದೆ ಇದು?
ನಂದು the form of delegation form ಹೆಂಗಿರುತ್ತೆ ಅಂತ ತೋರಿಸಲಿಕ್ಕೆ petitioner ಹಾಕಿದೆ.
ಓ ಇದು ನಿಮ್ದ ಇದು?
ನಮ್ದು ಆ ಕಾಲಮ್ ಅವರು ಏನು
the format of the application that is to be filed is as follows. Clause 3 of the said application in its general form indicates whether the person who is wanting to contest or cast his vote has suffered any disqualification or otherwise. In the said column, it is an admitted fact that the said column, in the said column, the sixth respondent has not indicated that he has suffered any disqualification. and therefore has submitted his application to contest the ensuing elections, all on the strength of an interim order of stay that is granted by the DRCS. It is trite law that grant of an interim order of stay will not obliterate the order. The interim order would only eclipse the order and not extinguish it. Therefore, on the strength of the interim order, the order of disqualification, on the strength of the interim order, unless there is final adjudication of the matter, the interim order would not inure to the benefit of the petitioner, benefit of the sixth respondent to contest, as the disqualification that is suffered is for a period of 3 years of this election or the ensuing elections. In that light, the application of the petitioner seeking to contest or to vote in the ensuing elections is contrary to law. Again, ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ.
Now they have been included in the final voter list.
Now election
Yes, well
process
done.
has begun. Respondent number 6 has also filed nomination. So my humble submission, another contention, Lord, is all these correctness or validity of the provisional list or final list is also now published. Is a subject matter of election petition.
That's one problem.
Now, post filing of the writ petition, that is done. If the endorsement which is issued is quashed, he stands as it was, as on the date of provisional list.
Endorsement quashed ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ? ಏನಾಗಲ್ಲ.
And if endorsement is quashed and if it is held that he is ineligible.
No, that reasons have been indicated already. Yes. So in the light of the aforesaid reasons, order dated 4/10, the endorsement dated 4/10/2025 stands obliterated, and all consequential action that is to be taken, all consequential action pursuant to the quashment of the endorsement dated 4/10/2025 shall ensue.
Please.
Yes.
Request, Lord. Hand delivery of the
Final order.
operative
Nale.
portion.
Tomorrow.
Because
Appeal.
because 19th is the scrutiny. That's why 19th scrutiny ಇದೆ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ. ಅದು ಮಾಡಿ ರೆಡಿ ಮಾಡ್ಬಿಡಿ.
State may directly take notes. State may directly take notes.
So 1, 2, 3 government.
1, 2,
4
3,
Vishwanath
1, 2, 3
Hegde.
state, yes.
4th Vishwanath Hegde, 5 and 6 my learned friend takes.
See, 5 and 6 your Hegde ಅವರು. Vishwanath Hegde for
R4
R4, 1, 2, 3 state.
I'm only for 6.
6 ಮಾತ್ರ.
Well, society. That society is representing.
Delegating ನಾನು ಅಪೇರ್ ಆಗಿದ್ದೆ, ವಕಾಲತ್ತಿಲ್ಲ.
ಮತ್ತೆಲ್ಲ.
Directed to take notice ಮಾಡು. Okay, we'll.
5 and 6, yes. ಇವತ್ತೇ ರೆಡಿ ಮಾಡ್ಬಿಡಿ. ಇವತ್ತೇ ರೆಡಿ. 90?
89, my lord, 89. On the last occasion, the lordship has ascertained whether notices were issued prior to passing of the amount. Lord, in this case, there was a guidelines have been issued by the state, wherever such type of lines have, the beneficiary has to notify the farmer, and thereafter compensation has to be determined by the deputy commissioner.
Beneficiary here.
Let's hear.
Lord, may I pass on the guide?
Let's hear. What has happened? So far as lines are concerned, lines are not yet fixed. What we do is we prepare a rough sketch and give it to the ADLR. Accordingly, we have submitted our application to ADLR. Who gives us a proper survey number. Thereafter, we deposit amount. So far as compensation is concerned, pair number 2, we give an undertaking to the effect that whatever would be committed by the deputy commissioner, we are ready to pay. So far as
ಕ್ವಾಂಟಿಫೈ ಮಾಡಿಲ್ಲ.
Enhancement ಅಂದ್ರೆ ಇಲ್ಲಿ ಬರಲ್ಲ.
ಅಲ್ಲ ಕ್ವಾಂಟಿಫೈ ಮಾಡಿಲ್ಲ.
Quantify ಮಾಡಿದ್ದೇವೆ.
ಇಲ್ಲ, ಅದು ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ರಾಪರ್ಟಿ ರೀ. I am relying on annexure L to show that in respect of agriculture property, the deputy commissioner has quantified. It is a non-agriculture property since
Where is the
2012.
quantification for NA?
Not so far as NA is concerned, what I am told is that so far as present geo is concerned, in fact, the assessment itself is based on the NA potentiality. Ma'am, for a moment, pass
The
on.
converted land, NA potential land.
Yes, Lord. NA potential, mining lease has been executed.
These lands.
Mining lease execute again.
Yes.
Yes, sir.
So far as first petition is concerned, it is only the corridor area which would be passing through his land. We should almost support the first line would be 72 meters. The base line would be 30 meters.
No, not on that.
Please.
The
For
land,
millards, any
what determination the deputy commissioner has done is concerning agricultural lands. That is an admitted fact.
Please, millards, that is not as per my information. For millards, even that compensation millards is assessed, millards based on millards any potential itself. Millards, millards, though millards.
Where are the records?
Millards, records millards, order the millards, it is specifically.
Page 124 is the order passed by
Land
the.
ಅತ್ತೆ ಮಾಡಿದ್ದಾರೆ.
Agriculture land.
ಅಲ್ಲಿದೆ ನೋಡಿ, ಕೃಷಿ ಭೂಮಿ ಅತ್ತೆ ಇದೆ ಅದರಲ್ಲಿ.
ಮತ್ತೆ ಕೃಷಿ ಭೂಮಿ ಅಲ್ವಲ್ಲ ಇವ್ರದ್ದು.
Millards, for that.
It was converted in year 2012, Miller.
Any millards compensation, prayer number 2 millards, I am ready to millards deposit any amount millards as. would
But
be
even
millards
though, my
committed.
lord, assessment is made for 2,600 per square meter. For agricultural land, it is not. Since not taking note of the fact that it is an non-agriculture.
Correct ಆಗಿ ಬರೆಯಕ್ಕೆ ಏನು ತೊಂದರೆ?
ಅಲ್ಲ, ಅದು ಚದರ ಮೀಟರ್ಗೆ ಅಂತಾನೆ ಬರ್ತಾರೆ 2000.
ಅಲ್ಲ, ಅದೇನಿರಲಿ, ವಾಟ್ ಇಸ್ ದಿ ಡಿಟರ್ಮಿನೇಷನ್ ಇರ್ಬೇಕಲ್ಲ, ಸುಮ್ಮನೆ ನಿಮ್ ವಿಮೆಂಟ್ ಫ್ಯಾನ್ಸಿ ಅಲ್ಲ.
Page 123, Miller.
What is all this?
Page 123 ಅಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಎಲ್ಲಾ ಅಂಶ ಪರಿಗಣಿಸಿಕೊಂಡು ವಿದ್ಯುತ್ ಪ್ರಸರಣ ಮಾರ್ಗದ ಕೃಷಿ ಜಮೀನುಗಳಲ್ಲಿ ಸ್ಥಾಪಿಸಿದ ವಿವಿಧ ಮಾದರಿ ಗೋಪುರ ಅಡಿಪಾಯಗಳಿಗೆ ಪ್ರತಿ ಚದರ ಮೀಟರ್ 2,600 ಅಂತ ಪರಿಹಾರದಿಂದ ನಿಗದಿಪಡಿಸಿದೆ.
Agriculture land.
ಅಲ್ಲ, agriculture land, but the quantification is.
ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಗೆ ಎಷ್ಟು?
ಪರ್ ಎಕರ್ ಅಂತ ತಗೊಂತಾರಲ್ಲ, ಎಕರ್.
ಇಲ್ಲಿ ಎಷ್ಟು ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಚದರ ಮೀಟರ್ಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
Square meters.
Square meters.
ಸ್ಕ್ವೇರ್ ಮೀಟರ್ ಅಂತಾನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
For that.
Only a user right millards, may I pass on millards, the latest GO millards for a moment. Millards, any compensation committed not subject to millards, what DC says, may I take millards to page 2.
ಅಲ್ಲ, that is the same document which has.
We'll direct the DC to reconsider it. That's all.
Yes, please.
Now notiದ್ರೆ millards, column number 3, determination of compensation. No.
The same thing which I have just now.
The compensation shall be based on the guidelines for the land, prevailing guidelines of non-agricultural land of
ಆಯ್ತು,
residential nature.
let the DC appropriately reconsider it and pass out. And whatever compensation it determines,
We
you
are
are
ready,
bound to
Mr.
pay.
Yes.
The petitioner,
So far as second petition is concerned, I am told that millards, neither millards a base millards, no millards lines should be millards passing through millards the second petition.
first is ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
First,
Second petition ಆವಾಗ. The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner claims to be the absolute owner in possession of the properties as appended to the schedule. The petitioner enters into a quarrying, the petitioner applies and is granted quarrying lease permitting the petitioner to commence quarrying business for a period of 50 years and 30 years respectively on 2/7/2016 and 1/10/2020. On the strength of the said lease, the learned counsel for the petitioner submits that the land of the petitioners is a non-agricultural land converted way back in the year 2012. The issue in the list is not with regard to the quarrying lease of the petitioner. The issue is with regard to drawing up of the power grid in the land of the petitioner in terms of the Electricity Act 2003. The deputy commissioner, who is authorized to hear the objections of the aggrieved, in whose lands are aggrieved, whose lands are being utilized for the purpose of drawing of power lines or establishment of power grid, as the case would be. The deputy commissioner has drawn up proceedings and determined certain compensation. The order of the deputy commissioner reads as follows. Page 122 and 123. The order indicates that the land of the petitioner is agriculture, and the compensation is determined taking note of the fact that the land is an agricultural land. The learned counsel appearing for the respondent state and Neelendra Gunde would dispute the position on the ground that if it were to be an agricultural land, the compensation would be assessed on acreage, and the compensation now is assessed by square meters. Though the submission would merit acceptance, the order of the deputy commissioner is on the premise that it is an agricultural land. Therefore, the deputy commissioner will have to now redo the exercise of determining the compensation, noticing the nature of the land of the petitioner, which according to the petitioner stood converted way back in the year 2012. For on the sole score that the order suffers from non-application of mind as to whether the land of the petitioner is agriculture or otherwise, the matter is to be remitted back to the hands of the deputy commissioner to redo the exercise of determination of compensation of the lands of the petitioner on appropriate consideration as to whether it is an agricultural land or non-agricultural land or non-agricultural land / converted land, and determine compensation accordingly. For the aforesaid reason, the following order. The petition is allowed in part. The order dated 29/6/2024 stands quashed.
No, that is not challenge. They are only seeking writ of mandamus.
The petition stands allowed. Mandamus issues to the deputy commissioner to redo the deputy commissioner to reconsider, to consider the representation. Consider the representation of the petitioner and draw up the appropriate compensation with regard to the nature of the land of the petitioner. The question nature of the land of the petitioner within an outer limit of 8 weeks from the date of receipt of the copy of the. No problem. Yes.
So far as not second petition is concerned,
Then
Lords, they claim to be owner of Lords survey number 94/2/3 and /4. Lords, I am told that Lords, so far as Lords the lines are concerned, that is the corridor area. Lords, it is Lords around
90.
Yes.
It is around 303 meters away Lords from his land.
Same relief.
Same relief, but idರಲ್ಲಿ Lords, Lords, neither Lords the tower base Lords nor Lords corridor area Lords passes through his land. Our corridor area.
let the DC draw up a report and do it.
In his petition itself, Lords, may I pass on Lords for a moment? But assessment. Now it passes only through Lords survey number 107. Tower base 24/10. Lords, Madhyadali, that is tower base 24/10. The survey number is 107. The land of petitioner is not the eastern side. That is report.
Allah, let the DC look into everything and do it. The petitioner.
Lords, in the event not the corridor passes through his land.
In accordance with law, yes. The petitioner is before this court seeking the following prayer. The case at hand is also identical to writ petition 89, serial number 89, number Aki. So the difference is with regard to the contention of the petitioner and the respondent. The learned counsel for the petitioner submits that ಇದರಲ್ಲಿ ಏನಂದ್ರೆ ನೀವು ಡಿಫರೆನ್ಸ್ ನಿಮ್ದೇನಿಲ್ವಾ?
ಏನಿಲ್ಲ.
Contention of the respondents, petitioner. The learned counsel Nilendra Gunde submits that the electric lines does not pass through the land of the petitioner at all. And therefore he is not entitled to claim any compensation as is now claimed in the subject petition. Therefore, on the very reasons rendered in writ petition, the 89, on the very reasons rendered therein, the deputy commissioner will now analyze the claim of the petitioner with regard to compensation, bearing in mind the contention of the counsel Nilendra Gunde that no electric lines are passed through the land of the petitioner. Map is produced, village map either. The survey map is placed before the court. The same be placed before the deputy commissioner, and the deputy commissioner shall also look into the survey map and pass necessary orders in accordance with law. Yes. Survey map or the report submitted and the report submitted by the petitioner.
Great.
Ordered accordingly. 8 weeks the deputy commissioner shall pass necessary orders within 8 weeks from the date of receipt of the copy of this order. Yes, next. ಯಾರ್ಯಾರಿಗೆ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್. ಒನ್ ಅಷ್ಟೇ ಏಜ್ ನೋಟಿಸ್.
Please.
One submission, previous matters. Let the date may be fixed for appearance. If they want to place any documents. ಅದು 89 90 ದಲ್ಲಿ ಅವರು.
Assessment ಗೆ Lords, let him Lords appear.
They want to produce anything. Other thing
We'll fix a date for your appearance.
Before
DC ಮುಂದೆ. ಎರಡರಲ್ಲೂ the petitioner shall appear before the deputy commissioner on the 30th of October 2025 at 2:30 PM. The deputy commissioner shall hear the petitioners and pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order within 8 weeks thereafter.
Please.
Yes.
Great. 91 Henry Act.
I appear for the respondent caveat.
Pass over. ನೆನ್ನೆದ ಇದು? Day before yesterday.
Lord, this matter in relation to the election to this society, the election has been separately questioned where identical issue is involved, where the court has ordered that.
Which is that petition, sir?
That is WP 106790/25.
ಅದು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ಇವತ್ತು?
ಅದು ನೆನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು. It can be posted, both can be posted together because
ನಾಳೆ ಹಾಕ್ತೀನಿ ಎರಡನ್ನು.
ಏನ್ ಇದರಲ್ಲಿ ಇದೇನಿಲ್ಲ.
Tomorrow, sir.
ಎಲೆಕ್ಷನ್ ಆಗೋಗಿದೆ, ಅದರಿಂದ ಆಗೋಗಿದೆ. ಬರೀ ವೋಟಿಂಗ್ ಮಾತ್ರ, ಐ ಮೀನ್ ಕೌಂಟಿಂಗ್ ಮಾತ್ರ ಬಾಕಿ ಇದೆ.
ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್ ಕವರ್ಡ್ ಅಲ್ವಾ ಇದಕ್ಕೆ? ಲಾಸ್ಟ್ ಅದೇ after lapse of 27 years is the only thing that is to be heard. A number
but
WP
106790 of 25.
Tag this petition along with so and so, list them both tomorrow in preliminary hearing. Next. ನಾಳೆ ಡಿಫಿಕಲ್ಟಿ ಇದೆಯಾ? ನಾಳೆ ಡಿಫಿಕಲ್ಟಿ ಇದೆಯಾ? ಮತ್ತೆ
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನು
you are
ಅರ್ಜೆನ್ಸಿ
before the
ಇದೆ?
court, sir, don't worry. You are before the court. You are before the court, don't worry. Yes, next.
Bill number 92, Srinivas Nayak.
Withdraw. Learned counsel for the petitioner files a memo. Memo ilva? Learned counsel for the petitioner submits that he be permitted to withdraw the petition and avail of such remedy as available in law. In the light of said submission, the petition is disposed as withdrawn.
My name may be shown in the connected writ petition for respond number 10.
Learned the registry to print the name of Srinivas, Srihash Nilofan as appearing for the 10th respondent in 92.1. R2 state, very 2 matrana. R2 state, yes.
With your lordships kindly,
Yes, sir.
serial number 157 ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು. 230 ಮಾಡ್ಲಾ?
230 ತಗೊಂತೀನಿ. 157 in 2-3 ಇದೆ election. I'll take all of them at 230.
Oblige.
Yes, please.
We refer to cell number
Second list
93.
ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ. Second list ಇಲ್ಲ.
SB Hebbali.
Yes, sir.
Connected WP is there, has to be tagged.
ಇದು 2011. ಅದು ಯಾವ ವರ್ಷದ್ದು?
Within the same party.
ಯಾವ ಇಯರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ?
2021.
11, 21. What is under challenge?
What is challenge? The petition, I am interested in there are no notice. And added to that, there is a civil dispute between the parties. So we filed an application for section 30 for reference.
Partition.
For reference.
Suit ಏನು? Suit for?
Suit for declaration of ownership. And the trial could decree in my favor. Appellate court
Right.
reversed.
One opportunity ಅಷ್ಟೇ. Next time no adjournment. Yes.
Next in November.
List the November. Why?
Next month.
Why? 2011, sir. List the matter on 28th. It is made clear. Oh no, along with writ petition so and so number kudi.
101180.
It's made clear no further adjournment will be granted in the matter. Yes.
Bill number 90.
First week of November.
ಯಾಕೆ ನೀವು ಇರೋದಿಲ್ವಾ? 14 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. They are all answerable.
We are also interested.
In fact,
You are interested. ಮತ್ತೆ ಬಂದ್ಬಿಡಿ.
In fact, my lord, the issue cannot be adjudicated unless the RSA pending, my lord, seeking their rights
still pending, my lord.
RSA ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದೆ.
Pending ಇದಾವೆ, ಮೂರು RSA pending ಇದೆ.
ಆಯ್ತು, then list after 4 weeks.
Please.
94, Chetan Manoli. J. Gachinmat.
For the respondent, I need to file, I'm appearing for the corporation, my
Need
lord.
to file what, sir?
Objection. Recently, I have been impleaded.
Recently?
I have been impleaded.
In case ಇಲ್ವಾ?
ಇಲ್ಲ ಕೇಸ್ ಇದೆ, ಅವ್ರದ್ದು objection is necessary, my lords.
We need to.
Initially burden was on Huda, now it is on HDM.
Learned counsel appearing for, what's your name?
Irangoda Kapoor.
Irangauda Kabur seeks 2 weeks time?
2 weeks time.
2 weeks time to file statement of objections. Finally, 2 weeks time is granted to file statement of objections to the fourth respondent. Yes.
Any date after?
List the matter on 4th November.
Please, please.
94.
4th November.
Please. Note, only.
14%.
My lord, kindly have it next week, my lord.
Huh?
Kindly have it next week, my lord.
Why?
Senior is held up in court all 7, my lord, since.
Total 7, ask him
Yes.
to come.
Please.
He will be held up for whole week, is it? Yes, sir. ಏನು?
My lord, in this writ petition, I have challenged the land acquisition proceedings initiated by the state in respect of our land, my lord. Brief facts are like this, my lord.
Yes.
My lord, the father of the respondent number 5, my lord, had filed a civil suit
ಹೇಳಿ.
over our land seeking relief of declaration, my lord. The said suit came to be dismissed with cost, my lord. Thereafterwards, he wanted to take vengeance against us, my lord.
Vengeance case ಅಲ್ಲ, land acquisition.
Land acquisition, yes, my lord.
Vengeance ಬಗ್ಗೆ ಹೋಗ್ಬೇಡಿ.
Okay.
Yes.
Thereafterwards, my lord, the fifth respondent came to be elected as an MLA, my lord.
ಆಮೇಲೆ
Thereafterwards, my lord, as per annexure A1, page 69, my lord, the town municipal council, Gajendragada, passed a resolution to acquire entire land standing at our survey number, my lord. Only our survey number, my lord. They have targeted our land, my lord, for the purpose of establishing vegetable market, my lord. Thereafterwards, my lord, the deputy commissioner issued a preliminary notification under section 4(1) during January 2007, 9th January 2007, my lord. The purpose and extent of the area mentioned in this notification is very important, my lord. The purpose is mentioned in the very second line, my lord, from the top. ಈ ಮುಂದಿನ ಅನುಸೂಚಿಯಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 72, my lord. ಈ ಮುಂದಿನ ಅನುಸೂಚಿಯಲ್ಲಿ ಸೂಚಿಸಿರುವ ಜಮೀನುಗಳು ಒಂದು ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕೆ ಅಂದರೆ ರೋಣ ತಾಲೂಕು ಗಜೇಂದ್ರಗಡ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಾಯಿಪಲ್ಯ ಮಾರುಕಟ್ಟೆ ಪ್ರಾಂಗಣದ ಕುರಿತು ಬೇಕಾಗುತ್ತಿದೆ ಅಂತ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಗದಗ ಇವರಿಗೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ, my lord. Later onwards, they have diversified the purpose, my lord. In the chronological order, I will submit, my lord. And the area of acquisition, my lord, it is mentioned as 10 acre 20 guntas, my lord. Because our land was measuring exactly 10 acre 20 guntas, my lord. Based on record of rights, they have mentioned that their requirement is 10 acre 20 guntas, my lord. In pursuant to that preliminary notification, we have filed a objection which is at page number 73, annexure D, my lord.
Yes, sir.
In that, my lord, we have taken a specific contention, page number 74, my lord. From the top, I may be permitted to read, my lord. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ರಸ್ತೆಯ ಹಕ್ಕು ಅದೇ ಅಂತ ಒಬ್ಬ ಶ್ರೀ ಗುರುಶಾಂತಪ್ಪ ಬಂಡಿ ಸಾಕಿನ್ ಗಜೇಂದ್ರಗಡೆಯವರು ಹಕ್ಕು ಕೇಳಿ ಗದಗ ದಿವಾಣಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಮಾಡಿದ್ದರು. ಸದರಿ ದಾವೆ ಚೌಕಶಿಯಾಗಿ ಖರ್ಚು ಸಹಿತ ವಜಾ ಆಯಿತು. ಸದರಿ ಶ್ರೀ ಗುರುಶಾಂತಪ್ಪ ಇವರು ಈಗ ಪೂರ್ತಿಯಾಗಿದ್ದು ಅವರ ಮಗ ಈಗ ರೋಣ ತಾಲೂಕಿನ ಶಾಸಕರು ಅಂತ ಆರಿಸಿ ಬಂದಿದ್ದು ಹೇಗಾದರೂ ಮಾಡಿ ಸದರಿ ಆಸ್ತಿಯನ್ನು ಕಬಳಿಸುವ ದುರುದ್ದೇಶದಿಂದ ಹಾಗೂ ರಾಜಕೀಯ ದುರುದ್ದೇಶದಿಂದ ಈ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕರಣವನ್ನು ಕೈಗೆತ್ತಿಕೊಂಡಿದ್ದು ಅದೇ. ಸದರಿ ಜಮೀನು ಯಾವುದೇ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಗಳಿಗೆ ಬೇಕಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನು ಕಾಯಿಪಲ್ಯ ಮಾರುಕಟ್ಟೆ.
ನೀವು ಪೆಟಿಷನ್ ಓದ್ಬೇಡಿ.
ಆಯ್ತು, my lord. Okay. This was the objection, my lord. And finally, we requested to drop the acquisition proceeding, my lord. Later on, the land acquisition officer fixed a date for hearing, my lord, personal hearing. That notice was received. In pursuant to that, we submitted a representative which is at annexure F, page number 76, my lord. We sought for adjournment of the hearing, citing the reason that the bar association had
ಆಯ್ತು, ಈಗ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ವಾ?
ಕೊಡ್ಲಿಲ್ಲ, my bar association strike ಕರೆದಿದ್ರು my lord.
ಆಮೇಲೆ
ಅದಕ್ಕೆ ನಾವು ಅದು ಗೊತ್ತಿತ್ತು, ಹಂಗಾಗಿ ಪರ್ಸನಲ್ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿ my lord. ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ my lord. ಆಮೇಲೆ ಮತ್ತೆ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಒಂದ್ 2-3 ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿ my lord. ನೀವು ನಮ್ಗೆ ಏನು ಹೇಳ್ತಿಲ್ಲ ಅಕ್ವೇಷನ್ ಡ್ರಾಪ್ ಮಾಡಿ ಅಂತ. ಅದಾದ್ಮೇಲೆ ಗೊತ್ತಿಲ್ಲ my lord, ಅದು ಪೇಜ್ ನಂಬರ್ 78 annexure S ತರ 6-1 ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಆಗಿಬಿಟ್ಟಿತ್ತು my lord. However, we were served with notice under section 9-1 my lord. ಅವಾಗ ಗೊತ್ತಾಯ್ತು ಇವರು 6-1 ಇಶ್ಯೂ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ, ನಮಗೆ ಹಿಯರಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. Thereafterwards, we approached this honorable court in writ petition number my lord.
ಆಯ್ತು, ಆಮೇಲೆ ಹೇಳಿ.
The said writ petition was partly allowed my lord. The observation of this honorable court is important to be noted my lord. Para number 7, just I will read one para my lord. The third ground that the land is excessively acquired merits serious consideration. If the private lands are to be acquired compulsorily, then the government has to audit the land requirements. If the proposed beneficiary simply states that the entire land standing at a survey number is acquired for a public purpose, the same cannot be accepted mechanically without examining the requirements objectively. It is not the case of the respondents that the breakup of the land was given by the local body, respondent number 3, which came to be acted as a basis for the initiation of the acquisition proceedings. However, what extent of the land should be acquired is a matter to be decided by the concerned authorities and not by this court. The ends of justice should be met by this court, directing the respondent number 1 to objectively evaluate the requirements of the respondent number 3. If it finds that the land acquired is more than what is actually required, it shall pass the orders for deletion of the same. This exercise of the determination of the correct extent of the land shall be concluded expeditiously for the purpose of withdrawal of excess extent of land, if any, from the acquisition proceedings. And next 2 more lines, man. Before giving this direction, I ascertained from the advocates appearing for the parties in this case that the petitioners continue to be in possession of the lands.
ಈಗಲೂ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ?
ಈಗಿಲ್ಲ my lord. Before complying with this direction my lord, without giving any notice my lord, they have acquired the entire 10 acre 20 guntas my lord. Not only that my lord, they have sold it to the fourth party my lord for altogether a different purpose which was not notified, not declared under section 6-1 my lord.
ವೆಜಿಟೇಬಲ್ ಮಾರ್ಕೆಟ್ ಬಂದಿಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ my lord, ಬಂದಿಲ್ಲ. ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ವೇರ್ ಹೌಸ್ ಕಾರ್ಪೊರೇಷನ್ ಗೆ ವೇರ್ ಹೌಸ್ ಕಟ್ಟಕ್ಕೆ ಕೊಡ್ತಾರೆ my lord.
ಪಬ್ಲಿಕ್ ಪರ್ಪಸ್. Who is to answer?
My lord, ಇನ್ನೂ ಸ್ವಲ್ಪ ಇದೆ my lord.
ಇನ್ನೂ ಸ್ವಲ್ಪ ಇದೆ.
ಪೇಜ್ ನಂಬರ್ 101 my lord. ಈ ತರ ಡೈರೆಕ್ಷನ್ ಏನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ my lord, ಈ ಹೈಕೋರ್ಟ್ ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಇಂದ, ಅದ ಪ್ರಕಾರ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಒಂದು ಮೀಟಿಂಗ್ ಕರೆದ್ರು my lord ಟು ಡಿಟರ್ಮೈನ್ ದಿ ಎಕ್ಸೆಸ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್. ಅದರಲ್ಲಿ ಮುನ್ಸಿಪಾಲಿಟಿ ಪರವಾಗಿ ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು, ಲೀಗಲ್ ಅಡ್ವೈಸರ್ ಎಲ್ಲರೂ ಹಾಜರಾಗಿದ್ರ ಮೇಲೆ ನಾವು ಇದ್ವಿ. ಅಲ್ಲಿ ದ ಮುನ್ಸಿಪಾಲಿಟಿ ಪರವಾಗಿರೋ ವಕೀಲರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಯಾರಿಗೆ? ಪ್ರಿನ್ಸಿಪಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ. ಏನಂತಂದ್ರೆ ನಾವು ರಿಟ್ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ದೇರ್ ಫೋರ್ ಯು ಶುಡ್ ನಾಟ್.
ರಿಟ್ ಅಪೀಲ್ ಏನಾಯ್ತು?
ರಿಟ್ ಅಪೀಲ್ ಅಪೀಲ್ಡ್ ದಿ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್.
ಆಯ್ತು, ಆಮೇಲೆ
my lord ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್
ಅಲ್ಲ, ಅದೇನಾದ್ರು ರಿಟ್ ಅಪೀಲ್ ಕನ್ಫರ್ಮ್ ಆಗಿದಲ್ಲ?
ಆಯ್ತು, ಬಟ್ ಲಿಬರ್ಟಿ ವಾಸ್ ರಿಸಲ್ಟ್ ವಾಸ್ ಟು ಇಂಪ್ಲಿಮೆಂಟ್ ದಿ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್.
ಆಯ್ತು.
ಇವರು ಅಲ್ಲಿ ಈ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ನ ಎಷ್ಟು ಎಕರೆ ಬೇಕಂತ ಡಿಸೈಡ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರೆಸ್ಪಾಂಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾರನೇ ದಿವಸನೇ ಬಂದ್ಬಿಟ್ಟು ಥರ್ಡ್ ಒಂದು ರೆಸೊಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ my lord, ವೇರ್ ಇನ್ MLA has taken part in that meeting and they have created third party rights my lord.
ಆಯ್ತು, ಅಷ್ಟೇನಾ?
ಇದೆ my lord.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು, ನೀವು ಬಂದಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದೆ.
ಆಯ್ತು my lord, ಟೈಮ್.
Yes, when do you want?
I do not have instructions to do submissions, my lord. Kindly
No,
have
you
it, my
can't
lord.
do submissions,
Next
I
week,
understand.
my lord. Next week,
Place
my
the
lord.
matter on 28th at 2:30 PM.
November 6th. Please.
ಯಾಕೆ ನೀವು ಇರಲ್ವಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ಆನ್ November 6th, 2025 at 2:30 PM.
Great.
Please.
96 VM Shilvan.
Sought for declaration that land acquisition loss has lapsed. As there are two lands.
ನೀವಿದ್ದೀರಾ ಸರ್?
Lord, for the government, my lord, I appeal.
Ready?
Yes, ma'am.
Yes.
Plus there are two lots lands, survey number 238/2, measuring 12 acres 22 guntas, and 239/2, measuring 15 acres 22 guntas. Earlier there were proceedings in 1992. Ultimately that acquisition was dropped. Later on public interest was filed. Later on again acquisition was made in 1999. And the first notification was issued on 11/2/1999, 4/1 notification. And sixth one notification issued on 17/3/1999.
Your synopsis is here.
Synopsis.
ಹಾಕಿದ್ದೀರಾ?
Okay.
ಅಲ್ಲ ಇಲ್ಲಿದೆ ಅದನ್ನ ನೋಡ್ ಮತ್ತೇನು ಅದನ್ನೇ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. Yes.
Plus, when this was challenged, this acquisition was challenged in writ petition. Court held, my lords, they have not followed 5(1). It is mandatory. Therefore, 6(1) notification was quashed. In the meanwhile, they pass an award. Automatically, my lords, pursuant to order of this honorable court, the award goes. 2000. Later on, again, it was acquired. That was questioned before this honorable court in another writ petition. And writ petition later on dismissed. Writ appeal is also dismissed. But no award is passed as on today. No toll to notification issued. Therefore, my lords, they rely upon 2000 award, which is already quashed by this honorable court. That is my case.
ಅಷ್ಟೇ.
Asked. And possession is not taken, admittedly possession is not taken. I got an interim order in this also. I produced this document to show that.
2012 ಇಂದ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದರಲ್ಲಿದೆ. Because they said position, symbolically they have taken position, but the actual position is not taken. I filed an application for injunction that is granted.
Well, here at 2:30. 2:30.
My presence may be dismissed, because I got pattern matter in court number 2.
ಅವ್ರು ನಿಮ್ದು ಅಷ್ಟೇ ಅಂತ ಹೇಳಾಗಿದೆಯಲ್ಲ.
Number 130, place number 1, serial number 4, interim order is granted. May I seek for hand delivery?
ಅಪ್ಲೋಡ್ ಮಾಡ್ರಿ.
Serial number 124, my lord. I'm a respondent. I have to file objection, my lord. 2 weeks.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ?
Please, 124.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಯಾವ್ದು ಬೇಕು? ಹೇಳಿ.
Please, please.
Hello, serial number 97, my lord. We have engaged senior counsel today. He has some personal inconvenience, my lord.
97 ಏನು?
Connected matters, my lord. We have informed the other side.
All right. When do you want?
28th or 29th, my lord. It may be called on
29th.
29th. Lord.
Serial number
My lord,
104.
serial number 123, my lords.
Lord, in 97, I appear for request on 30th. Instead of 29th.
ಆಯ್ತು 30th ನಾನು ತೊಂದ್ರೆ ಇಲ್ಲ.
Lord, serial number 100, my lord. I am for the petitioner. Lord, it's a land acquisition matter. I'll get ready and we'll argue, my lord, next week, any date. Senior.
All right. Yes.
100.
100 also.
Please.
Worship,
ಯಾವ್ದು
104.
ಬೇಕಾದ್ರೂ ಕೊಟ್ಬಿಡಿ.
104.
You can tell
Please.
the court officer.
Please.
103 tomorrow morning.
103? Adjournment. ಬರ್ಕೊಂಬಿಡಿ.
In 137, I undertake to file wakalat and I also raise time for filing of objections.
ಆಯ್ತು ತೊಂದರೆ ಇಲ್ಲ. Yes.
My lords, 123, my lords. I have to file wakalat, my lords.
123.
Please, my lords. I have to file wakalat.
File. Who is coming in the way?
I seek for some short accommodation, my lords.
That will be granted. Yes.
My lord, serial number 111, my lord. Weeks accommodation.
111.
111.
111. Yes.
Obliged.
Madam, 104.
Chetan.
ಸಡನ್ಸ್ ಇಲ್ಲ. ಆಗಳಿದಂಗೆ ಆಯ್ತು. ಇಲ್ಲ ಆ ಕಡೆ ಕೊಟ್ಟನು ಬರ್ಲಿಲ್ಲ, ಏನ್ ಬರ್ಲಿಲ್ಲ. ಇಲ್ಲ ಅವ್ರಲ್ಲ ಈಗಿಲ್ಲ, ಬರ್ತಾರೆ 2:30 ಅದ ಬ್ಲಾಕ್ ಆಗೈತೆ ಅಂದ್ರೆ ಸ್ಕ್ರೀನ್ ಇದನ್ನಿಲ್ಲ ತಡಿ ಅದ್ರಲ್ಲಿ ಅಲ್ಲ ಬರ್ಲಿಲ್ಲ ಹಳೆ.
Hello. No. Okay.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. MSME ಆಯ್ತು ಆಯ್ತು ಆಮೇಲೆ ಅಷ್ಟೇ. Have you withdrawn? 3 days. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಬೇಕು, ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ನನಗೆ. ಸರಿ ಸರ್. List on 28 made clear no further adjournment is granted, would be granted in the matter. Serial number ಏನು? 87.
Lord, may make a interim order may be extended in your state.
Interim order extend ಆಗುತ್ತೆ.
Please.
ಹಾ.
And matter it was.
ಬೆಂಗಳೂರು ಯಾವುದು? ಓ ಎಸ್ ಎಸ್. ಆಯ್ತು, ನಾನು ಜಡ್ಮೆಂಟ್ ದಿನ ಇಟ್ಕೊಂಡಿದ್ದೆ. ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಮೂವ್ ಮಾಡೋದು ಕರೆದ್ಬಿಡಿ. ಒಂದೇ ನಿಮಿಷ ಬಂದಿದೆ.
In this case, this petition is being filed, agree with the orders dated 23/8/25.
What is that order?
That is 311 application filed by me is rejected, my lordship.
138 proceeding.
Yes, my lordship. In Belur case, my lordship. In this case,
ಬೇಲೂರ ಬೆಂಗಳೂರು ಕೇಸ್ ಏನ್ ಹೇಳಿ?
Bengaluru.
ಇರ್ಲಿ.
Trial court order against the trial court order, we filed the criminal petition in Bengaluru, my lordship. In this case, my lord, urgency.
311 application is rejected.
Rejected, my lordship.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
23/8 ಅಲ್ಲಿ rejected.
Sir, at what stage of the 2017 CC
Yes,
when did you file this 311 application?
My lordship, in this case, my lordship, one submission, my lordship. The respondent number 1 filed the complaint before the trial court by different persons. They have filed 5 cases, my lordship. 5 cases, my lordship. Further, my lordship, in one cases, they allowed my petition. In one cases, they allowed my petition. 65. Previously, before this honorable court, my lord, there is a direction to dispose the case early, my lord.
ಆಯ್ತು.
In this case, my lord, in one cases, they allowed my application to mark the document. In 3 cases, they have not permitted. Therefore, only my humble submission, I am not seeking stay. Only one date to mark. Permit to mark the only documents, my lord. Only.
Where is the order impugned?
81 to 88.
Page?
81 to 88.
81 to 80.
88. Annexer E, my lordship. 88 there. In this case, my lordship, the documents I will submit. What are the documents?
Anything else, sir?
Tomorrow is the case.
Tomorrow is the judgment. Madli.
Allah, my lordship, not for judgment, for argument only. Why, my lordship, why there is delay, my lordship? I submit, my lordship.
Where is your application?
Application is annexer, page number 38, annexer C. Annexer 3. Our case is, my lordship, there is no direct or indirect contact in the transactions with the respondent number 1.
Anything else, sir?
My lordship, in one cases, they allowed my application 65B. The 5 cases, my lordship. Now, I come here with the 3 cases, my lordship. The documents are very much required because.
Oh, yeah, there is no foundation in the application at all. Why they are required?
My lordship, there is no direct or indirect contact with transactions.
Sir, don't worry. These documents will neither here nor there.
My lordship,
and tomorrow is the judgment. I am not going to say
not
anything.
judgment, my lordship. Not judgment, only argument.
My argument.
My lordship, tomorrow itself I will furnish the document. I will not seek a single day. I will not seek, my lordship.
No, sir.
The reason
2017 CC, I have already directed closure of the proceedings.
I agree, my lordship. Only tomorrow itself.
But I don't agree with you.
My lordship, I will produce the documents tomorrow itself, my lordship. In one case, myself, last submission.
No, sir.
Only one submission, my lordship.
138 proceeding 10 ವರ್ಷ ನಡೀತಾ ಇದೆ. No, sir.
My lordship, only one submission, my lordship. In initially, cross up PW1 is adopted in other cases. my humble submission is, all these documents already marked in one case, maybe taken into record, that's all, that's also okay, my lordship. That I will
ಅವಾಗ ಈ
observe in
ಕೇಸ್
the-
ಮುಗಿದ ತಕ್ಷಣ ಅಲ್ಲಿ ಮುಂದೆ ಹೋಗ್ಬಿಡಿ.
My lordship.
ಅವಾಗ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲೇ ಹೇಳ್ತೀನಿ.
ರಮೇಶ್ ಸರ್, ಮ್ಯೂಟ್ ಒತ್ತಿ.
I'm so sorry, I'm so sorry.
My lordship, one submission, the cross of PW is adopted in all the cases, like that the documents
That
marked by.
argument you make, documents ಬಗ್ಗೆ I will not stay nor permit this application under 311.
Yes, my lordship, only submission is.
ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಕೇಸ್?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಒಂದ್ ಕೇಸಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿರೋದನ್ನ ಎಲ್ಲಾ ಕೇಸ್ಗೂ ಅನ್ವಯಿಸ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಬಿಕಾಸ್ PW1
ಮಾಡಿ, that I will observe.
yes,
The
my lord.
petitioner in all these cases is common. The proceeding is common. The offense alleged is common. These petitions were before this court on an earlier point in time, where this court had directed closure of the proceedings within a time frame. The matter is slated to be listed for its arguments tomorrow. Date haki. At this juncture, the petitioner accused is before the court, challenging an order passed rejecting the application under section 311 of the CRPC. The rejection of the application is on the score that the affidavit which seeks recall of PW1 for the cross-examination does not render any reasons. A perusal at the application would clearly indicate that there are no reasons indicated as to why the document should be marked or the recall of PW1 for further cross-examination. The matter is at the fag end of the trial. In that light, there is no warrant of interference at the hands of this court with the order passed by the concerned court rejecting the application under section 311 of the CRPC. At this juncture, the learned counsel for the petitioner submits that the common evidence is led in all the cases where document is marked in one case and the same should be taken note of in the least in the other cases. The said submission would merit acceptance. Therefore, the documents that are marked in one case, if is needed for the defense of the accused, shall be permitted to be taken note of in the other cases, except the aforesaid observation.
CC 321/19 ನಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿರತಕ್ಕಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ
So and so. ಅದರಲ್ಲಿ ಹೈಫನ್ ಹಾಕ್ಬಿಟ್ಟು in CC
321 of 321 of 17
77 321 of
17
321 of 2017.
ಅದು ಕ್ರಾಸ್ ಆಫ್ PW1 ಅಂತ ಬಂತು. ಇದು ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಗೆ ನಾನು
ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಓನ್ಲಿ ಒನ್ ಸಬ್ಮಿಷನ್, ಒಂದು ಕೇಸ್ ಬಂದಿಲ್ಲ. ಟುಮಾರೋ
ಬಂದ್ರೆ ಇದು ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ. ಸೇಮ್ ಆರ್ಡರ್. ನೀವು ಬೆಂಗಳೂರಿಗೆ ಹೋಗ್ಬಿಡಿ ನಾಳೆ. ಎಸ್, with the aforesaid observations ಎಲ್ಲದಕ್ಕೂ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. ಸ್ಪೆಷಲ್ ಪೆಟಿಷನ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಡಿಸ್ಪೋಸ್ಡ್. ನಾಳೆ ಬಂದ್ರೆ ಅದಕ್ಕೂ ಸೇಮ್ ಕವರ್ಡ್ ಮಾಡಿ. ಎಸ್, ಯಾವಾಗ ನಿಮ್ಗೆ ಯಾವಾಗ ಇಷ್ಟ. ಎಸ್, ಅದು ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ ತೋಡಿ.
My lord, may I make one short submission?
Yes.
My lord, in the morning, your lordship was pleased to pass an interim order in serial number 11 and club it with a batch of cases, my lords, license cancellation. That effective portion is correct, my lords, but the grounds on which we sought for is slightly different, my lords. So that portion, if it can be deleted in today's order, my lord. Because the grounds we are asking is second and third analysis were not provided.
I'll buy interim order ಮಾತ್ರ ಕೊಡ್ತೀವಿ ಬಿಡಿ. ರೀಸನ್ ತೆಗೆದು.
Please, great.
62 162 ಯಾರು ನಂದ ನಾನು ಕೊಟ್ಟಲ್ಲ. FC ಇಲ್ಲ ಕೊಂತ
ಹೇಳಿ. ಈಗ ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ನೋಡಿ, ಅವ್ರನ್ನೇ ಕೇಳ್ಬೇಕು, ನನ್ನ ಹತ್ರ ಇಲ್ಲ.
ರವಿಶಂಕರ್ ಸರ್. ಏನಕ್ಕೆ ಹಾಕಿರುತ್ತೆ ಬಂದಿದ್ದಾರೆ ಅವರು. ತೊಂದರೆ ಇಲ್ಲ, ಕರೀರಿ ಎಲೆಕ್ಷನ್ ಮಾಡಿ.
156 Adikun wala?
Lords, 156, I'm appearing for the petitions council, my lords.
Yesterday's matter.
Yes.
Yes.
Yes, I am appearing for the third respondent bank in the meeting.
Yes, sir.
Lords, the dispute lies in a very narrow compass. If your lords is to see, there is a demand notice issued at page number 27, annexure B, where we were required to pay 11,31,800. This is a statutory notice in terms of section 22A. Substantially, my lords, it should be in terms of section 22B. The 20 subsection 2 B4, my lords, will be the essential provision where such demand notice is contemplated. Lords, now annexure C, the entire amount is paid on or before 9th. It was required to be paid. We have paid the amount. Lords, now despite having paid this amount, I am still kept, my lords, in the ineligibility criteria, ineligibility list, on the count that we are still a defaulter.
When did you pay the amount?
1st of September. Which your lords will find, my lords. The challan is available at page number 28.
Yes.
Lords, now
entire amount is paid?
The entire amount, my lords, we have paid, the demand was 11 lakhs.
ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, we have paid more.
So amount
With interest,
stands paid.
amount stands paid. Lords, now the question of declaring ineligibility, my lords, it need not be going to the further question. The question of declaring of the ineligibility, my lords, is what is provided for in terms of section 22 B4B. If your lords were to see.
One moment.
I don't come under A because recoveries I have done. It's only under B, because of which the notice is issued.
20 subclause 2.
After
B4.
A4, A5, then there is B, then Roman 1, 2, 3, 4. Then again, my lords, in Roman 4, A. Lords, what is very necessary to be pointed out to your lordships is B speaks about a cooperative society member. Lords, subsection 2 of section 20 speaks about the members who will be ineligible to vote. In that, if it is a cooperative society member, because cooperative society will be essentially a part of another cooperative society, which may be a secondary, federal, or a state level society, there, A, my lords, is my recovery. I should have recovered from the persons to whom I have lent 50%. That there is no allegation. Next, B, which fails to pass on to the financing bank or credit agency, as the case may be, 50% of the demand or the entire portion of the recovered amount of the demand of the financing bank or credit agency, whichever is higher, at least 15 days before the date of the general meeting or the date of the election, after a notice of not less than 30 days in this regard has been issued to the society. Notice, whatever is the demand to be made is the demand which is the statutory notice covering under section 22B4B. Notice, now if your lordships were to see rule 13D3. Again, it contemplates, my lords, the timings within which it's a time schedule when the default is to be notified, within how many days. Essentially, my lords, it also reiterates that 30 days notice is required to be given for payment
13D?
of the money. 13D sub rule 3. The distinction is 13D2A is pertaining to the disqualifications under section 22A4 and A5. Defaults are covered under section rule 13D3. Now this is the schedule. Now other than this, there is nothing else which can be done to declare me as a defaulter. This is the set procedure. Now they issued the demand notice. I have paid the money. Now after this period is already over now. Now we are another 3 days down the line, we are on the election. Now with this 30 days period having already expired, question of me being declared as ineligible on any other count does not arise. Because this is a procedure contemplated in the statute itself.
Yes,
so,
sir.
Yes, my lord.
Yes, sir.
Lord, I rest my case, my lord, with the same provision which I had relied upon yesterday in the other 2 cases which my lord had yesterday disposed of. Kindly turn to annexure G, my lord, page number 40.
Yes.
Kindly see the first portion. There are two portions in that particular document. It is called demand, recovery, and balance. One is at the bank level, the other one is at the society level. I am concerned with the bank level. Kindly see the percentage of recovery that they have made. 9.14. Now, my lord, that invites the disqualification under section 22B, clause 4A.
Yeah, doesn't apply.
Same foundation illa adಕ್ಕೆ ನೆನ್ನೆ ಬರ್ದಿದ್ದು ಆರ್ಡರ್.
No, I said I rest my case with that because that is the statutory prohibition. And if my lord again he is pressing into service MS Gill, my lord, I have no answer at this stage.
Just one.
Because
I wanted to clarify
second,
this.
Sorry,
Ravi
Shankar,
my apologies. My apologies.
Now, if my lord is referring to MS Gill, which was done yesterday, now from the records I am able to point out, not from my objection because I have not filed my objection as yet. From the records I am able to point out, and your lordship knows, MS Gill says that record should speak for itself. Now, record speaks for itself here. So, therefore, having a combined reading of Annexure G and the provision which I referred to drives home the point that he is a defaulter. So, he is ineligible to be included in the list of voters. That's what precisely we have done.
Now, Ravi Shankar sir.
Lords, can I just clarify this?
ಅಲ್ಲ, ಒಂದು clarification ಬೇಕು.
Please.
Come to page 40.
Please, my lords.
This is with regard to no recovery being made.
My lords, this how this bank is misleading itself is for this reason.
This is not declaration of defaulter.
Yes. My lords, what they are now bringing about saying that bank level recovery is never contemplated under the scheme of the Act for disqualification. Lords, may kindly go to section 22B4 for a minute. It's not contemplated. Bank level recovery is something not contemplated at all.
B4B.
B4, Lords, may kindly see B4 first.
B4, yes.
Lords, it starts as a cooperative society whose principal object is to advance loans and whose percentage of recovery
is.
Yes. Now, less than 50% of its total demand for cooperative year immediately preceding the cooperative year during which the meeting or election is to be held. That means, Lords, now I will have a credit agency. Lords, now in this situation, the credit agency is the bank. The bank is the credit agency. Lords, PACS, Primary Agricultural Credit Society, is what we do. Under various schemes, the loans will be lent to the farmers. Now, in the loans which we have lent to the farmers, I am required to recover at least 50% of the dues which would emanate for the previous year. In the previous cooperative year, that is preceding the year on which the election is required to be held. This is only so far as the recovery at the level of the cooperative society. I should recover. Next, Lords, this is pertaining to cooperative society. Question of bank level recovery is unheard of. Then next, B. A cooperative society which fails to pass on to the financing bank or the credit agency, as the case may be, 50% of the demand or the entire portion of the recovered amount of the demand of the financing bank or credit agency, whichever is higher. But now let us assume that in the previous accounting year of the cooperative year, I was required to recover 1 crore. Notice, if I recover 60 lakhs, I am required to deposit the entire 60 lakhs before the credit agency, which will be the DCC bank. This is a disqualification qua the activities of myself, not the bank level recovery. Bank level recovery is unheard of. This is what I do. If I recover 50 rupees, I should go and deposit 50 rupees to the credit agency. This 50 rupees should not be less than 50% of the dues which is recoverable in the previous cooperative year.
Yes.
No, may I make my submission, my lord?
Yes, sir.
Turning on the same provision which my learned friend referred to, he is trying to draw a dichotomy between two aspects. One is the amount that he is required to recover by virtue of clause B and subclause 4, which says whose principal object is to advance loans and whose percentage of recovery is less than 50% of its total demand for the cooperative year immediately preceding the cooperative year during which the meeting or election is held. The previous year's recovery is less than 50%. He can't ignore this portion. The word used is or.
But in the
Kindly
order,
see.
it is 22A.
My lord, your lordships agreed
They
with me
can't issue a
yesterday.
demand notice at 22A, my lords.
The 22A. It's
ಅಲ್ಲ 22A ಮಾತ್ರ ಫೌಂಡೇಶನ್ ಇರೋದಿಲ್ಲ 22A ಮಾತ್ರ.
There is no foundation.
There
I'm
is no
pointing out.
foundation laid in the order. No, even if you say it was a wrong provision out of inadvertence brought in, even then there should be foundation for a right provision.
May I beseech your lordship for a minute's hearing, my lord, in this?
Yes, no problem. Really.
No, I am placing before this honorable court the records of the proceedings. It's a certiorari proceedings. Records are before this honorable court. I am pointing out violation of a mandatory statutory provision traceable to this particular provision which I often read and my learned friend also read. It points to the fact, sorry, my lord.
You file your objections.
I'll file, my lord, but if he's a defaulter, he's not entitled to participate in the voting.
We will permit him participation subject to the result of the petition. Matter requires consideration.
I rest my case with this, my lord. I'm pointing out a violation of a statutory provision which disentitles him from participation. That too, where the percentage of recovery is less than the stipulated percentage. If your lordships considers that,
File your objections.
oblige me.
Where, sir?
I have filed an impleading application, my lord. Who is the contesting candidate, my lord, whose nomination has been accepted. Now, my lord, the list is also announced, published, my lord, where the under format 16, my lord. Therefore, my lord, may I request, my lord, in page.
I think process start agide anta.
Oh, the process has already commenced. The election is scheduled on 19th, my lord.
Yes, Ravi Shankar sir, that's one problem.
Lords, we are only being permitted to vote, my lords. There is no interference with the process. The Supreme Court has said, my lords, only voting. Only voting.
Only voting. Voting.
Only voting.
No, I am not contesting, only voting.
List of candidates has been published.
Only voting.
No difficulty. We are only asking for voting.
Heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner and the learned senior counsel Pramod Katavi representing the third respondent.
Jaikumar Patil.
He is muted, my lord. Probably he is muted.
The voting I will grant, subject to the result of the petition that will be kept in separate with all that.
Of this thing, my lord, even that would create a complication. I would respectfully submit, in view of the earlier view taken by this honorable court in the case of Muhammad Bari, H.S. Raju, etc., my lord, it is for him to approach the under section 70, even for voting rights also, my lord. It definitely changes the voter list. It is a process that's being continued, my lord. Therefore, I would respectfully submit, my lord.
Which is the judgment, sir?
ಇಲ್ಲ ಅವರದು
ಯಾವ್ದು ಕೊಡಿ ಸರ್?
ಗಂಗಣ್ಣ ಕೇಸ್ನಲ್ಲಿ ಹೇಳಿದ್ರು. ಗಂಗಣ್ಣ ರಾಜು ಆ ಕೇಸ್.
ದಟ್ಸ್ ಜಸ್ಟ್ ಅನಂತ ಹೆಗಡೆ ಅವರದಾ?
ಅನಂತ ಹೆಗಡೆ ಅವರು ಆಮೇಲೆ ರಾಜು ಕೇಸ್ನಲ್ಲಿ.
I just
even voting rights section 17 initiate ಮಾಡಬೇಕಾ voting rights?
Anything to do with the voter list upgradation, etc., it's being said it's only section 70, that is 29-271 of 23 by his lordship Justice Kamal, my lord.
ನಾವು ಇದನ್ನೇ ಫಾಲೋ ಮಾಡ್ತಿರೋದು.
ಇದನ್ನೇ ಫಾಲೋ ಮಾಡ್ತೀವಿ.
ಅದು ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಆಗಿರೋ ಮತ್ತೆ
ಇದು ಇಲ್ಲೊಂದು ಇದೆ.
ಅಲ್ಲ ಕೊಟ್ಟ ಮೇಲೆ ಸಹಿತ they said don't count, go there. Now what is being
ಈಗ ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಡೋಂಟ್ ಕಮ್ ಗೋ ದೇರ್ ಅಂತ ನಾವು ಅದನ್ನೇ ಹೇಳೋಣ, ಬಟ್ ಈಗ ವೋಟ್ ಮಾಡ್ಬಿಡ್ಲಿ.
ಅಲ್ಲ in Muhammad Bari's case it was said no voting rights was also not given. It was said you go to section 70. There is no way for these in these election matters.
ಅಲ್ಲ ಆಮೇಲೆ ನಿಮಗೆ ಈ ಕಡೆ ಇದ್ದಾಗ ತೊಂದರೆ ಆಗ್ಬಿಡುತ್ತೆ. ಇವಾಗೇನೋ ಈ ಕಡೆಯಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀರಾ, ಈ ಕಡೆ ಬಂದ್ರೆ ತುಂಬಾ ತೊಂದರೆ ಆಗ್ತದೆ ಬರದ್ರೆ.
ಇಲ್ಲ advocates ಗೆ it's a
ಹುಷಾರಾಗಿ
advantage.
ಹೇಳ್ಬೇಕು ನೀವು, ಯಾಕಂದ್ರೆ ಇಲ್ಲೂ ಇರ್ತೀರಾ.
It's an advantage for the advocates.
ಅದಕ್ಕೇನೆ ಈಗ we will do a via media. Yes.
ಸೆಪರೇಟ್ ಬಾಕ್ಸ್ ವೋಟ್ ಹಾಕಿ ಕಾಸ್ಟ್
Vote ಹಾಕಿ.
ಅಲ್ಲ ಸೆಪರೇಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಇವ್ರದ್ದು
ಅದೆಲ್ಲ ಮಾಡ್ತೀವಿ, ತೊಂದರೆ ಇಲ್ಲ. Voting rights I'm definitely going to give. Yes. The heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. ಅದು ಹೇಳಿದ್ನಲ್ಲ, ಜೊತೆಗೆ ಸೇರಿಸಬೇಕಾಗಿರೋದು ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಸರ್, ರಾಜಶೇಖರ್ ಬರ್ಚಿ. The issue in the list is with regard to suffering of disqualification by the petitioner to cast the members of the petitioner. Members of the petitioner to cast the vote in the ensuing elections.
ಡೆಲಿಗೇಷನ್ to delegate the petitioner
Delegate
number
of
one
the
society.
petitioner, my lord.
Petitioner number one society.
To delegate the petition to, the issue in the list pertains to delegation of the second petitioner by the first petitioner for the purpose of voting in the ensuing elections slated to be held on the 19th of October 2025.
Third response society.
To the third respondent society. The learned, the disqualification suffered is on account of a notice issued on 8/8/2025. The notice invokes section 20 within bracket 2 within bracket A of the Act to hold that the petitioner cannot delegate the second petitioner as it has suffered such disqualification on account of a default.
Sorry. The notice says you deposit the amount failing which
notice of a default. The notice would indicate the fact that if the entire amount has to be deposited within how much?
19/10/2025.
Within 19/9/2025. The learned senior counsel submits that D.R. Ravishankar submits as on 1/9/2025, the entire amount along with interest had already been deposited. In that light, there is no question of disqualification. The learned senior counsel Pramod Katavi takes this court through section 20B, section 22B,
4A.
B Roman 4 A and B.
2B Roman 4A to contend that recovery, which is a statutory obligation of the society which is constituted for the purpose of advancing loans, if falls below 50%, such a society would incur such disqualification to delegate for the purpose of voting or contesting and voting as the case would be. The learned senior counsel D.R. Ravishankar submits that the provision that is invoked in the notice is section 20 within bracket 2 within bracket A, and there is no foundation even laid in the notice for the mandate of alleging violation of the mandate of section 22B4A. In the matter would require consideration. The petitioner is seeking voting rights, seeking a right to vote in the ensuing elections to be held on 19/10/2025. In the light of the aforesaid circumstance and the matter requiring consideration, I deem it appropriate to permit the second petitioner, who is the delegate of the first petitioner, to cast his vote in the ensuing elections, and making it clear that no equity would be claimed by the petitioner at the later point in time. The vote cast by the petitioner shall be kept in a separate, sealed cover, which would and further steps would be taken pursuant to the order passed by this court on the next date. List the matter on 28th.
Lords, the results may not be declared till then, my lords, because they will exclude this vote and then otherwise let them.
Please. Last again ಹೇಳಿದೆ. ಅಯ್ಯೋ ಅದಕ್ಕೆ ಮುಂಚೆ ಏನು ಹೇಳಿದೆ ಮೇಡಮ್? kept separate, ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಮಾಡೋದು ಆಮೇಲೆ. Kept in a separate sealed cover. In the light of the aforesaid directions, the result of the elections should not be declared till the 28th. 28th in preliminary hearing.
Please, it's grateful.
Obliged me.
ಅಯ್ಯಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
ನಿಮಗೆ
ಅದೇ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಬ್ಜೆಕ್ಷನ್
heard along with main matter.
ನಾನು ಹೇಳ್ಬೇಕಾಗಿರೋದು.
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು. Registry to print the name of Rajshekhar Burji is appearing for the impleading applicant. Yes.
Please.
We'll hear it.
Deeply obliged.
R1 to R3? R1 and 4 AGA. R3 ಶಿವರಾಜ್ ಮುದೋಳ್ ಸರ್ ಇದ್ದಾರೆ. ಆಮೇಲೆ
R5 ಬ್ರಹ್ಮಗೌಡ.
R5 ಅಷ್ಟೇನಾ? Yes.
Much obliged.
Yes. ಇಲ್ಲ ಇನ್ನೂ ಎಲೆಕ್ಷನ್ ಬಿದ್ದವಲ್ಲ ಎಷ್ಟೊಂದು ಇದೊಂದೇನಾ? ಇನ್ಯಾವ್ದು ಅರ್ಜೆನ್ಸಿ ಏನು ಶಿವರಾಜ್? ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಏನದು? ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್
ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ.
ಹಾ ಹೇಳಿ ಯಾವುದು?
ಸೀನಿಯರ್
ಸೆಲ್ ನಂಬರ್
157
ಕೊಡಿ ಅದು.
senior counsel is on. Next.
It's 157.
Permitted to mention, madam. This next matter I'll mention.
ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
Yes, on the impleading appeal.
Impleading?
Impleading. At our instance, the objections were considered and he was disqualified under section 21(3). More than 2 votes, it can't be done. They are only urging that the society can't be disqualified. But now, if delegation form is sent by a person.
Yavat election?
25th is the election.
Then we'll take it tomorrow.
17th followed the last date for making nomination.
Tomorrow is 16th.
Madam, senior counsel Ashok Arnold is appearing in this matter.
ನಾಳೆಗೆ ನಂದಲ್ಲಿ 2003 ಮ್ಯಾಟರ್ ಐತಿ. 2003 ಮ್ಯಾಟರ್ ಹಿಯರಿಂಗ್ ಇದೆ, ಅದು ಸ್ಟಾರ್ಟ್ ಆದ್ರೆ ಲೇಟ್ ಆಗುತ್ತೆ. ಅದು ಟುಮಾರೋ ಇಟ್ ವಿಲ್ ಟೇಕನ್ ಇಟ್.
ನೀವು ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ತಗೊಂತೇನೆ
ಪ್ಲೀಸ್. ಎಸ್
ಕಂಟಿನ್ಯೂ.
Number 96. Reem Shrivan.
ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲಿ
Court roll number 2. He's held up in court roll number 2.
ಆಯ್ತು ಪಾಸ್ವರ್ಡ್.
He has stated that he has got some in other court. He would not be coming.
ಟೈಮ್ ಬೇಕಂತ. 2012 ನಾಳೆ
I'm ready.
He'll come, my lord.
ಇಲ್ಲಿ ಬರ್ತಾರೆ.
Senior is not there.
ಮೇಡಮ್ ಬರಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ತಗೊಂತೀನಿ.
ಬರ್ತಾರೆ ಮೇಡಮ್.
It is an admitted fact, my lord. Few dates.
ರೆಡಿ ಕಮ್ ಅವರೇ ಮುಗಿಸಿಲ್ಲ ಇನ್ನು. ಮುಗೀತು ಅಂದ್ರಲ್ಲ?
ಅಲ್ಲ ಮುಗೀತು ಅವ್ರು.
ಹಾ ಕರೆಕ್ಟ್ ಹೇಳಿ, ನೀವ್ ಹೇಳಿ.
ನಾವ್ ಹೇಳಿದ್ರು
ಎಸ್ ಎಸ್
ತಗೊಂಡು ಹೋದ್ರು.
ಆಯ್ತು
ಕೇಸ್ ನಮ್ಮದು ಕೋರ್ಟ್ ಅಂತ. ಅಲ್ಲ ಅವ್ರು ಬರ್ತಾರೆ ಅಂದ್ರೆ
ಬೇಡ ಬೇಡ ನೀವು ಸ್ಟಾರ್ಟ್. ಶಿ ಇಸ್ ದೇರ್.
ಅಲ್ಲ ಇವ್ರು ಏನು ಹೇಳ್ತಿದ್ದಾರೆ? I don't want to take any advantage of.
Oh, you don't worry, sir. Yes. ನೋಡಿ ಅವರು ಬಂದ್ರು ತಗೊಳ್ಳಿ.
Let him argue.
Yes.
My lord. My lord, I would like to draw your lordship's attention for few dates, my lord. Their dates would be very relevant because their prayer is, my lord, I will read the prayer first. Issue writ in the nature of certiorari or any other writ or order and declare that the acquisition proceedings of the land of the petitioners has lapsed and issue a writ in the nature of certiorari or other writ or order direction at the award and award. This is the basic prayer, my lord. I would like to demonstrate, my lord, how it is not lapsed. My lord, the 4-1 notification was issued on 12/11/1998. 6-1 notification was issued on 30/4/1999. My lord, the award was passed on 22/6/2000, which was duly approved by the government on 7/8/2000. Going by these dates, my lord, the section 11A, my lord, provides that the award should be passed within 2 years from the date of the 6-1 notification. My lord, going by these dates, the award is passed within 2 years. So, my lord, there is no question of lapse at all.
What happened to that?
My lord,
What happened to that?
which one, my lord?
Writ petition satisfied ಆಗ್ಲಿಲ್ವಾ ಅದು?
Writ petition age, ಅವರು there, they have sought for not to dispossess ಅಷ್ಟೇ. Only dispossess ಅದನ್ನ even.
ಆಯ್ತು, writ petition order ಇದೆ ತೋರಿಸಿ.
Writ petition order.
ಶೀಲ ಒಂದ್ಸರಿ ಯಾವ್ದು ಓದಿದ್ರಲ್ಲ, ಯಾವ್ದು?
Order ಇತ್ತು, not to dispossess.
Page, my lord, 15.
One five.
That is, yes, madam. That is passed in 2001, subsequent to the award.
ಅಲ್ಲ, ಅವಾರ್ಡ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಎಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದು 6-1 notification was set aside. Next year, my lord, page 15. Because 5-2 inquiry was not held.
ಒಂದು ನಿಮಿಷ.
At page number 30, your lordship can.
ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ಸ್ ಆರ್ ಕ್ವಾಸ್ಟ್ ಅಂದ್ರೆ ಏನೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
Earlier notifications are quashed. Earlier notifications.
ಅದನ್ನೇ ಹೇಳಿರೋದವರು.
Petition date.
ಆಯ್ತು, ನಾವು impugned orders notifications are quashed, so goes the award.
21/3/1990.
ಇಲ್ಲ, ಆಯ್ತು, ನೋಟಿಫಿಕೇಶನ್ ಹೋಯ್ತು.
ಹೌದು.
ಆಲ್ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೋಯ್ತು.
ಆಯ್ತು, ಆಮೇಲೆ ಫ್ರೆಶ್ ಇವೆಲ್ಲ ಅವನು.
ಫ್ರೆಶ್ ಮಾಡಿದ್ರಲ್ಲ.
ಅದೇ.
ಆಯ್ತು, ಫ್ರೆಶ್ ಮಾಡಿದಾಗ ಅವಾರ್ಡ್ ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಅವಾರ್ಡ್, ಮೈ ಲಾರ್ಡ್.
ಫ್ರೆಶ್ ಅವಾರ್ಡ್ ಎಲ್ಲಿದೆ ತೋರಿಸ್ಬಿಡಿ.
ಅದೇ
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀವಿ.
I will, my lord.
If you are clinging upon the award that was set aside, then you have no case. ಹೊಸ ಅವಾರ್ಡ್ ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅವಾರ್ಡ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಸರ್, ನೋಟಿಫಿಕೇಶನ್ ಹೋದ್ಮೇಲೆ ಅದು ಎಲ್ಲಿಂದ ಉಳಿತು?
ಅಲ್ಲ, ಈ ನೋಟಿಫಿಕೇಶನ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿಲ್ಲ.
ಯಾವ ನೋಟಿಫಿಕೇಶನ್?
That is issued on 12/11/1998.
ಏನ್ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್?
Criminal notification. 6-1 notification.
Impugned orders ಏನ್ ಮಾಡಿ, ಏನು ಸರ್?
34/2000.
Now come to.
The dates are different.
Now, one ನಿಮಿಷ sir. Now after 1903 have lapsed. And nothing transpired. In view of the circumstances, the inquiry contemplated section 5A would not be any prejudice to the government. The government shall examine the aspects put forth in detail so and so. The impugned orders are quashed, fresh decision shall be taken. Impugned orders ಏನು ಶೀಲವನ್ sir ಅದರಲ್ಲಿ?
I will read.
That is 6-1 notification. 6-1 notification. Howದು 6-1 notification.
May I point out, my lord, from the impugned, I mean, the judgment itself, the notification was issued initially on 31/3/1990.
Correct.
Disposing the inquiry contemplated under section
5A, and final notification is issued 2/4/98.
2/4/1998. After lapse of 8 years. Now, after 1998, 3 years have lapsed, my lord.
There is subsequent
And
notification.
nothing transpired thereafter. In view of the circumstances, the inquiries would not be in any precedence of government. Government shall examine all aspects
Sorry,
put
ಓದ್ಕೊಂತ
forth
ಇದ್ದಾರೆ.
by the,
Sorry, ಓದ್ಕೊಂತ.
before proceedings. But, the impugned orders are quashed. A fresh decision shall be taken in matters as expeditious as possible, affordable, so also. But, my lord, I have taken down from his synopsis only. Your lordship.
Synopsis ಬಿಡಿ sir, come to the order itself.
ಅವ್ರ synopsis ಅಲ್ಲಿನೇ ಅವ್ರ dates ಕೊಡ್ತಾರೆ. That's how I am.
ಅಲ್ಲ, ಆಯ್ತು, ಈಗ ನೀವು synopsis.
ಅವ್ರ synopsis ಅಲ್ಲಿನೇ.
ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕರೆಕ್ಟ್, ಇವ್ರ ಸಿನಾಪ್ಸಿಸ್ ಕರೆಕ್ಟ್?
ಅಲ್ಲ, ಅದನ್ನ ನಾನು I have to examine, but ಅವ್ರದೇ ಡೇಟ್ ತಗೊಳ್ತೀನಿ ನಾನು. ಅವ್ರ ಡೇಟ್ ತಗೊಂಡೆ ನಾನು ಕನ್ಕ್ಲೂಷನ್ ಬಂದೆ.
ನೀವು ಅವ್ರ ಡೇಟ್ ತಪ್ಪಿರ್ಬೋದು, ಬಿಟ್ಬಿಡಿ ಸರ್.
My lord, his in synopsis,
ನಾನು
our
ಇಷ್ಟೇ
4-1
ಕೇಳಿದ್ದು.
notification is
Fresh award, see 6-1 notification goes.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಹೇಳುದು ಇವ್ರ ಪ್ರಕಾರ
ಸಿನಾಪ್ಸಿಸ್ ಬಿಡಿ ಸರ್, come to the
ಅಂದ್ರೆ
order.
ನಾನು I will examine.
ಎಕ್ಸಾಮಿನ್ ಏನು ಆಯ್ತು?
ಇಲ್ಲ, ಅದು ಹೌದು ಅಲ್ಲ ನೋಡ್ಬೇಕಾಗುತ್ತೆ ನಾನು. ಯಾಕಂತ ಹೇಳಿದ್ರೆ
ಇಷ್ಟು ವರ್ಷ
he himself had admitted in the written
ಅಲ್ಲ,
petition
13
also.
ವರ್ಷ ಆದ್ಮೇಲೆ ವಾಟ್ ಎಕ್ಸಾಮಿನೇಷನ್ you want?
Lord, he can't take
Plus,
a different view
when the
now.
matter was argued, he says 2000 award is passed, therefore this writ is not maintainable. I have shown that award goes because final notification is quashed.
ಕೇಶವ ರೆಡ್ಡಿ ಸರ್
ಅಷ್ಟೇ ಇದೆ.
ಕೇಳ್ತಿರೋದು ಒಂದೇ, ಹೊಸ ಅವಾರ್ಡ್ ಎಲ್ಲಿ?
99 ಅಂದ್ಮೇಲೆ ಅವಾರ್ಡ್ ತೋರಿಸ್ಬಿಡಿ ಸರ್.
ಅಲ್ಲ, ಹೊಸ ಅವಾರ್ಡ್ ಎಲ್ಲಿ?
ಹೊಸ ಅವಾರ್ಡ್ ಇಲ್ಲ, ಈ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ
ಹೊಸ ಅವಾರ್ಡ್ ಎಲ್ಲಿ?
ಅವಾರ್ಡ್ ವಾಸ್ ನಾಟ್ ಸೆಟ್ ಅಸೈಡ್ ಅಂತ, ದಟ್ ಇಸ್ ಮೈ
6-1 ಹೋದ್ಮೇಲೆ ಎಲ್ಲ
ಡೇಟ್ಸ್ ಪ್ರಕಾರ, ಬಟ್ ಐ ಡೋಂಟ್ ನೋ. Now he is taking a different contention. My lord,
let him take any contention.
In his writ petition, it is admitted fact by him only.
Ayyo, I am asking one simple question.
But ನಾನು record
6, I record.
ಇಲ್ಲ, I have to examine.
Only you examine. 6-1 notification ಹೋದ್ಮೇಲೆ
ಕೊಡಿ, ನಾನು I will come back.
ತೊಂದರೆ ಇಲ್ಲ. 6-1 notification ಹೋದ್ಮೇಲೆ
That is their contention now. According
ಅದರ
to
ರೆಸಿಡ್ಯೂ ಎಲ್ಲ ಹೆಂಗ್ ಉಳಿಯುತ್ತೆ?
According to me, he has challenged that 6-1 notification, but it was not passed. But only interim order was there not to dispossess. ಅಷ್ಟೇ.
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಆಗಿ ಫೈನಲ್ ಆರ್ಡರ್ ಆಗಿದೆ ಈಗ.
ಅದು ಆರ್ಡರ್ ಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಏನೇನಾಗಿದೆ?
ಕರೆಕ್ಟ್. ಫೈನಲ್ ಆರ್ಡರ್ 6-1 notification is gone.
ಅಲ್ಲ, that was not passed. This 6-1 notification that is not passed. ಇದು ಬೇರೆ ಯಾವ್ದೋ ಆರ್ಡರ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
ಬೇರೆ ಯಾವ್ದೋ ಆರ್ಡರ್ ತೋರಿಸ್ತಾ ಇದೆ.
ಹೌದು. Now according to
ತೋರಿಸ್ಬಿಡಿ ಸ್ವಾಮಿ, ಅದು ಹೋಗ್ಬಿಡ್ತೀನಿ ನಾನು.
ಕೇಶವ ರೆಡ್ಡಿ ಸರ್, ನೀವು ಹೊಸ ಅವಾರ್ಡ್ ಒಂದು ತೋರಿಸಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. After 1999, which is the award that you have passed?
After 1999.
You show me that, I will dismiss the petition straight away on delay.
They admit my position also, my lord, they have issued a receipt.
Examine ಮಾಡ್ತಾರೆ.
Award was passed on 22/6/2000. It was approved on 7/8/2000.
2000.
ಹೌದು.
ಹಾ, ಇಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿರೋದು ಯಾವುದು? 6-1 notification.
6-1 notification was
Sir,
34/1999.
Basic thing I'm asking.
Yes, ma'am.
Award comes after the 6-1.
6-1 notification only.
6-1 goes. What happens to the residue like the award?
ಅಲ್ಲ, I am of the impression that 6-1 was not set aside, it was dismissed. ಎಲ್ಲೋ ಅವ್ರ ಜಡ್ಮೆಂಟ್ ಓದಿದ್ದೀನಿ ನಾನು. ಜಸ್ಟಿಸ್ ಇವ್ರದ್ದು ಗುಂಜಾಲ್ ಸಾಹೇಬ್ರದ್ದು.
ಗುಂಜಾಲ್ ಅವರು
2000 ಸಾಹೇಬ್ ನೋಡಿ, ಅನೆಕ್ಷರ್ ಸಿ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಯಾವ್ದು
ಅನೆಕ್ಷರ್ ಸಿ ಅವ್ರದ್ದು ರಿಟ್ ಪಿಟಿಷನ್.
ಗುಂಜಾಲ್ ಅವ್ರದ್ದು ಯಾವ ಜಡ್ಮೆಂಟ್?
ಇನ್ನೊಂದು ಬೇರೆ, there are several proceedings, my lords. That order was passed earlier. There are several proceedings thereafter. Some it was lost.
That's not relevant here.
They are no way concerned.
ಇದು ಮೋಹನ್ ಕುಮಾರ್ ಅವ್ರದ್ದು.
That is
ಅದು subsequently dismiss ಆಯ್ತು. Writ appeal ಹಾಕಿದ್ರೆ writ appeal.
Page 34 annexure C.
ಏನದು?
Writ petition was dismissed, writ appeal was dismissed. Till that day, no award was passed.
Dismiss for default. Yes, sir. Award.
2 days time. Friday I will give.
2 days award.
Yes.
List on Friday at the request of counsel Shri Keshav Reddy.
I will get you record.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಗೊತ್ತಿದೆ. ಅವ್ರಿಗೂ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ.
ಅವ್ರ ಡೇಟ್ ಪ್ರಕಾರನೇ ಅವ್ರು ಕೇಳಿದಂತ, ಅವ್ರು ಹೇಳಿದಂತ ಡೇಟ್ಸ್, ಅವರು ರಿಟ್ ಪಿಟಿಷನ್ ಆಗಿ ಹೇಳಿರೋದು, ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹೇಳೋದು, ಅದನ್ನ ಕಲ್ಔಟ್ ಮಾಡ್ಕೊಂಡು
ತಪ್ಪು ಹೇಳಿದ್ದೀರಾ? ಯಾಕೆ?
ಅವ್ರು ತಪ್ಪು ಹೇಳಿದ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ತೀನಿ?
I withdraw my
I should not be. I should not be blamed because now he says some other.
I'm surprised that I'm surprised the state is hinging upon the synopsis and not the judgments.
I'm taken by surprise now. ಮತ್ತೆ ನಾವು ಅವ್ರ ಪಿಟಿಷನ್ ಮೇಲೆ ನಾವು ಪ್ರಿಪೇರ್ ಆಗಿ ಯಾವ್ದ್ರ ಮೇಲೆ ಮಾಡ್ತೀವಿ ನಾವು?
Correct.
Yes.
Friday.
Please.
Yes.
With your lordship's slave lot, serial number 157, election matter.
ಈಗಿತ್ತಲ್ಲ. Yes, sir.
Yeah.
ಅಲ್ಲಿ ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಹಿರೇಮಠನ
What happened is, in this yesterday, my lord, in my petition, which Mr. Gurudas Kannur had appeared, Lord already disposed of same petition.
Same?
Same. It is not same. It is not same. I am a delegate only for 2 cooperative society.
In favor of the petitioner.
No, I have the yes, I have the document to show that
there is a delegate to 3 societies.
Voted thrice. Okay.
Only issue involved is that.
No, there is a delegate for 3 societies. Here it is not so. Just at the end of when the calendar of events is announced, they issue a notice. I give a reply that we have sent a delegate only for 2 societies. Even then they ignore it and mention it.
ಅಲ್ಲ, 1 minute sir. 3 societies documents ಇದೆಯಾ? I will take it tomorrow then. ನಾಳೆ ಬೆಳಗ್ಗೆ. In fresh matters.
ಎಲೆಕ್ಷನ್ ಇದೆ ಇದರಲ್ಲಿ ನಾಮಿನೇಷನ್ ಹಾಕೋಕೆ.
Tomorrow fresh matters.
Name may be shown.
ಯಾವ್ದ್ರಲ್ಲಿ? 150
applicants.
ನಿಮ್ದ?
Mallikarjun Swamy B. Hiram.
The registry to print the name of Mallikarjun Swamy Hiramad and Saurabh Hegde as appearing for the impleading applicants. List tomorrow in fresh matters.
Please.
ನಾಳೆ ಕೊಡ್ತೀನಿ ಸರ್. ಇಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೂ. ಲರ್ನಡ್ AGA 1 to 1, 4, 6 and 7. ನಿನ್ನೆ ಆಗಿದ್ದು ಯಾವ್ದು ಗುರುದಾಸ್ ನಂಬರ್ ಕೊಡಿ.
ನಂಬರ್
ಯಾವ್ದು ರಾಕ ನಿಮ್ದೆ? ರೆಡಿ ಇದೆ. I think ready the I've signed.
List 2 ದಲ್ಲಿ
I've signed it now.
Yes.
Yes, next.
Number 99 ST Kadakatti.
The petitioner is challenging the annexure D, my lord. The sale notice issued by the respondent number 2. The petitioner has purchased the land from the respondent number 4, my lord, to the registered sale deed in 2001, my lord.
14,24,939. ಎಷ್ಟಿದೆ ಡ್ಯೂ?
No, my lord, no, I am the purchasers, my lord.
Purchaser?
No, my lord. To the registered sale deed, I was purchased.
Now is the sister. The brother has sold to his sister, my lord, at the time of the loan which was taken from bank, my lord.
Again, what's the problem?
The sale notice was issued, my lord, on 2012. Annexure D, we are challenging, my lord.
Who is the borrower?
Please, my lord.
Who is the borrower?
The respondent number 4, my lord.
Who is the respondent number 4?
I had purchased the property from.
Sir, who is the respondent number 4, sir?
The petitioner has purchased the property from respondent number 4, my lord.
So respondent number 4 is the borrower.
Yes, ma'am.
When did you purchase it?
On 2001, my lord.
Yes, what's the problem now?
31/7/2001, my lord. I had purchased by seeing the income certificate, my lord, that is annexion B, my lord. In the income certificate, it is clear, my lord. There is no due of any loans.
Encumbrance certificate.
Yes, ma'am.
Yes.
By seeing that, I had purchased, my lord. But
Now
after
what has happened?
Now the sale, now they are challenging the sale.
Sale notice we are challenging.
ಇದೆಯಾ ಈಗ?
No, my lord.
ಮತ್ತೆ ಸೇಲ್ ಆಗೋಗಿದೆಯಾ?
Sale ಆಗಿದೆ.
ಮತ್ತೇನು ಉಳಿತು ಇಲ್ಲಿ?
Entire documents.
What indulgence can be shown now? Oh, 24 ಬಂದಿರೋದು ಮತ್ತೆ ಬಂದೇ ಇಲ್ಲ. The petitioner is before this court seeking the following prayer. What was called in question was a sale notice dated 24/7/2012. 13 years have passed by pursuant to the issuance of the sale notice. There is no interim order granted in the case at hand. Therefore, the date of sale, i.e. 24/7/2012, has already spent itself. In the light of the date of sale spending itself, no further, the subject petition need not be detained before this court for any further orders, leaving open all the remedies available to the petitioner to be availed of. The petition stands disposed as having become infructuous.
Please.
Yes.
Okay.
102 Prashant Gowda, Sharmila and Patil.
The clients have taken back the file. Filing memo for retirement.
Where is the acknowledgement? Acknowledgement of the clients taking away the file. What is the matter? Prashant Gowda ವಕಾಲತ್ ಹಾಕಿದಾರ?
No, madam.
ನೀವೇ ಹಾಕಿಲ್ವಾ?
No, Prashant Gowda, on behalf of Prashant Gowda.
Learned counsel appearing for the petitioner submits that the petitioner has, the file has been returned to the hands of the petitioner and and files a memo for retirement on that ground. Therefore, issue court notice to the to the petitioner. Next.
Not 5. Third party. Withdrawal.
Lords, I seek a short accommodation, my lords. Kindly have it in the next week, my lords.
2016. List the matter on 4th November.
Please, my lords.
Time baker. Yes, next.
Not 6. Hemant Kumar and Havarvi Srinivas Vinayak.
For the petitioner,
Day before yesterday's matter, they are seeking a writ.
My lordship, as per annexure A passed by the fourth respondent, my lordship. Annexure, as per annexure A, my lordship, kindly see. Order passed by the Tahsildar. ಅದರಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಅದರಲ್ಲಿ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದಾವು ಅವ್ರೇನು ವರದಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೂಡ ಅಂತ ನಾವು ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ.
ನಿಮಗೆ ಸಂಬಂಧನೇ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ನಾವು ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ, ನಮ್ಮ petitioner also co-shareholder of this property.
My lord, one submission on instructions. Lord, of the similar applications were filed by the petitioner seeking the same relief, about 25 to 30 pages under the Right to Information Act, narrating the entire fact. But under the Right to Information Act, an application, only a particular document can be asked and that can be furnished. If such an application is submitted by tomorrow itself, we will furnish. Over page, ಕತ್ತಿ ಬರ್ದು Right to Information Act ನಲ್ಲಿ ಮಾಹಿತಿ ಕೇಳಿದ್ರೆ
ಒಂದು PO ಕೊಡ್ರಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದಾರಂತೆ ಸರ್. ಒಂದು ಇದಕ್ಕೆ ಇನ್ಫಾರ್ಮೇಶನ್ಗೆ ಒಂದು ಇದನ್ನ ಕೊಡ್ರಿ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ, ಕಲೆಕ್ಟಿವ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೇಳಬಹುದು, ಬಟ್
ಅದ್ರ ಸಲುವಾಗಿನ ಸಪರೇಟ್ ಕೊಟ್ಟಿದ್ದು ಸ್ವಾಮಿ ಅದನ್ನ. ಅಲ್ಲ, ಈಗ ಇವ್ರು ಕೊಡದೇ ಇರೋದಕ್ಕ
ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ರೆ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಮಾಡ್ತೀನಿ ಕೊಡಕ್ಕೆ, ಇಲ್ಲ ಏನಿಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇವ್ರು ಕೊಡದೇ ಇರೋದಕ್ಕ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಇದು ಕಮಿಷನ್ ಆಫ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕಮಿಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟರು ಕೂಡ ತಹಶೀಲ್ದಾರ್ ತಪ್ಪು ಮಾಡಿದಾನೆ, ಅವನಿಗೆ ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡು ಕೇಳಿ
ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡು he has been suspended and he has enquiry has been
ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಂಡು ಇವರಿಗೆ ಮಾಹಿತಿ ಕೂಡ ಅಂತ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಬಟ್ ಅಷ್ಟಾದ್ರೂ ಇವರು ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಕೊಟ್ಟಿಲ್ಲ ನಮಗೆ ಇನ್ಫಾರ್ಮೇಶನ್.
RTI ಅಲ್ಲಿ ಹಾಕ್ತೀರಾ ಹೆಂಗೆ?
ಆಲ್ರೆಡಿ ಹಾಕಿದ್ದಿದೆ ಸ್ವಾಮಿ. 2017ರಿಂದ ನಮ್ಮನ್ನ ಕಾಡಕತ್ತಿದ್ದಾರೆ ಅವರು.
Allah, may I just pass on the description which he has, about 30 pages. If particular thing is mentioned, my lord, that can be furnished. Entire detail he has narrated and he is seeking information.
ಆಗಿ ಇಂತಿಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು ಅಂತ.
ಅಲ್ಲ, as per annexure A, my lordship. As per annexure A. Annexure A. Order passed by the Tahsildar.
ಎಲ್ಲಿದೆ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಿದ್ರಲ್ಲಿ?
ಸರ್, ಇದರಲ್ಲಿ ಹೇಳ್ತಿದ್ದಾರೆ, ಗುರುಪಾದಪ್ಪ ತಂದರಂಗಪ್ಪ ಜವಳಿ ಇವರು ದಿನಾಂಕ 4/6/2009 ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಹೆಟ್ನಾಳ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39, 40, 43, 44 ಇವುಗಳು ಉಪಯೋಗ ಮಾಡಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಂತೆ ಪ್ರಕರಣ ಅಳತೆ ಮಾಡಲು ಭೂಮಾಪಕರಿಗೆ ರವಾನಿಸಲಾಯಿತು. ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಭೂಮಾಪಕರು ಅರ್ಜಿದಾರರಿಗೆ ಮತ್ತು ಜಂಟಿ ಹಿಡುವಳಿದಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಹಿಡುವಳಿದಲ್ಲಿ ಹೊಂದಿರುವ ಜಮೀನು ಅನುಭವ ಪ್ರಕಾರ ಅಳತೆ ಮಾಡಿ ಸ್ಕೆಚ್ ನೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ನಾವು ಕೇಳಿದ್ವಿ ಸ್ವಾಮಿ, ಇವ್ರು ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಕೆಚ್, ಮ್ಯಾಪ್ ಇವನ್ನೆಲ್ಲ ಕೇಳಿದ್ವಿ ಸರ್.
As per tomorrow itself, if he submit
an application, yes, will direct them to furnish. The petitioner is before this court seeking the following prayer. The petitioner is at the doors of the court on the score that the information that is sought by the petitioner has not been furnished to its complete extent. The learned AGA on instructions would submit that the application submitted by the petitioner is not in the application format, but a narration of several events which runs into 30 pages. Therefore, the learned AGA would submit that if a specific request of a particular document is made in accordance with the provisions of the Right to Information Act, the information would be provided within 7 days from the date of submission of the said application. The said submission is placed on record. The petition stands disposed, reserving liberty to the petitioner to submit an application in strict consonance with the provisions of the Right to Information Act, seeking specific documents without narration of any story or without any further narration. In the event the petitioner would submit an application under the Right to Information Act as observed here and above, information of that is sought shall be furnished by the respondents in accordance with law within 7 days from the date of receipt of the said application, ordered according.
Please.
Next.
107, Hanmantar Latur, BS Kanke.
This case, the petitioner, the challenge the order passed by permanent lok adalat, the death of husband of the first petitioner by electrocution. They filed a claim petition before permanent lok adalat for seeking a compensation. The
Again, what is the problem there?
enhancement, my lord.
Enhancement.
Of compensation.
Lord, your lordship, it was posted day before yesterday, my lord. 13,25,000 rupees awarded by the permanent lok adalat. Entire payment is made. Lord, I am requesting, Lord, the prayer made in the writ petition, my lord. They are not questioning, my lord, or seeking modification of the award. The prayer is, my lord,
To pay remaining compensation. How the remaining compensation?
We are seeking the compensation of rupees 13 lakh.
Who determined that? 13,25,000 is already.
We say sought 25 lakh rupees, my lord.
13,25,000 pay ಮಾಡಿದಾರೆ already.
ಮಾಡಿದ್ದಾರೆ.
11 ಲಕ್ಷ ಯಾವ್ದು ಉಳಿದಿರೋದು?
We sought 25 lakh rupees in the claim petition. They awarded.
ಕೇಳಿದ್ದು ನೀವು ಕೇಳಿದ್ದೆಲ್ಲ ಕೊಡಲ್ವಲ್ಲ ಯಾವಾಗ್ಲೂ?
challenge ಮಾಡಿಲ್ಲ. Challenge ಮಾಡಿಲ್ಲ ಅದನ್ನು.
So after recalculation, that amount may be considered award, my lord. If the considering future prospectus, because the tribunal lok adalat has not considered future prospectus.
ಮತ್ ಕಳ್ಸೋದು ಯಾಕೆ? ಏನ್ ಪ್ರಣಯಸತಿ ಪ್ರಕಾರ ಏನ್ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ, ಇದು Lord, everything is done, Lord, in accordance with the law and also Lord, the law laid down by the Honorable Supreme Court. Lord, he has to challenge the,
another 3 lakh rupees harassment.
If the earlier compensation that is determined is not according to your assessment, then you'll have to challenge.
Challenge her.
ಏನ್ ಕೇಳಿದಿರಾ?
Remain directing the
ರಿಮೈನಿಂಗ್ ಯಾವ ರಿಮೈನಿಂಗ್? ಎಲ್ಲಿ
11
ನಿಮ್
lakh
ಪ್ರಕಾರ
rupees.
ಕ್ಲೈಮ್ ಅಲ್ಲಿ 1 crore ಕೇಳಿದ್ರೆ ರಿಮೈನಿಂಗ್ ಕೊಡ್ಬೇಕು ಅಂತಿದ್ಯಾ?
But there is no such any, but my submission is, my lord, if the calculation made by the tribunal, if it is satisfied, we are not fine. But the tribunal, lok adalat, are not considered future prospectus and other conventional heads, my lord. So if it is
ಈಗಲೂ
future prospectus,
will
it
permit
comes-
you to amend and raise a challenge if you want. Compensation ಆದ್ರಿಂದ he will not have objections. ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಇದನ್ನೇ stick on to this?
It is considered recalculated, it comes to 16 lakh rupees, my lord.
ಅದು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ತಾನೇ ಅದನ್ನ?
But ಅದನ್ನೇ ನಾವು direction, we sought a direction for 11 lakh, another 11 lakh rupees.
Difficult to advise. Yes. List after 4 weeks.
108, PG Mowgli, 1031.
Madam, I appeal for petition, madam, regarding selection of Anganwadi worker. The applications were invited, madam, for the post of Anganwadi worker for center Nagarsikoppa. And there is the notification, page 14. The center name is mentioned. It pays broad 15, serial number 21 broad. The application is invited for post for Nagarsikoppa Thanda, Nagarsikoppa village. The petitioner being the resident of that particular area, she applied for the post. And the beam road is the application filed by her, and page 23 road. She has mentioned that she is the resident of that Nagarsikoppa. And the C road, the resident certificate.
Who is the resident of Nagarsikoppa?
Petitioner road.
Petitioner.
Yes.
The third respondent yaru?
Fourth respondent.
Fourth respondent.
She is the resident of Nagarsikoppa Thanda road. There is another center that place. But
Where is the notification?
Page A road. Page 14 road.
Page 14.
Page 15.
ಯಾವ್ದಕ್ಕೆ ಕರೆದಿದ್ದೀಗ?
Page 15 road, item number 21 road. Item number 21, page 15.
One moment. Nagarsikoppa.
Nagarsikoppa.
ಅಲ್ಲಿ ತಾಂಡ ಅಂತಾನು ಇಲ್ಲ?
ಇಲ್ಲ, Nagarsikoppa. But the petitioner is the resident of Nagarsikoppa, and there be in the residence, the application, she has mentioned that she is the resident of that Nagarsikoppa.
Yes, madam.
Please, Your Worship.
Page
Nagarsikoppa village and Nagarsikoppa Tanda are the same revenue village. Your
How?
Worship. It is, Your Worship.
Revenue village ಪ್ರಕಾರ ಮಾಡಬೇಕು ಅಂತ
Yes,
ಇದೆಯಾ?
Your Worship. As per the notification, Your Worship.
Page.
Guidelines are there, like guidelines, pass on the guidelines for it. And now the development is, now the Nagarsikoppa Thanda, one center is working, it has become vacant. Now the respondent is working both the places. If she is responsible to not center Rakshakoppa Tanda center,
ಆ ತರ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮತ್ತೆ ನೋಟಿಫಿಕೇಶನ್
now she is working in both the places. This is the.
Yes, in the event notification is made,
Your
you
Lordship,
apply.
as per
I
the,
pass on the guidelines for which provides that for the applicant should be resident of that particular area. Item number
Same revenue village ಅಂತ ಹೇಳಿದೆ, guidelines
Yes,
ಅಲ್ಲಿ
Your
ಇದೆಯಾ?
Lordship.
Page.
item
It
number
is
1.
in guidelines, Your Lordship.
ಅಂಗನವಾಡಿ
ಒಂದು
ಕಾರ್ಯಕರ್ತರ
ಗ್ರಾಮದಲ್ಲಿ
ಆಯ್ಕೆ
may
ಸ್ಥಳೀಯರಾಗಿರಬೇಕು.
I read, Your Lordship?
ಒಂದು ನಿಮಿಷ ಮಗಳೇ ಸರ್.
May I read, Your Lordship? ಒಂದು ಗ್ರಾಮದಲ್ಲಿ ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ಅಂಗನವಾಡಿ ಕೇಂದ್ರಗಳಲ್ಲಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕರ ಆಯ್ಕೆಗೆ ಸಂಬಂಧಿಸಿದ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಗ್ರಾಮಾಂತರ ಪ್ರದೇಶದ ಕಂದಾಯ ಗ್ರಾಮ ಹಾಗೂ ನಗರ ಪ್ರದೇಶದ ಕಂದಾಯ ವಾರ್ಡ್ಗಳನ್ನು ಪರಿಗಣಿಸಬೇಕು. ಒಂದು ಗ್ರಾಮದಲ್ಲಿ ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ಅಂಗನವಾಡಿ ಕೇಂದ್ರಗಳಿದ್ದಾಗ ಆ ಕೇಂದ್ರ ವ್ಯಾಪ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ವಾರ್ಡ್ದವರಿಂದ
Anything else, sir?
She is resident of that particular area. She is
ಅದೀಗ
not.
ಆ ವೇಕೆನ್ಸಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. The petitioner is before this court calling in question an order dated 4/10/2018 by which the fourth respondent is appointed as an Anganwadi worker to the Nagarashi Koppa village. The petitioner and the petitioner and the fourth respondent were participants in a selection process for the appointment of the post of Anganwadi worker pursuant to a notification issued on 20/2/2018. The provisional select list was notified on 19/6/2018, and the contention is, without considering the objections of the petitioner, the fourth respondent is now appointed to the post of Anganwadi worker. The learned counsel appearing for the petitioner would vehemently contend that Nagarshi Koppa Tanda, where the fourth respondent resides, is entirely different from Nagarshi Koppa in which the petitioner resides. The notification calling for applications for Anganwadi workers was for Nagarshi Koppa and not Nagarshi Tanda. In that light, the fourth respondent could not have been appointed to the post of Anganwadi worker as against the claim of the petitioner is his solitary submission in challenge to the appointment of the fourth respondent. The learned HCGP on instructions and learned HCGP taking this court through the guidelines issued for the purpose of appointment of Anganwadi worker would buttress the submit that Nagarshi Tanda and Nagarshi Koppa Tanda and Nagarshi Koppa are one and the same as they come within one revenue village, and consideration of the cases of those applicants in such revenue village is a norm that is depicted in the guidelines. She would therefore seek dismissal of the petition. I have given my sounds. Therefore, narrated facts are not in dispute. Both the petitioner and the fourth respondent were participants in the process of selection for the purpose of appointment of Anganwadi worker in Nagarshi Koppa village. The sole contention as observed here and above is that the petitioner is from Nagarshi Tanda, Nagarshi Koppa village, and the fourth respondent, the appointee, is belongs to Nagarshi Koppa Tanda. The learned, as submitted by the learned AGA, the such circumstance is regulated by the guidelines. The guidelines, insofar it is germane, reads as follows. Clause 4. The said clause, the aforequoted clause, is indicative of the fact that if one Anganwadi, if a notification seeking appointment to the post of Anganwadi worker falls within two villages,
one revenue village, please.
Falls within two villages but comes under one revenue village, the said those villages coming under the said revenue village will have to be taken, will have to be given credence as the given credence for the purpose of considering the case of the petition, those applicants for appointment as Anganwadi worker. In the light of the said circumstance, the aforequoted clause would clearly indicate that both the petitioner and the respondent belong to one revenue village. one revenue village would be that the petitioner belongs to Nagarshikoppa and the fourth respondent to Nagarshikoppa Tanda. Barring this submission, there is no other submission made with regard to the entitlement to the appointment of the petitioner. In the light of the said submission, and in the light of said submission being steered clear in terms of the guidelines itself, there is no warrant of interference with the order of appointment to the fourth respondent to the post of Anganwadi worker. Finding no merit in the petition, Anganwadi worker. At this juncture, the learned counsel appearing for the petitioner submits that in another Anganwadi Kendra coming within the same jurisdiction, there is a vacancy and the fourth respondent is now made to work at two places. The petitioner can be considered for appointment as Anganwadi worker to the Kendra where there is vacancy. While a mandamus to that effect would not lie, it is open for the respondent state to consider and take necessary action in accordance with law. With the aforesaid observation, without interfering with the appointment of the fourth respondent, the petition lacking in merit stands rejected. Next.
Serial number 4, Srinivas Nayak.
Senior is on his legs in court all 2, my lord.
File. Odilva ನೀವು?
I have read, my lord.
What's the matter?
Petitioner is an auction purchaser, my lord. In a tent.
Yes, sir.
Lord, I had purchased the property in the auction. Those properties were, Lord, subject matter of, Lord, interim attachment by the government. And, Lord, final attachment in pursuance of the, Lord, jurisdictional court order. Now, there is an encumbrance, Lord, reflecting in the, Lord, records of rights. But I have sought for, Lord,
refund.
No, not refund. I requested them to get it cleared off.
Yeah, requested whom?
The special officer, second respondent and third respondent.
Sorry, urgency aniga.
Now, if they, Lord, release the amount to the depositors, and if, Lord, they say that encumbrance could not be cleared, I am nowhere.
We'll see. The one AGA. KPID na?
Haudu.
One AGA, 2 Viresh Bodhiyada yaradu?
Yes.
Viresh Bodhiyal 2.
2 and 3.
2 and 3.
4
1
government.
4 state. 2 and 3 Viresh Bodhiyal. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 28th in plenary hearing. Status quo be maintained by the parties till the next date of hearing.
Please, grateful.
Number 2, Saurabh Hegde.
Right to vote. Right to vote.
Same. Right. Last time. No. Same. Yes.
Number 3, Anand Bagewadi.
Voting,
Voting rights.
voting rights.
But in this, I am the impleading applicant, my lord. Our petition in hakide there are some problems, my lord.
Problems, sir.
How do? Because they have not mentioned why they have disqualified properly. Lord, it may be
Voting
kept,
rights separate
it may be kept tomorrow, my lord. I will produce the document, my lord. Tomorrow in the fresh
Annex
matter
D.
list, I'll produce it, my lord.
2 GB attend ಆಗಿಲ್ಲ.
I'll definitely give.
ಅಲ್ಲ,
We will not deny voting rights at all.
Lord, but I will come on record. ನನ್ಗೆ ಗೊತ್ತು voting ಕೊಡೋದು ಅಂತ, but tomorrow I'll come on record. That's
Come on, ಇವಾಗಲೇ come on record. Why are you worried? Yes.
Lord, tomorrow morning, my lord, in the fresh matters, voting.
No, that's all right. Voting right ಕೊಡಕ್ಕೇನಂತೆ. What, sir? ಈ ಕಡೆ ಇದ್ರು ಅದನ್ನೇ ಕೊಡೋದು.
ಅಲ್ಲಲ್ಲ.
Then voting rights, yes.
In the separate ballot box.
ಅದೆಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್. To be kept separately ಇದೆಲ್ಲ ಇದೆಯಲ್ಲ.
Lord, in that one person is disqualified, it seems.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅದರಲ್ಲಿ ಡಿಫಾಲ್ಟರ್ ಇದ್ದಾರೆ ಒಬ್ಬರು.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ.
ಪರಲ್ಲ ನೋಡೋಣ. voting rights ಗೆ ತೊಂದ್ರೆ. Yes.
Bill number 4.
This is also voting.
This is also not seeking voting rights.
Voting rights?
Yes.
Same order.
Not. I request not hand delivery.
Not. Yes.
Till number 5.
Sharath, Girish Edward. Is voting rights, na?
Swimming against the tide, Maraj. Seeking denial of voting right.
Denial of voting rights. Why, sir?
But he is a defaulter. As such, entails disqualification under section 29C.
ಈಗೇನಾಗಿದೆ?
Chosen as a delegate and he is enlisted in the final voters list. I have produced documents to show that Marad he is.
Agli, it will remain subject to the result of Madam.
That's what Marad. If I may request, of course, Marad denial when Marads are granting rights, Marad would be.
Voting rights denial, I will not.
His vote may kindly be kept in a separate box.
Correct.
That
The petitioner is before this court, calling in question order either.
I'm seeking for a mandamus to delete his name from the list.
Yes. The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to delete the name of
respond number 10.
Respond number 10 from the array of voters hyphen eligible voters. The
Annexure D, page 14.
Reject agide.
He is not. Illa. I have given a representation to the returning officer.
Though the petitioner does urge substantive grounds, the right to vote cannot be taken away, but cannot be taken away by a stroke of pen unless it is unless it being not taken away would cause problems to the conduct of elections. In the light of the said circumstance, the voting rights order, same.
That's what I want to
voting rights order ಮಾಡಿ the vote cast by the which respondent?
Respond number 10.
Respond number 10 shall be placed in a sealed cover and would placed in a sealed cover and would not be opened without the leave of the court.
Notice to the respondents.
1,
3, 4, 5 and 6.
1, 3, 4, 5 and 6. AGA.
Please.
Remaining.
2 and 6. Mr. Bharam Gowda, Marad sir. Idralli andre the other society and all.
1, 3, 4, 5 ಮಾತ್ರ ತಾನೇ ನೀವು 6 ಯಾಕೆ ಹೇಳಿದ್ರಿ?
6 is the returning officer of the. Returning officer.
ಅವ್ರಿಗೆ 6 ಕರೆಕ್ಟ್ ಆಗಿ. ಇನ್ಯಾರಿಗೆ?
Cooperative Election Authority. ಅದು ಅವರು Bharam Gowda appear. Then Marad notice to respondents 7 to 10.
Respond notice to respond 7 to 10. Yes, next.
Please.
May I request note serial number 3 and 4 notice ಆಗಿದೆ.
ನಾಳೆ ಹಾಕಿದೀವಲ್ಲ?
3 and 4 note.
What did we do? 3 and
1 government 2 to Malad 4 Bharam Gowda.
ಅದರಲ್ಲಿ emergent notice to the remaining respondents. Yes.
Please, I request handle your.
That will see. Yes. Next.
Till number 6, Rajendra Puroi.
This is with regarding to medical termination.
Medical termination of pregnancy, my lord.
24 weeks, 2 days.
2 days.
I accept notice for all the respondents.
ಮತ್ತೆ ರೀಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗ?
ಹೌದು, well, committee form
the committee has to be constituted.
Form and thereafter, my lord.
ಇದು release the order in the evening. ಯಾವ ಕಮಿಟಿ ಎಲ್ಲಿ?
My lord,
Vijayanagar district.
Vijayanagar district committee.
ಅಲ್ಲ, ವಿಜಯನಗರ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮೆಡಿಕಲ್ ಸೈನ್ಸಸ್.
Yes.
ತಗೊಳ್ಳಿ. The Vijayanagar Institute of Medical Sciences, sorry, the Dean of Vijayanagar Institute of Medical Sciences.
District hospital, district surgeon is the
surgeon. The Vijayanagar Institute of Medical Sciences shall committee is already there.
Committee, it has to be formed.
Shall constitute a committee to assess the health of the petitioner to undergo a medical termination of pregnancy and drop a report of such. Drop a report thereon. The report shall be placed before the court on the next at least on Friday in preliminary hearing. The committee shall meet tomorrow at 3 p.m. and do the needful as is observed here in above.
Petitioner shall appearance tomorrow. Our committee ಮುಂದೆ ಬರಬೇಕು.
Committee ಮುಂದೆ
ನಾಳೆ ಆಗುತ್ತಾ?
ಅಲ್ಲ, I will inform district.
Yes. ಅವರೇ ಬರೆದವರು ಹೆಂಗಾಗುತ್ತೆ? The petitioner shall appear before the committee at 3 p.m. tomorrow.
Please.
If ಇವತ್ತೇ ರಿಲೀಸ್ ಮಾಡಿ.
Please.
Yes.
Number 7, Interim Harvey.
Voting rights, my lord, then KDCC Bank.
Voting.
So Barmagoda and that's API agreed to take notice, my lord.
ಯಾರ್ಯಾರಿಗೆ?
3 and 5.
file ಕೊಡ್ಲಿ.
3 and 5.
ಫೈಲ್ ಕೊಡಿ
Office ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
ನೀವು ಹಿಂಗೆ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಯಾವ
ಅಲ್ಲ,
ಇಂಟರ್ವ್ಯೂ
I am sure. We have served the copy.
ಮೂವ್ ಮಾಡಿದ್ಮೇಲೆ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕೋ ಬೇಡ?
ಕೊಡ್ಬೇಕು. ಆಫೀಸ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀವಿ ನಾವು.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Will serve, my lords.
ಈಗಲೇ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಎಸ್.
Seal number 8.
8 and same, my lords.
Same,
3 and
same.
5 take notice to AP Gowda and Barmagoda. ಈ ಕೊಡ್ತೀನಿ.
ಎಸ್.
Seal number 9, Gayatri sir, Sachin Siangri.
Here for the petition, let's surface matter.
Petition.
That's the only reason I filed writ petition is this.
School.
School, the educational institution, Mulats, petitioner number 5. Wherein Mulats
See the
more
outstanding.
outstanding was Mulats as on the date of 9/10/2025 was Mulats 5 crore 72,000. And the same day Mulats we have deposited 1 crore. 1 crore
To
already.
interfere, madam.
That's the only ground is
What ground?
3,500 students are studying in that. Lots now administrative office is locked by the bank.
ನೀವು ಯಾರು?
The appearing for the KVTR, my lord.
ಬ್ಯಾಂಕ್
Yes, my lord.
ಎಷ್ಟಿದೆ?
My lord, outstanding is more than 4 crores,
14 crores.
4 crores, my lord.
4 crores.
And moreover, my lord, it is a fourth round of litigation, my lord.
I have
Sir,
disclosed.
approach this honorable court, my lord.
Let's I have produced the writ petitions. Along
And
with the writ
earlier, my
petition.
lord, they are challenging in this writ petition, my lord, same as they are challenged, my lord, same is withdrawn by the petitioner, my lord.
ಕಷ್ಟ ಮೇಡಮ್. ವೆರಿ ಡಿಫಿಕಲ್ಟ್.
Let's
ಸರ್ಫೇಸ್.
And even, my lord, in that writ petition also, they are same grounds, my lord.
ಅದು ಇವರೇ ಅಪಿಯರ್ ಆಗಿದ್ದ?
No, my lord, another
ಹಂಗೆ
counsel.
ಇವ್ರು ಅಪಿಯರ್ ಆಗಿರಲ್ಲ.
Let's will deposit some more amount also. 1 crore is already deposited. Let's midterm examinations are going on now in the school.
Midterm.
That is what I have been told. Now exams are being conducted.
Lord, already
That's
this
also
court is already
negotiations are
last-
going with the bank.
Last occasion, my lord, this court already considered, my lord, only on same ground, my lord.
ಎಕ್ಸಾಮಿನೇಷನ್ ಗ್ರೌಂಡ್.
The examination, the school is running on my lord. But aware that.
ಅವಾಗ ಸ್ಕೂಲ್ ಇಸ್ ರನ್ನಿಂಗ್, ನಾವು ಎಕ್ಸಾಮಿನೇಷನ್ ಇಸ್ ರನ್ನಿಂಗ್.
Yes, my lord. This court has already taken a lenient view, my lord. Aware, this bank also taken a lenient view, my lord, granted the.
ಈಗ ಲೀನಿಯನ್ಸ್ ಡಿಫರೆಂಟ್ ವ್ಯೂ, ಯಾಕಂದ್ರೆ ಅವಾಗ ಬರೀ ಸ್ಕೂಲ್ ವಾಸ್ ರನ್ನಿಂಗ್.
Continuously, we are given a time, sufficient time,
ಆಯ್ತು,
my
ಈಗ
lord.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
Let's now within 1 month, 50 lakhs will deposit. Milords, what I have been told is that Milords, he is trying to sell one more property which is not pledged to the bank, Milords. If that is sold, Milords, within 1 month, he may be able to pay entire amount. Milords, within 1 month, we'll deposit 50 lakhs, Milords. 1 crore is already deposited this month only, after the possession is taken.
But already, my lord, the bank is. And
ನಿಮಗೂ ಪ್ರಾಪರ್ಟಿ, ನಿಮಗೂ ಉಳಿಯುತ್ತೆ, ಅವ್ರಿಗೂ ಅವ್ರಿಗೂ ಉಳಿಯುತ್ತೆ, ನಿಮಗೂ ಬರುತ್ತೆ. ದಟ್ ಇಸ್ ದಿ.
Sir, what we are, my lord, at least, my lord, 50%.
ಈಗ ನಿಮ್ಗೆ ದುಡ್ಡು ಬೇಡವಾ?
My lord, they are not ready to deposit, my lord, after.
Will deposit.
The advantage, my lord.
Milords, I'll make
Even,
my
my lord,
parties
they
to file an
are.
approach.
50 ಲಕ್ಷ ಬೇಡವಾ?
At least, my
50
lord,
lakhs ಗೆ ರಿಕವರ್ ಮಾಡಕ್ಕೆ ಇನ್ನು 50 months ಬೇಕಾಗುತ್ತೆ ನಿಮ್ಗೆ.
my lord, what happened, my lord?
If you
They are
stick,
having the
if you stick
outstanding
to
of-
your guns, we will dismiss it.
Yes, my lord.
You avail the remedy, ತೊಂದ್ರೆ.
Yes, my lord.
Let's I'll ask my parties to file an affidavit to that effect. Milords, they'll deposit before this honorable court.
Because, my lord, what by instruction by me, my lord, they are at least, my lord, the outstanding amount, at least 3 crore rupees, my lord, we are ready to, my lord.
If they're ready for one-time settlement, Milords, I'll also ask for my.
You cannot direct anything.
Yes, I understand, Milords.
And even, my lord, they approached Supreme Court also, my lord, in the arbitration proceeding we are initiated, my lord. Even, my lord, they approached Supreme Court, my lord, they are also withdrawn, my lord.
ಕಷ್ಟ ಮಾಡಿ.
Let's.
1 ಕೋಟಿ ಪೇ ಮಾಡಿ.
Yes.
4 weeks ಕೊಡ್ತೀನಿ, 1
Yes.
ಕೋಟಿ ಪೇ ಮಾಡಿ.
Yes, Milords.
In the interest of students.
Yes, Milords. Highly obliged.
At
The
least, my lord,
petitioner
undertaking-
is before this court calling in question certain proceedings instituted by the respondent bank, invoking the provisions of the Surface Act 2002. Though in the normal circumstance, the writ petition challenging the said proceeding would not be entertainable, and the petitioner will have to be relegated to the concerned court or the appropriate authority as the case would be. The learned counsel for the respondent, Sachin Angdi, would submit that the subject petition forms the 4th in round, and all of which have been unsuccessful. The learned counsel for the petitioner Gayatri SR submits that the borrower is a school. The students, how many students?
More than around 3,500 students.
Around 3,500 students are studying in the school, and now and presently the midterm examinations are on in the said school. In that light, if the bank is now permitted to auction the property and the auction purchaser entering the premises of the school,
Auction notice is not issued. Only the possession is, yes.
if the bank is permitted to take possession of the property and take surface proceedings further, it would put the career of career of 3,000 students in jeopardy. In that light, though the apex court holds that the writ petition should not be entertained, in the interest of the students, I deem it appropriate to entertain the petition. However, not without any condition. The petitioner shall deposit 1 crore before the bank within 4 weeks from today. In the event the petitioner would not deposit the said amount by the next date of hearing, the interim order would get automatically vacated, and the respondent bank would be at liberty to proceed further in accordance with law. For the deposit of 1 crore be made on or before the 15th of November 2025. List the matter on 17th and the fresh matter.
They've already locked the administrative office. The keys may be.
Students lock madilva? Yes.
I'm sorry.
The learned counsel submits that the administrative block is locked by the bank, without which the school cannot function. Therefore, subject to the condition that the bank shall open the administrative the lock that is put to the administrative block, with reserving liberty to relock it in the event of non-compliance of the deposit of the amount. Yes. Yes, sir.
Hundred and ten, Jagdish Patil, MB Kanvi.
Road is constructed, my lord, in my property without acquisition process, my lord.
ಯಾರು MB ಕಣ್ವಿನಾ?
ಅಲ್ಲ, ಇದು KRDCL, my lord. Respondent number 3 has to consider it is the KRDCL. CV Angdi appears.
Where is he? The learned counsel for the petitioner submits that the property of the petitioner is utilized for formation of the road without initiating formal acquisition proceedings. The third respondent is to answer, who remains absent. List the matter on 28th, awaiting his appearance.
One submission in this, my lord, SCGP R3 to R6 and ತೋರಿಸಿದ್ದಾರೆ. So for R3, my lord, CV Angdi's name may kindly be shown.
ನಿಮಗೆ
ಉಳಿದಿದ್ದು ನಾವು ಅದೇ.
111, Prasad Patil.
I'm sorry, Mulats. Hand delivery may be permitted.
Mulats.
At the bank matter.
Surface. Yes.
Great.
Memo ಇಲ್ಲಿ ಮೆಮೊ ಕೊಟ್ಬಿಟ್ಟು ಕೇಳಬೇಕು. Yes.
Appeal for the petitioner, my lords, compassionate ground appointment. Serial number 111.
Yes, sir. Shweta Kulkarni.
Compassionate ground appointment, my lords.
Compassionate.
Please, my lords. Notes, the petitioner father is working as a Paura Karmik, my lords. Notes his date, my lords, he died in the year 2020, my lords. My lords, the impugned annexure, my lords, at annexure H, my lords. Notes, my representation was rejected by the respondent number 2 and 3, my lords.
Who is respondent number 2 and 3?
My lord, the respondent number 2 is Deputy Commissioner, District Compound, my lords. The 3 is, my lords, the Commissioner, my lords, IT Corporation, Belgaum, my lords.
Yes, who is to answer? Nivena?
The respondent number 3 has filed a statement of objections, Your Lordship. As per the application, Your Lordship, at the time of making application for appointment, Your Lordship, the petitioner was minor, Your Lordship.
ಅಲ್ಲ, ಸ್ಕೀಮ್ ಪ್ರಕಾರ ಏನಿದೆ? ಗವರ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಏನಾ?
Yes, my lords, I have produced the rules, my lords. My lords, I have produced the rules.
Majority.
My lords, immediately after the next year, my lords, at the time of the application, my lords.
Before 1 year ಆಗಿದೆಯಾ?
Please, my lords. Lords, as per the rule, my lords, the time is extended to 2 years, my lords.
Now 2 years, correct.
Yes, my lords. My lords, kindly peruse annexure Z, my lords. Page number,
When did you attain 18 years?
my lords, my date of birth is 2003, my lords. My lords,
2021.
lords.
2021.
Please, my lords. My lords, my application was given at next year. My lords, 30/11/2020, my lords. Exactly 17 years, my lords, at the time of application, my lords. My lords, as per the rule, my lords, 2 years was extended, my lords.
Yes, madam.
That
My
is
lords, I am appearing for respond number 3, my lords.
All right, yes.
Your lordship, that is with the response, prospective effect, your lordship.
Prospective.
Yes, your lordship.
Same prospective. Yes, respond number 3.
Please, my lords. My lords, as of on the date of application, my lord, the petitioner was 17 years old, my lord.
Correct. Within 2 years.
Please, my lords.
Illa, my lord, that notification was passed in the year 2021, my lord, whereas the father of the respondent has died in the year, 30th/11/2020, my lord.
Anything else, madam? The petitioner is before this court seeking the following prayer. The petitioner is the mother of the petitioner, who was Paurakarmikan.
Father of my lords.
Paurakarmikan.
Please, my lords.
The father of the petitioner was working as Paurakarmika, dies in harness on 29/10/2020. Pursuant to the death of the sole breadwinner of the family, the mother of the present petitioner, mother of the petitioner submitted a representation to the third respondent seeking appointment on compassionate grounds to the present petitioner.
Not one submission, my lords. The petitioner himself has submitted, my lords.
ಅದು ಆಮೇಲೆ ಮೆಜಾರಿಟಿ ಬಂದ್ಮೇಲೆ.
Please, my
Oh, your
lords. No,
lordship.
no, my lords.
At the
No,
time
my
of
lord.
taking the application, your lordship, he was 17 years old.
Yes,
When he was minor, then only has submitted the.
You have submitted yourself.
Yes, my lords.
The father of the petitioner dies in harness. He was he was working as Paurakarmika. The petitioner then dies in harness on 29/10/2020. The petitioner then submits a representation to the third respondent seeking appointment on compassionate grounds on the loss of the sole breadwinner of the family. The application of the petitioner seeking appointment on compassionate grounds comes to be rejected. Reject agidya?
Yes, my lords.
Rejected on the score that the petitioner ought to have attained majority. Adena ground?
Yes, my lords.
What ground?
Yes, them.
Attained majority majority in terms of the rules, which the petitioner has not. Therefore, it comes to be rejected. The petitioner is, this is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the rule presently in subsistence or as on the date of the submission of the application was that a minor should attain majority within 2 years from the date of death. It is only then such cases for compassionate appointment can be considered. The learned counsel submits that the date of death of the father of the petitioner was 29/10/2020, and 2 years time was available from 29/10/2020, and the application is made long before the expiry of 2 years, which was on 30/11/2020. He would submit that the rejection is on the face of it erroneous. The learned HCGP would vehemently refute the submission in contending that the petitioner was a minor at the time of submission of the application, and ಬೇರೆ ground ಇದೆ ನಿಮ್ದು?
Your lordship, the amendment, your lordship, has taken place on in the year
The
2021.
amendment with regard to from 1 year to 2 years alva?
Please, your lordship.
The amendment with regard to the time limit in which the application should be permitted comes about only in the year 2022, and the date of death of the sole breadwinner is in the year 2020. She would, on the aforesaid score, seek dismissal of the petition. I have given my anxious consideration to submission so and so. The aforementioned facts are not in dispute. The petitioner is the son of the father of the petitioner, who was working as a Paura Karmika, dies in harness on 29/10/2020. The petitioner submits an application seeking appointment compassionate grounds, at which point in time the petitioner was 17 years old. The endorsement comes to be issued rejecting the said claim on the score that the petitioner has not attained a majority within 2 years from the date of death as is necessary under the rules. As necessary under the rules. It is not 22,
2021, your lordship, it is not 20.
necessary under the rules. The petitioner at the time of submission of the application was 17 years old. The application is submitted on what date?
Not the first representation was submitted on 30/11/2020, my lords. And the
30/11.
Please, my lord, 30/11.
Amale?
Second representation was submitted on 5/8/2022, my lords, immediately after attaining the majority, my lords.
The records would clearly reveal that the petitioner had submitted a representation seeking appointment on compassionate grounds at the outset on 31st?
It was 30/11/2020.
On 30/11/2025.
2020.
And on attaining the age of, age of 18 years, has submitted another application on 5/8/2022. 2022. In the light of the amendment to the rules, which earlier depicted that one should attain majority within 1 year, is now extended to 2 years. In that light, the petition deserves to succeed with a direction to the respondent to respondent to consider the case of the petitioner in accordance with law and pass necessary orders thereon. For the aforesaid reasons, the following order. A mandamus issues to the respondent to challenge ಮಾಡಿದಿರಾ ಏನು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
Please, my lords, my application reject ಮಾಡಿದ್ದಾರೆ sir. Represent. Please, my lords, at annexure H. Annexure H.
Stated, your lordship. Annexure P.
In the
Annexure F by.
So annexure H stands quashed. The respondents are directed to consider the case of the petitioner for appointment on compassionate grounds in consonance with law, bearing in mind the observations made in the course of the order within 12 weeks from the date of receipt of the copy of the order.
Please, great.
And then 12,
Obligation.
Purnima Banta.
The respondent number 2, my lord, has made a provision under 10A regulation, my lord.
Yes, sir.
STEM has made a 10A regulation, my lord,
What regulation?
for appointment of against the assistant engineer, my lord. Again, my lord, on 18/3/2015, my lord, they are withdrawn, my lord. And 13/3/2018, my lord, the capital authority is one number 2. On the withdrawal of that, again they included 102 junior engineers, my lord. In that, pursuant that, my lord, that annexure G, my lord.
There was a provision for appointment by transfer by regulation 10A, my lord. ಅದೇ ಇವ್ರೇನಂತ ಇದಾರೆ ಆ ದಿನ if I may permit, there was a regulation for that minimum 3 years of qualifying service as well as completion of probationary.
They are not mentioned in the qualifying service. Annexure G, my lord.
May I just
annexure G.
Annexure F, page 47, may I draw lordship attention
on once,
please.
Yes.
Annexure G, my lord. Page number 50. Page number 50, my lord. The resolve that for the reason explained above, approval B, and the hereby accorded to the considered appointment by transfer from the post of junior engineer to the post of assistant engineer for the following subject to fulfill the conditions to completion of 3 years of qualifying service, my lord. So they are calculating from the probationary period, my lord.
No, those persons already applications were pending and they are not completed. May I just draw lordship attention to page number 47, annexure F, my lord.
Can we take this on Friday?
Please. Yes. May I request on 29th, my lord, if possible?
29th. Place the matter on 29th.
Please.
Please, my lord.
14. Then Goli. 11, 14.
Please, my lord. In missing complaint, my lord, in this, anyone memo will be applied there, but anyone searching report in not in available. Only death report in the, this one memo in applied there, my lord. Please, my lord. ಇಲ್ಲಿ ಇವರು ಮೆಮೋ ಸ್ಟೇಟ್ ಕಡೆಯಿಂದ ಎಲ್ಲಾನು ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಬಟ್ ಆ ಮೆಮೋದಲ್ಲಿ ಏನಿದೆ ಓನ್ಲಿ ಡೆತ್ ರಿಪೋರ್ಟ್ ಅಷ್ಟೇ ಹಾಕಿರೋದು. ಈ
ಪ್ರಾಬ್ಲಮ್ ಏನಿದೆ?
ಪ್ರಾಬ್ಲಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗೋದೇ ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ ಮೈ ಲಾರ್ಡ್.
But they are seeking a writ of
ಸತ್ತಿರೋದೇ ಹಾಕಿರೋದು, ಬದುಕಿರೋದು ಎಲ್ಲಿಯಾದ್ರೂ ಕಾಣೆ ಆದದ್ದು ಒಂದು ಪಾಂಪ್ಲೆಂಟ್ ಹಚ್ಚಿದ್ದು ಅಥವಾ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ದು ಯಾವುದೇ ರಿಪೋರ್ಟ್ ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಎಂಟೈರ್ ಮೆಮೋ ಇದು ರೆಫರ್ ಮಾಡಿದ್ರು ಕೂಡ ಒಂದು ಅದರಲ್ಲಿ ಇದಿಲ್ಲ. ಪ್ಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇನ್ ರೆಫರ್ ಟು ದಿ ಆರ್ಡರ್ ಮೈ ಲಾರ್ಡ್.
ಮೆಮೋ?
No, my lord. Memo is not considered taken to the order to in investigation, my lord.
ಕೊಡಿ ಮೇಡಮ್ ಫೈಲ್. ಮೇಂಟೆನೆನ್ಸ್?
Hello, they are seeking a writ of mandamus to trace out the missing person.
Missing
That is the
person,
prayer
my
which I
lord.
sought.
Who is gone missing?
2020, my lord.
ಯಾರ್ ಮಿಸ್ಸಿಂಗ್?
In Basappa Meti brother, my lord. Siddappa.
Who is Siddappa? Who is Basappa?
Siddappa Meti is legal big brother of in Basappa Meti.
Big brother? Yes. ಪೆಟಿಷನರ್ಗೆ ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಮೇಡಮ್? ಬಸಪ್ಪ ಸಿದ್ದಪ್ಪ ನಮ್ಗೇನ್ ಗೊತ್ತು?
ಸರ್, ಬಸಪ್ಪ ಅವರು ಸಿದ್ದಪ್ಪಗ ಅಣ್ಣ ಆಗ್ಬೇಕು.
ಅದನ್ನೇ ನೀವು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರಿ, ನಮಗ್ ಅದ್ ಬೇಕಾಗಿಲ್ಲ.
ಪ್ಲೀಸ್ ಮೇಲ
ಹೇಳಿ.
ಇವಾಗ ಏನಿದೆ ಮೈಲಾಡ್, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಅಂದ್ರೆ ಮಿಸ್ಸಿಂಗ್ ಆಗಿ ಇಷ್ಟು ವರ್ಷ ಆದ್ರೂ ಕೂಡ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಿಂದ ಸರ್ಚ್ ಮಾಡಿದ್ರು ಕೂಡ ಕರೆಕ್ಟ್ ಆಗಿ ರಿಪೋರ್ಟ್ ಇಲ್ಲ ಸರ್. ನಾವು ಅಲ್ಲಿ ಕೂಡ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ವಿ.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ತಡಿ.
To that effect, my lord, we have placed along with the memo, whatever the instructions and the investigation that has been taken place is placed before the lord.
ಸಿಗ್ಲಿಲ್ವಾ ಅವರು?
ಇನ್ನು ಸಿಕ್ಕಿಲ್ಲ.
5 ವರ್ಷ ಆಯ್ತಾ?
ನೋ ಮೈಲಾಡ್, ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ಆದ್ರೆ ಸರ್ಚಿಂಗ್ ಮಾಡಿದಲ್ಲಿ ಒಬ್ಬರು ಪರ್ಸನ್ ಆದ್ರೂ ಈ ತರ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿ ಇರ್ಬೇಕಲ್ಲ ಮೈಲಾಡ್. ಬರೇ ಸತ್ತಲ್ಲಷ್ಟೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದೀವಿ ಅಂತ ಮೆಮೊ ಹಾಕ್ತಾರೆ.
ಸತ್ತಾಗ್ಲಾ? ಅಂದ್ರೆ
ಡೆತ್ ಆದಂತ ಪರ್ಸನ್ ವಿಸಿಟಿಂಗ್ ಮಾಡಿದಷ್ಟೇ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ ಇವರು. ಈಗ ಮಿಸ್ಸಿಂಗ್ ಆದ್ರೆ ಇಂತಿಂತ ಸ್ಟೇಷನ್ಗೆ ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಒಂದು ರಿಪೋರ್ಟ್ ಕೂಡ ಇಲ್ಲ ಮೈಲಾಡ್. ಮಿಸ್ಸಿಂಗ್ ಆದ ಪರ್ಸನ್ ಇದ್ರೆ ಆ ತರದ್ ಯಾವುದೇ ರೀತಿಯಿಂದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ ಮೈಲಾಡ್.
ಮಿಸ್ಸಿಂಗ್
ಬಟ್ ಮೈಲಾಡ್ ಪಾರ್ಟಿ ವಿಲ್ ಬಿ ಅವೈಲೇಬಲ್. ಯು ಪರ್ಮಿಷನ್ ಗಿವನ್ ಟು ದಿ
ಮತ್ ಮಿಸ್ಸಿಂಗ್ ಅಲ್ಲಿ ಇಲ್ಲೇ ಇದಾರೆ
ಅವ್ರ ಬ್ರದರ್ ಅವರು ಇರೋದು ಮೈಲಾಡ್. Present in petition filing, the Basappa Meti will be there.
So what should I do?
ಅಂದ್ರೆ ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ ಅಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋದ್ರು ಕೂಡ ಏನು ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದಕ್ಕೋಸ್ಕರನೇ ಪಾರ್ಟಿನ ಪ್ರೆಸೆಂಟ್ ಇಡ್ತಾ ಇರೋದು ಮೈಲಾಡ್. ತುಂಬಾ ಸರ್ತಾನೆ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ, ಯಾವುದೇ ರೀತಿಯಿಂದ ಕೋಆಪರೇಟಿವ್ ಇಲ್ಲ.
To that effect, I will file an affidavit of the investigation officer.
ಬಟ್ ಮೈಲಾಡ್ ಮೆಮೊ ಹಾಕಿದೀನ ಅಂತಾರೆ. ಲಾಸ್ಟ್ ಎಂಡ್ ಅಲ್ಲಿ ಕೂಡ ಒಂದು ರಿಪೋರ್ಟ್ ಆದ್ರೂ ಕಾಣೆ ಆಗಿರೋದು ಇಂತಲ್ಲಿ ವಿಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಯಾವುದೇ ರಿಪೋರ್ಟ್ ಇಲ್ಲ ಮೈಲಾಡ್. ಓನ್ಲಿ ಡೆತ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅಂದ್ರೆ ಈ ಪರ್ಸನ್ ಸಂಬಂಧಪಟ್ಟಂತ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಆ ಪರ್ಸನ್ ಬಗ್ಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ ಎಲ್ಲೂ ಇಲ್ಲ. ಪ್ಲೀಸ್ ಕೈಂಡ್ಲಿ ಇನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟು ದಿ ಆರ್ಡರ್ ಮೈಲಾಡ್.
ಪೊಲೀಸ್ನವ್ರು ಕಾಣೆ ಆಗಿದ್ದಾರೆ?
ಪೊಲೀಸ್ನವ್ರು ಕಾಣೆ ಆಗಿಲ್ಲ ಮೈಲಾಡ್. ನಮ್ ಪಾರ್ಟಿ
I'll place affidavit of the investigation.
The petitioner is before this court on the score that despite registration of a missing complaint, no effort is taken by the jurisdictional police before which the complaint was so registered to trace out the person that is missing. In this jugglery, 5 years have passed by. Therefore, the learned AGA to place an affidavit of the station house officer before whom the complaint was registered as to what has become of the complaint and the present stage of investigation by the next date. List the matter on 23rd.
Please.
24th.
Please, madam.
115, Jagdish Patil, PS Complaint.
Compassionate appointment, my lord, is rejected on the ground, my lord, that the RSA is pending.
RSA is pending.
RSA is pending.
Dispute between two wives, sir.
And
Two
she,
wives.
and
First
she is
wife,
not
my
a
lord.
party here. And she
First
is not
one-
made a party here. Please.
First
First or
wife,
second?
second wife, a child of second wife, my lord. First wife is issueless.
She is the lady who has filed the appeal, my lord, is not made a party and she's disputing the very status of the petitioner being
First
the
wife. You first wife alva?
Second wife.
Second.
ಅಲ್ಲ ಮದ್ವೆನೇ ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರ
He
ಕಂಟೆನ್ಷನ್
disputed her status, my lord.
Obviously.
if they make her as a
Children
party
out
here,
of voidable malady, void or voidable malady, they are entitled.
if she was a party to this petition,
Why
things
do you
would be
want?
easier. Because she's even claim entire claim or dispute ಮಾಡ್ತಾರೆ. Even we are parties in RS.
Not seeking.
Even HESCOM authorities are parties before RS.
RSA ತೀರ್ಮಾನ ಆಗ್ಲಿ ಬಿಡಿ.
RSA is pending.
ತೀರ್ಮಾನ ಆಗ್ಲಿ. ಅಲ್ಲಿ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಹಾಕೊಳ್ಳಿ. ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನನಗೆ, ನಿಮಗೆ ಇದು, ನಮಗೆ ಅದು ಅಂತ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವಾಗೆಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ.
Short date.
ಏನ್ ಬೇಕಂತ ಯಾವಾಗ ಬೇಕಂತ. ಲಿಸ್ಟ್ ಆನ್ 30th. Please.
16, Dinesh Kulkarni.
My lords, petitioners are the owners of the land, my lords. It was acquired by respondent number 2, my lords, but the lands of the petitioners were not developed, my lords.
Not developed?
Not developed, not.
Housing board?
Yes, my lords. Those were not utilized, my lords.
Who should answer your petition?
My lords, now I have sought for writ of mandamus to consider to consider the report made by respondent number 3 to 4, my lords.
And delete the land of the petition.
Yes, my lords.
I may direct take notes to respond number
Who
1 and
appears?
5.
Housing board ಯಾರು sir?
Housing board. Respond number 2.
Palatti. ಒಂದು ಚಾನ್ಸ್ ಕೊಡುವ.
Yes.
We'll take it on 24th ಇಲ್ಲ 28th.
Yes.
Please, ma'am. I may direct take notice, my lords.
Heard the
Respond number 1.
learned counsel appearing for the petitioner and the awaiting, there is no representation on behalf of the housing board. The learned counsel Vaibhav Inamdar appearing for the petitioner would submit that the acquisition was for the purpose of building houses.
Residential layout.
Residential layout, building houses, the residential layout by the Karnataka Housing Board. And not, and the land still remains undeveloped and therefore a representation is submitted to delete the land of the petitioner or petitioner measuring 4 acres and 14 guntas, which is not yet considered. There is no representation on behalf of the respondent housing board, respondents 3 and 4, awaiting his appearance as a last chance. List the matter on 28th.
Yes, representation was considered. Later on, the respondent number 2 directed respondent number 3, that is engineer, to submit a report making spot inspection.
List on 28th.
Yes.
I may direct take notes, my 1 and 5.
Hotel.
Notice served, my lords. I may.
Learned AGA is directed to accept notice for respondents 1 and 5.
5, please.
Obliged.
Next. 17, H.M. Dharwad.
Hearing for petitioner. Pray for a week's time, madam.
They are seeking for renewation of the release period. But as per the terms and condition at the time of tender, my lord, they have to submit their renewal application along with
Tender matter, interim order, 2 ವರ್ಷ ಆಯ್ತು. Yes, list the matter as a last chance on 28th in preliminary hearing.
Please.
Yes.
Baswaraj Veerappa.
4th.
Chennam is Kulkarni.
Yes, I appear for petitioner, my lords, in this matter.
Yes, sir.
Lords, we are challenged. IA number 8 was filed under section 151 of the CPC, seeking set off of the amount ordered towards the interim maintenance out of the total amount of 4,92,300, my lords, which is already paid to the respondent herein.
Let the respondent come forth. Yes.
Please, my lords. Interim order may candidation.
Under 11th, interim order subsisting will continue to the next state of care. Yes, next.
Please.
Petitioner has challenged Annex F, my lord. Annex F is a notice issued under section 107 of CRPC. Now, the petitioner has made a complaint with the respondent number 3. In pursuant that, my lord, instead of registering complaint, they issue me a notice under section 107 of the CRPC.
Lord, one submission pursuant to the notice having been issued, both the respective parties approached and they have given a statement before that we will settle dispute among us. That is the part of the endorsement. To that effect, endorsement was also
The
issued.
petitioner is before this court seeking the following prayer. The coordinate bench of this court, owing to the submission made by the counsel for the petitioner, had passed the following order on 11/7/2024. The learned AGA has produced the records pertaining to the case for verification, for perusal of the court. The records would indicate that both the parties to the list, the complainant and the petitioner, have settled the dispute. They are going to settle the dispute and do not create any untoward incident. In that light, I deem it appropriate to dispose the petition, noticing the fact of the undertaking given by the petitioner and the respondent.
Only petitioners.
Undertaking given by the petitioner, reserving all liberty to knock at the doors of the appropriate fora in the event of need. Petitions, therefore, observation, petition stands disposed.
Please.
One 25, Rashtakar B. Haldi.
One is, my lord, a representation, consideration of my relief, and another one is, my lord, direction to resurvey of the subject matter of this said petition.
Please.
The petitioner is before this court seeking a direction, seeking the following prayer. Heard sounds. On 11/1/2021, the petitioner purchases the subject property by a registered sale deed from the hands of the 7th respondent. The 5th respondent, a survey was sought to be conducted of the subject property. Survey ಮಾಡಿದಾರಲ್ಲ?
ಮಾಡಿದ್ದಾರೆ sir. Survey ಮಾಡಿದ್ದಾರೆ. Without in my securance of resistance, survey was conducted.
Survey comes to be conducted of the subject property on 6/5/2022. The survey is against the petitioner. The petitioner was not informed of the survey or did participate in these proceedings. Therefore, the conduct of survey is behind the back of the petitioner. The petitioner then submits a representation to respondents 2 to 5 to resurvey the property in his presence, which representation is not considered as on date. The learned AGA on instructions would submit that if reasonable time is granted, the property of the petitioner would be surveyed and appropriate report would be furnished to the petitioner. In that light, I deem it appropriate to dispose the petition with a direction to the respondent state to conduct the survey on 4th November at 10:30 a.m. And furnish the report of such survey to the petitioner. All other contentions other than the one considered shall remain open. The petition stands disposed.
One more, ascertain whether the primary health center come under my property or not. Please, please. Please.
26, Santosh B. Rao, Chetan Manoli.
Respond number 6,
My lord.
corporation. Have to file objections in this matter.
75 ido.
Petitioner
Learned
has
counsel for the respondent seeks 2 weeks time to file statement of objections. Objections, if any,
Please.
by the next date. List on 12th November.
Obliged.
127, Shank Kardivar.
Lords, there are some inconvenience, my lord. It may be taken next week.
ಬೆಳಗ್ಗೆಯಿಂದ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ. ಎಲ್ಲಿ ಪ್ರಶಾಂತ್ ಕಾಡ್ದೇವ್ರ ಎಲ್ಲಿದೆ? ಸೀಲ್ ನಂಬರ್ 120? Learned counsel appearing for the petitioner seeks 10 days time, less the matter after 10 days. Enter matter idea?
Yes.
Enter matter subsisting will continue to the next day.
128 MS Harvey.
Petitioners are the farmers. They have challenged them, my lord, the
Notices
the
having
notice
been
issued to the
issued.
first respondent police. And the premise that means the crime was registered against them, my lord.
We'll take it tomorrow.
Please, since my lord, they threatening, the police are threatening to my lord, seize the vehicle of the farmers.
We'll take it tomorrow. I'm a little unwell, so I'm not able to.
128.
Madam, ಉಳಿದಿದ್ದು ರಿಪೀಟ್ ಮಾಡ್ಬಿಡಿ ನಾಳೆ. List will be repeated tomorrow.
One submission. Next
In
matter,
matter?
129.
Sir.
May I request it to be listed in preliminary hearing?
ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳ್ತೇನೆ.
Milord, one submission, Milord.
139.
Milord, one submission.
ಒಂದು ನಿಮಿಷ.
139.2. Seeking mandamus, consider my representation.
ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ನಾಳೆ.
Preliminary hearing ಅಂತ.
Milord,
Tomorrow you make a mention.
Please.
Milord, I need 2 weeks time to file statement of objection in 139.
Yes.
The Lordship may kindly grant 2 weeks time to file objections.
ನಾಳೆ ತಗೊಳ್ಳ.
2 weeks time may kindly granted, Milord. He wants to create a constituency, new constituency in view of the 2 talukas newly created.
ಎಲ್ಲಿ ಸುರೇಶ? Same order.
Kindly, my lord. Serial number 161, my lord. Serial number 160.
Tomorrow we'll take.
Serial number 161, my lord.
Lord's unregistered sale agreement. I may be permitted to deposit the stamp duty and penalty subject to outcome of this writ petition.
Next date.
Any date may be fixed, Lord, subject to outcome of this writ petition. Next date before trial court is on 31st.
20?
31st.
31st. I think tomorrow is before 31st.
Please.
Kindly, my lord.
In
Serial number
preliminary hearing.
160. Serial.
Interim order selection ಆಗುತ್ತೆ ಮೇಡಮ್ ಎಲ್ಲ ನಾಳೆ.